Hearing examiner Ryan, can you hear me okay?
Mr. Lee, yeah, I hear you.
All right, thank you.
No worries. I'm just trying to deal with some document exchanging going on in the background here.
Okay.
See you in a little bit.
All right, bye-bye.
Bye. I will make co-host. And do you want me to admit everybody or hold on a second? Okay.
Chris, can you hear me?
I can.
Great, thanks. I'm going to close the doors here. Please admit the folks.
Yep.
Morning, Mr. Lee.
Good morning, Judge. How are you today?
I'm doing well. And yourself?
Good. Let's settle up and ride for the brand.
Yes, sir. Let's keep it moving, hopefully. Well, good morning. This is our day 3 of the hearings in the P&M rate case. And this morning, I believe we're going to hopefully start with the examination of Mr. Frank Graves, P&M's witness. Before we do, very briefly, are there any matters that we should address before we put Mr. Graves on the stand? Mr. Alvidrez?
Mr. Hearing Examiner, just confirming that we did submit yesterday P&M's responses to bench requests 2 and 4, and this morning we'll be supplementing bench request 4 with the PDF versions of the documents. It indicated that was going to be quite voluminous, but we will get that accomplished pretty quickly this morning.
Great.
The only other thing is, NEE Exhibit 7, I know was admitted, and I just want to make sure that the correct version of that, which is the one that Ms. Nanasi circulated to the parties yesterday, is the version that's going to go in the official record. That's the only other loose end that I'm aware.
Well, I checked that on Dropbox, and I believe I added the NEE 7 that she sent, which was revised. I need to check that again. But before we do anything with that, I want to ensure that I didn't delete the earlier version because I wanted to come back around on that to make sure that I didn't remove the wrong version of it. So I'm going to bear with me a second. We do need, some of these housekeeping matters, let's put them aside because it's more important that we get to the examination of Mr. Graves, because we're going to start with the commissioners on this because they have to move into their open meeting.
Oh.
And then they have, after that, the strategic planning meeting that I'm part of the core group of, and I'm going to be missing, unfortunately. So I want to move into the examination very quickly. I don't want to take up time with this. There is another matter, however, very quickly. I enjoyed talking to Mr. Graves back in 2117 a lot, but to save time there too, I'm going to be uploading to just my examination of Mr. Graves in 2117 in a few minutes to save time there. And I'm going to have the parties review that as a time-saving measure and ask that be made Commission AN 76. That'll save time.
I'm sorry, the number, Judge, Commission.
It'll be Commission AN as in Alpha Nancy. And that will be redacted, but it's just my colloquy with Mr. Graves back in that case. That will be uploaded at some point as well. I'll have the parties review it and they can see whether it would be acceptable. Hopefully it will be, or just to take administrative notice of my examination of Mr. Graves in the 2117 case. That'll be Commission AN 76. So that's another preview, something I'll be working on. It's done. I had something else that came up right before I had completed it. I'll put it there. So if there's nothing else right now, I'd like to put Mr. Graves on the stand and have Commissioner Ellison at least perform his examination of Mr. Graves. Is there anything else before we do that? Okay, great. Mr. Alvidrez, would you please call your next witness?
Yes, we call Frank G. Graves.
C. Graves.
Sorry, Frank C. Graves.
Mr. Graves, would you raise your hand? You solemnly swear the testimony you're about to give in the matter no opinions, be the truth, the whole truth, and nothing but the truth.
I do.
Mr. Graves,
Thank
will
you,
you,
sir.
sorry, Mr. Graves, will you state your name, your employer, and your job title for the record, please?
Certainly. My name is Frank, middle initial C, last name Graves, Graves. I am a principal with the consulting firm, The Brattle Group, which is
I'm
located.
sorry, sir, you're breaking up. I am a,
Sorry, I wonder if I need to be closer to the mic. Is that better?
yes, sir.
Yes, sorry about that. I am a principal at the firm, The Brattle Group, Brattle, located at 1 Beacon Street in Boston, Massachusetts.
Nice address.
And Mr. Graves, did you prepare pre-filed direct testimony in this case that was submitted on December 5th, 2022?
I did.
And can you confirm that PNM Exhibit 17 is a true and correct copy of your direct testimony in this case?
Yes, indeed, that is it, and it looks perfect.
Okay. And is your testimony true and correct to the best of your knowledge and belief?
Yes, no changes.
We would move PNM Exhibit 17 into evidence, please.
Is there any objection? PNM Exhibit 17 is admitted.
Moving on, can you confirm that PNM Exhibit 18, corrected, is a copy of your rebuttal testimony submitted in this case along with errata?
Yes, that is correct.
And is this testimony with the errata included true and correct to the best of your knowledge and belief?
It is.
We move the admission of PNM Exhibit 18 into evidence.
Any objection? Hearing none, PNM Exhibit 18 is admitted.
And Mr. Hearing Examiner, Mr. Graves is ready to stand for cross-examination.
And we will begin not with cross-examination, but with examination by our Commissioner Ellison. Commissioner Ellison, go ahead.
Hi, good morning. Good morning, Mr. Graves.
Hi, Commissioner. Nice to meet you.
Nice to meet you as well. Thank you for appearing today for some questions. Is there a standard of care that a regulated utility should be upheld to when making major investment decisions?
In a qualitative sense, the answer is yes. I think it's quite hard to define a bright line where it's clear whether alternative ways of making those decisions would have been required, even if it would have been better or different. But the basic idea is that the utility should be applying received methods that are used throughout the industry, so using good industry practice with reliance on then available information and Generally the method of modeling and evaluation can be debated and varies considerably from utility to utility, somewhat dependent on the complexity of the problem. But sort of using standard tools and standard sources for data that are current is a threshold condition, which when upheld usually is deemed to be sufficient for showing that they were acting normally, even regardless of whether you agree with their decision or not.
Could those types of decisions be documented, those major investment decisions?
Oh, well, certainly they normally are as a matter of practice, because often, in fact, I would say virtually always, they are reviewed in some sort of regulatory evaluation in which all of the basic assumptions and the results are presented and subject to debate. So there's quite a bit of documentation that come from that. I'm not sure if you were meaning some other kind of formal report or something that was different than that.
I mean, some sort of documentation of how the decision was reached at the time.
I'm not aware of that generally being sought or developed in prudence cases or resource planning cases. In general, there's a range of possible benefits from the plan that the utility prefers, and they present those, and then say, on the basis of experience and the confidence they have in their analysis, they believe Plan A is the best of the group. But there's, how they formally weight which aspects to include and or put more emphasis on. That's sort of like all of us. It's pretty tough to say exactly how you reached a decision, even if you did careful analysis.
Right. Well, I guess what I'm getting at is, wouldn't it be a good idea when a utility is making a major investment decision to document their reasoning and analysis at the time of making that decision?
I would certainly endorse that as a good practice, but I don't know that its omission represents a failure if they otherwise had those reasons, but just didn't fully elucidate them.
Okay, let me give you a couple of hypotheticals. Let's say in one case, a utility does a thorough analysis of the alternatives when faced with a major investment decision. They use the best known information at the time, they document it, and it turns out later events transpire that that turned out not to be the best decision. Versus utility management flips a coin and makes a decision, and then later on that turns out to be a bad decision. Should a regulatory commission view those two scenarios differently?
Yes, I would certainly agree that you're making a good point that at the extreme of a sort of arbitrary selection, there's no basis for believing the utility had a good insight or made a good choice. And so if it's just luck, whether they hit a good or bad outcome, if it turned out to be a bad one, then that would per se, I think, require penalization. The tricky thing about the coin flipping situation is you don't even know what the but-for alternative would have been. Maybe they've got two listed, but they just chose them. But if they're just, if they haven't done the valuations and the simulations of what the payoffs and risks and so on would be, then you can't tell how much harm occurred by virtue of flipping the coin versus having done the analysis.
So it really sounds like, this question of prudency is not just about the decision itself, but it also encompasses the decision-making process. Would you agree with that statement?
Definitely, at the extremes, that's very true. If you did a spectacular analysis and it turned out unlike your expectations, then you're pretty much absolved. And if you did a terrible analysis and it turned out badly, then you've got some problems that ought to be recognized. So it's a sort of a continuum. One thing I would point out, though, that makes this tricky is the people who are doing the evaluation are experts in what is typical of these kinds of results. And so they don't evaluate everything all the time if they have, good intuitions or what they think are good intuitions about whether a particular factor matters or not. So that's one reason why modelers might differ in their views as to how much analysis should have been done.
Okay, but it sounds like, even not at the extremes, but just as a general statement, it seems that prudency involves not just the decision, but the decision-making process, because, I think you've pointed out that you make a decision based on the best information you have at the time, and no one's got a crystal ball. And if things just don't turn out the way you expect, that's sort of one thing. But if your analysis was deficient or incomplete or didn't take place, that's something within the utility's control, isn't it?
Fair enough. I completely agree. One way to think about that is that the standard is, would other professionals evaluating a similar the decision at the same time using reasonable care have reached essentially the same decision, whether they made the analysis that same way or not. So it is the coin flipping part would clearly violate anybody's beliefs that that's what a reasonable basis for concluding was. So I think the relevant test is, if you review it and you concur that what was done was reasonable and you might have done it differently but reached the same conclusion, that's pretty dispositive that it wasn't a coin flipping situation. Again, it's a gray boundary. So
if you review the analysis and decision-making process.
Correct. And to some extent, that's what I've tried to do in my report, is to say, well, let's reconstruct this so that we can decide whether.
I'm sorry, sir, you're breaking up. I've tried to do in my report is to say, well.
I'm sorry. Yeah, sorry. I'm staying at the same distance from the mic, but apparently it's not.
I'm sure it's just a connection, sir.
Yeah. Okay. Anyway, I was going to say, in my reports, I attempted to reconstruct the analysis from the point of view of a third party, saying, if we had done this analysis, or instead of them, using what we regard as then available information, would we have reached a similar?
No, Mr. Grave, that folks, please read my transcript. We go through this, and I don't want to go through this with Mr. Graves again over this, but there's a different standard that applies to this, isn't there? It's in the New Mexico Supreme Court decision. I'll just reference it there and I'll step right back out, but it's what they should have known, but you're adding additional material information that they could have used in making their analysis, but in fact didn't. And in fact, you agreed that it was a bad process, didn't you?
Well, I agree that it had omissions.
It was.
I would have done it. Sure. Yeah.
You didn't say before that it was a bad process?
I don't recall using that exact language, but
Well, that's why I have the transcript. Okay, go ahead. Go ahead, Mr. Ellison. Commissioner Ellison.
Sure.
I'm sorry. I just don't want to repeat this 7 years later, but we are. Go ahead. Commissioner
I
Olson.
was not trying to offer a legal opinion. I was just saying my analysis is a reconstructive one.
It is reconstructive, counterfactual.
If, Mr. Graves, it's fair to say that you've studied the timeline and the analyses done leading up to the decision on the Four Corners plant extensively, isn't it?
Yes, I wouldn't claim to be a complete historian on it, as there's a ton of detail, but I've certainly looked at it pretty closely.
Were there any was there any documentation of that May 2012 analysis that you refer to? The was it strategist runs, or were there any was there a report or memo or any documentation of the assumptions used or anything else about those runs?
I'm not aware, or I can't recall a specific document. It was not done in the context of an IRP. It was a supplemental study that PNM did. And so, of course, those foundational sources are available and were partly what we relied on. You're correct, it was a strategist analysis, but I don't recall a summary report of any kind.
A report, or were capital improvements included in that analysis? The capital improvements that would be required to keep the Four Corners plant operating in, with reasonable availability?
Other than anticipating an SCR was going to be required in any event, there was not an analysis of capital expenditures in the future for any of the alternatives.
Isn't the fact, hold on just a second, Commissioner Ellison, let me add about the SCR very quickly before I forget. I'm sorry to interrupt, but isn't the fact that the SCRs were anticipated problematic compared to what other resources might have been procured? The fact that they had to do the SCRs in and of itself, that was going to be environmentally required.
I'm not sure I'm entirely following your question. I think they.
Yeah, I think you are, Mr. Graves. The
No,
fact that that expensive equipment was going to be required just to keep pollution out of the atmosphere in an already very polluted environment, wasn't that problematic? You followed that, right?
Well, sorry, not trying to be argumentative. It seems it was, important to put on better pollution control. So, Are you saying with the fact that they were committed to doing that is the problem, or just that they needed to do it?
They made the commitment to do that.
Yeah, I guess that's a decision of the joint ownership, of course, as well. So it's not just PNM. And
I think
it
that may
relates
have
to
involved-
complying with the EPA rules.
Right. Go ahead.
Were decommissioning costs included in that May 2012 analysis? The Four Corners plant ultimate decommissioning costs?
I don't believe so, because in the 20-year time frame they were looking at, if they kept the plant alive, they wouldn't have decommissioned it over that time frame. They did not include it as an accelerated problem if they shut down the plant, which would have actually been a cost to leaving it, not a cost of having it. And that is I estimated to be about a $3 or $4 million oversight.
But if, continuing, it would seem that if they had ended their participation in 2016, then, the environmental liabilities of the decommissioning could have been transferred to another party, correct? I mean, there would have been a
Hmm.
purchase and sale agreement of the P&M ownership share, and that agreement could have dealt with transferring environmental and decommissioning liability. Is that correct?
It's possible that some of that would have occurred. My experience with decommissioning generally is that when some company has owned an asset that eventually needs decommissioning and they've used it for, let's say, half of its expected life, and then they want to get out, they retain liability for the component of decommissioning that the first half of the use of the asset's life involved. So even if a new owner picks that up and says, I'll take the liabilities from here forward, normally there's a transition cost that's assigned for you having to pony up for your contribution to the eventual need for it to be decommissioned, even if you're getting out of it.
And those decommissioning costs, given the environmental liability, could be quite large. Wouldn't you agree? I mean, you've got a large ash pond, I would assume, and wouldn't you think there's probably mercury contained in the ash? I mean, wouldn't you say that the environmental liabilities of remediating that ash pond could be quite large?
I think that's completely fair. There's plenty of environmental side effects that are undesirable from coal plants that we're, trying to get away from here more and more in the power systems. Those would have been costs that would have been incurred in the 2030s, assuming the plant continued to operate. So what the consequence of P&M leaving earlier, if they had left for a gas plant, is they would have to pay the present value of their share of those future costs, whatever they were estimated to be. And just to be clear, that would be a cost that you would incur if you exited it. And so it would be an increase in the cost to switching to the gas plant. If you don't exit it, you don't accelerate your liability for those costs. And so actually, even though they're high, they are actually an impairment to the decision to switch to the gas plant.
But you would have using your logic then, but you'd be exposed to not half of the liability, but you'd be exposed to the whole liability if you retained your ownership percentage to the end. Isn't that
You still have
true?
liability.
Fair enough, but it would be 20 years later. So the
20
present
years
value.
later, but potentially much more.
Some,
I mean,
sure. Mhm.
wouldn't you see that? I mean, given the obvious need to decommission the plant, wouldn't you see that as quite an important factor to take into account in your analysis when you're comparing the options of say building a gas plant versus continuing your participation in Four Corners?
I completely agree. I think that's normally embedded in the carrying costs of the asset while it's operating. That is, Four Corners was, I imagine, I can't vouch for the amount of monies, but normally the future decommissioning costs of a coal plant are built into the rates that are paid for it from the beginning of the plant's operations through its entire life. So that they're essentially funded by the time you get to the final liability. So we don't have to add anything to the Four Corners situation to reflect that. It's already embedded in the cost that it's carrying.
Is there such a fund associated with Four Corners, a decommissioning fund that P&M has been paying into?
I haven't reviewed the details of that. I don't know whether they have an escrow fund or sometimes companies do. Sometimes they just surcharge the rates and they bear corporate liability for it at the end without actually setting aside the monies that the decommissioning funds involve. It depends on the type of asset. So for instance, nuclear decommissioning funds are escrowed, but other kinds of plant retirement
Right.
funds are not always.
I'm not aware if this information is in the record, Mr. Medeiros, but is there any way that we might get some information on whether there is an escrow fund for decommissioning of Four Corners and whether PNM has been paying into that?
There's a lot of, Commissioner, there's a lot of analysis of that in the evidence on that in the 2117 case. Perhaps the parties could pull up or reference that for the commission, the relevant information from that case.
That's great. I obviously don't have the background you do on this case, so if it's in the record, I'm fine with that. Mr. Graves, how do you know so well what was and was not included in that May 2012 analysis if there is no documentation?
Well, there are records of the components of analysis that they did. What I was saying is I'm not aware of a report with a nice cover sheet and a staple around it that summarizes everything that was done and how it came together. But there are many simulation runs, and there's a model of how the revenue requirements for the assets involved were calculated, and those were available to us to reuse.
So there are some records there of what was done.
Yes, and of the assumptions as well, like what were the gas cost beliefs that they had, what would be the future coal prices, those sorts of things were also documented, but in documents about those topics, not a overall document.
Okay, thank you. And I understand that in October 2013, board decision was made at PNM, which decided to sign 3 contracts associated with the extension of their participation in this plant. Is that correct?
Yes, that's my understanding as well. That involved the plant and ownership and the coal supply agreement.
With those 3 contracts being signed later at different times, I understand I think it's called the joint tenancy agreement that extended PNM's participation was signed in March 2015. Is that correct?
That date sounds correct to me. I think it's actually called the joint operating agreement. And I think it was the signing was deferred to then because there was alterations of some of the other co-owners' involvement in the plant. El Paso, I think, was getting out of it at the time. And so they were I understand they were waiting to have all the right parties at the table.
I see. Could PNM's board have reconsidered whether to participate between October 2013 and March 2015?
Well, there's part of that is about organizational situations affecting all the other co-tenants that I can't speak to. I don't know what other arrangements they had made or committed to. I think at that point, if the question was, could they have abandoned the coal plant and moved to unload their share and start something else, that would have taken a lot of analysis that would have been difficult to accomplish and reach closure on that quickly. And in particular, it would have been difficult to reach a conclusion about getting started on something else because they needed the coal plant or something from 2017 on for adequate reserves.
Their participation ended as of the end of 2016. Is that correct? Was it through December 2016?
Under the old agreement, yes, it would have been, I think, July or something like that of 2016.
Okay.
By
I
the way,
would-
that was just,
a
I'm
little-
sorry, just for clarification, I think that was only the CSA that would have ended at that point. They still would have had ownership and ongoing joint operating agreement responsibilities. Had they not.
So the
restructured.
coal, the fuel supply agreement would have ended in June of 2016,
That's my recollection.
but their ownership of the plant would not have terminated as of the end of 2016.
Not without other reconsiderations, yeah.
I see, because it seems like that would be quite an exposure to be locked into a plant that has only one source of coal. You'd want to know what your coal price is going to be before you're locked into that situation. Correct? I mean, if they had not renegotiated the coal contract, then, where would that have put them? They would have had to purchase or, pay for the power from this plant or pay for the coal with an uncertain price.
In principle, that could have happened. I think that actually was some large portion of the motivation for the May 2012 study, which basically evaluated a lot of alternative coal contracting arrangements to see if it was feasible to have an attractive one. And I think those informed their eventual negotiations for the CSA, but that's probably better to ask a company witness about that history.
Let me ask a little about your post-fact adjustments on, I'm looking on page 27 of your direct testimony. In this case, you have a figure FG4 where you take the original estimated savings of 33 million for continuing participation in Four Corners that was done in May 2012. And then you make a series of adjustments to get to a plus 9 million savings by continuing to participate in Four Corners. Is that correct?
That's a good summary. Some of them are negative adjustments. That is, they make the retention less attractive, in particular fixing the item we discussed earlier about the omitted capital expenditures causes a big hit to the appeal of having the Four Corners. But then when you correct for some of the other items that need to be further incorporated, if you're going to make that adjustment, like adding capital costs for the gas plants and omitting capital expenditures that couldn't have been avoided anyway, adding the decommissioning penalty that we just talked about, you get back to about 9. This is all with the point of view of saying in 2012, what else could have been included to evaluate it.
So with the ongoing CapEx, is it possible that another party could have assumed that if P&M's share of the plant were sold?
Oh, certainly that would have happened if you'd gone to the gas plant. And what I'm saying there is if you imagine retaining it, which is what the $33 million bar at the beginning of that chart starts, and then reflect the fact that had you done so, you would have to keep paying for these capital expenditures for many years, for the full remaining period of the plant, for the next 20 years. That would have added a $75 million penalty to the evaluation you should have done, that by itself.
Right. Yeah, I'm asking about the third item there, the ongoing CapEx FCPP 2014 to 2016.
Oh, mhm.
If PNM had reached an agreement to sell its share, isn't it possible that the purchasing party could have assumed those costs?
You would imagine they would from whenever they took ownership of the plant. It would have been pretty snappy to turn it around, the day after this analysis and say, well, let's go sell it. So that would have probably taken a while. And this is not evaluating yet a third alternative of them selling it and then moving on at a different time. This is evaluating what if they had improve that or that original analysis to compare it to a 2017 switch to a gas plant. So that's why it's that long. It's until 2017. You're going to keep paying for the plant just because you're still the owner.
Okay, I understand. But does this take into account what the company might have been able to sell its stake for? I mean, shouldn't that be an offset here as well? If the company were able to sell the plant for, I don't know, 20 million or whatever number you pick, then it seems like, that is that would be something that should be taken into account.
It certainly is possible that they would have sold it for some amount in their share for some amount in 2017 had they chosen the gas plant. By cutting off the ongoing responsibility for the revenue requirements in 2017, I'm essentially assuming that the next party would buy it at what the present value of those revenue requirements was worth. In essence, the new owner wouldn't see it as any more or less valuable than PNM already did, because it would likely be a regulated utility doing the same thing as them. So I don't have an assumption that it would be bought at a premium, sold at a premium or sold at a discount. It's basically sold at its utility value, which means you can avoid paying those costs in the future.
So you're saying that in effect, your assumption was that they could sell it at book value?
Well, not quite. It's that it was worth, to be honest, I didn't assume a sale at all. There was no, and to my recollection, PNM also didn't evaluate a sale as the outcome as to exactly what would happen if they didn't have it. They simply compared what is, and I'm extending their comparison of what if you kept it versus what if you switched. And if you switched and avoided having to pay for its capital requirements after 2017, you're essentially saying it's worth what we are charging customers for it. And so once we don't have to do that, someone else will take over that cost.
Okay, and the ongoing CapEx for the new combined cycle plant, is that a net present value over the life of the plant?
Yes. Through the horizon of analysis, through 20.
I'm sorry, sir.
Through the horizon of analysis, which was 2032, I think, or 2033 in this case. Because they do the analysis as we did over a 20-year horizon. The plant would have had continuing costs after that, but they're truncated.
Okay. Wouldn't you assume that, on a brand new gas combined cycle plant that the ongoing CapEx is going to be fairly small?
Well, we used numbers that are representative of newish gas plants in this analysis. You can see that it's a $24 million bar compared to a $75 million bar for the coal plant. So it's about a third as much per megawatt as the coal plant. So it is smaller, but it's a meaningful number.
So you have some references to back up your assumption here on the $24 million of CapEx?
Yes, they're based on similar experience of PNM at other gas plants, at the Afton gas plant particularly, I believe in this case.
Would you agree that this $9 million of savings that is calculated here is essentially in the noise, given the magnitude of investment that we're talking about, and that really small changes in any of these assumptions could change it the other way?
Very true. I guess another way of saying that is that from this extended analysis perspective, it's about a tie between continuing with Four Corners versus switching to a new gas plant. And you're absolutely right that under different conditions, the tie would not occur. And there's some which would make the coal plant look better and some that would make the gas plant look better. That's some of what I do in my next exhibit in this testimony.
And if we look at your page 39, this figure 10, I wanted to ask about the change in CO2 prices, in particular, the $33 million change there. So the analyses in May 2012, I understood to assume a $20 per metric ton CO2 charge. Is that correct?
That's my recollection, and I think it grew with inflation.
And here you've assumed you've done a sensitivity on some more a lower charge, or some more gradual implementation of that charge. Is that correct?
That is correct, yes.
Is that information that the utility would have known at the time? That, obviously they felt they didn't do a sensitivity in May 2012 on the carbon price, correct? They just examined the $20 per metric ton.
In my recollection, that's right. I don't recall another one, right?
So is there any reason why, as of late 2013, why they would have doubted that the $20 per metric ton charge would come to pass?
Would still prevail? Well, what I'm trying to capture in this chart is things that did change in sort of the public record of how utilities and the utility industry were thinking about some of the major drivers like gas prices, carbon taxes, and so on. And there was new and information evolving about all of those during that time frame. And I took the updated information that was available by middle of 2013 to say, okay, if you took that into account, there was evidence that utilities were lowering their typical carbon penalty price that they were building into their analysis. And there was evidence that the possibility of a policy to impose a carbon price was also becoming less likely. So I'm just reflecting that. So
you're saying that there was increasing doubt in the utility community about whether the $20 per metric ton carbon fee would be implemented.
Well, the utilities all around the country don't share a uniform belief about that. Some barely penalize their assets, some do it quite a bit. But mostly they use a number something like $20, which they introduced in their modeling at various times to reflect the possibility that sometime in the future there will be a penalty that's explicit, that is a charge for having used a carbon intensive power plant. Their beliefs about what the likelihood and the size of that, change over time. But it wasn't like they were all using $20 and they all agreed that it should be 15. It was just on average, most people seem to be lowering their expectations for what that would be in the future.
So you're saying had PNM redone their analysis as of late 2013, then they could have wanted to do a sensitivity around this carbon pricing.
It's certainly the kind of thing people sometimes do sensitivities around, especially if they think it's very likely that the penalty price is going to be imposed. And if they looked at the possibility that it would be later or smaller, then it would raise the value of the coal plant because that takes away some of the penalty on carbon.
When you look at the outcome of this bar chart here, it seems that the positive finding in favor of retaining Four Corners is almost completely dependent on that CO2 price assumption.
Yeah, I guess if you eliminated that and said there was no change, then you wouldn't have a bar there.
Sorry, if you eliminated that and
That bar on the assumption there would be no change, then you would just be at $19, which is the cumulative value after the change in coal price in the middle, instead of moving on to 46.
Okay, so I mean, this one hypothetical on the CO2 price has a significant plays a significant role in this ultimate finding of 46 million in favor. Would you also characterize this as, pretty this finding as sort of being on the edge where things could tip either way, where you would favor the Four Corners or you would favor the gas plant?
Sure, I think much like the view that we discussed earlier, that I think was reasonable in May 2012, that it was sort of a horse race between the two. It's still a horse race. And as you can see, it's one that could come out widely different if circumstances broke in different directions. The biggest lever is gas prices themselves here.
the biggest lever is
Gas prices, natural gas prices. So if they were high, then you would vastly prefer the coal plant. And if they were low, you would strongly prefer, maybe not quite as strongly, but also prefer the gas plant. And
Okay.
But again, it was about even, except still remaining pretty uncertain. And that's intrinsic to this decision generally. These are just very volatile, complex numbers, and there's really no time in the last decade when you could have done this analysis and not have a wide band of uncertainty around it.
Right. Well, Mr. Graves, I very much appreciate your answering my questions. Unfortunately, I've got a 10 o'clock appointment that I can't miss. I did have a couple more questions, and I'll see when I finish, and if when would make sense to ask them,
Reconvene.
but I appreciate it.
Sure, happy to help.
Thank you.
Thank you, Commissioner Ellison. Mr. Graves, are you available for the full day today?
Sure.
So if the commissioners can come back and ask their questions of you today, you'd be available for the full day?
That could work. Yes.
Even if we moved to Mr. Watson and came back to you?
Sure. Yeah. As long as you give me a prediction that I need to be here, I'll be happy to stay.
Thank you. Thank you, sir. I appreciate that accommodation, but my understanding is you're leaving
I
today.
do have an early flight tomorrow, so if we can wrap things up today, that will be extremely helpful.
Excellent. Okay. Thank you, sir, for that accommodation. Commissioner Aguilera, would you like to ask questions later or try a few now?
Sorry, my mute button was hidden. Later would be better. I also have to, we have a meeting in 5-ish minutes.
Okay, great. Okay. Thank you, Commissioner.
Thank you.
All right. Thank you. Thank you both, commissioners. So let's start.
Mr. Medeiros, can I ask one? I just want to ask one follow-up question to Mr. Graves, based on what he told, how he responded to Mr. Ellison. Hello, Mr. Graves. How are you?
Doing well, thank you. Nice to meet you.
You as well. I just want to try to understand something, from my review of the testimony, and I understand PNM contest this, but the one of the principal objections from the interveners is the
Sorry, but
absent
one of
principal objections. Sorry if I'm going too fast, Mr. Lee. One of the principal objections from the interveners is the absence of analysis. And as you were speaking to, and as I say, I understand PNM has positions on that subject, but as you were talking with Commissioner Ellison, the thought entered my mind, and I really wanted to ask you, and I'm asking you now. Do you see something meaningfully different between an incorrect analysis and the absence of analysis? Are those fundamentally different things?
Well, they certainly can be if the absence of analysis is huge and not something where the omitted issue or the omitted questions might have had reasonable intuition without the analysis, and if they were also large influences on the result, then that's a problem to not have done it. It's not obvious that there's a bright line for defining when there's too much absence of analysis. I'm not aware of any regulatory standards for that. But as we talked about before, if you were at the extreme of flipping coins, then clearly it's a huge problem.
Well, because I think my thought is, we just gone through an interesting time in history with the pandemic. I mean, no business, no industry, no nothing. I mean, there was warnings, right? We all know now after the fact, hey, we probably should have done a better job preparing for the next pandemic. But it's difficult to blame people or to cast aspersions on someone who didn't plan for it, right? But in the very different circumstance where, and I think of, as an attorney, right, there's levels of expectations that I exercise a certain degree of diligence in all decision-making and advice I offer to individuals. And for me to not exercise it is itself a unique problem, which in many ways cannot be overcome. And I'm just wondering if you would accept that as a true proposition.
Yeah, I think I generally accept that there certainly is a level of incomplete analysis that would cast a lot of doubts on deeming a decision prudent, even if it turned out to be a good decision. The problem is if it's a decision you would have made anyway, then you're stuck with saying, well, I don't know how much to penalize it, even if I really am unhappy with the analysis, because it's not related to the size of the error that you made. It's related to sloppiness of your approach, which by itself didn't create the harm. It's just bothersome. So I think that's the tension. I agree with you that it brings into question the sufficiency of what was done, but it doesn't help us understand what's a penalty.
If we just say, you know what, it was sloppy, it was a bad process. It may have been a bad decision, but you know what? You guys were lucky. You ended up, according to Mr. Graves' damages analysis, in a better position. What's to stop the utility from being sloppy the next time with the ratepayers, with rate base? What's the disincentive to continue to act sloppily and negligently and just be lucky, hope that you're lucky the next time, like with the pandemic?
Well, it's a perfectly fair question. I would hope, and I think most utilities would say, luck is nice, but you don't want to bank on it. And so if you can improve your methods, you would, knowing that you got through. And so I don't think it's a matter of indifference to just saying, well, we'll hope as long as we got through lucky one time, we'll take our chances again.
And so you'd want somebody from the CDC, who's from your neck of the woods, to take over, right? Wouldn't you? And attempt to modernize and pay attention and do all the things that one needs to do to not end up with another as bad pandemic. Obviously, the pandemic could not have been avoided, but
Right.
it could have been mitigated with folks like, you know who I'm talking about. I don't know.
Sure, yeah, no, I do. I've studied that a bit myself. Sure, you would like to see proactive things that, of course, the pandemic was complicated by politics in a way, as there were, just as a historical note, there were pandemic planning procedures that were developed in the 2012 through 2014 period that were pretty good, but they didn't get followed because of politics and leadership, and things like that. So
the handbook got set aside. It may have gotten burned, right?
apparently, yeah. So, yeah, I agree with you that you would like to see something done to ensure better approaches.
Okay, thank you. Go ahead.
No,
Hearing
I'm
Senator
not
Ryan.
upset. Thank you. I that was my only question. Thank you, Mr.
Okay,
Graves.
thank you.
Yeah, okay.
Thank you.
Fine.
All right, Mr. Harris, are you available? Are you there? I have you up first. Is that correct?
That's correct, Mr. Maderos. I apologize for the skylight in back of me. The light in my office is perfectly adequate, but I see the picture
Okay.
here isn't the best.
Well,
We can
Yeah,
see you. Not bad.
is it 25 minutes?
That is correct.
Okay, go ahead and start, please.
Okay. Good morning, Mr. Graves. My name is Dal Harris. I'm representing the Water Authority this morning.
How do you do?
And all of my questions, and I don't think I will go 25 minutes, are in regards to your rebuttal testimony.
Okay, I have it.
Okay. Starting with page 7 of your rebuttal testimony.
Okay, I'm there.
Okay, lines 1 to 5.
Yes.
Okay. On the first line on page 7, there's a statement that specifically the coming period's net impact.
I'm sorry, that specifically,
The coming period's net impact. And are you referring to the time period of 2017 to 2036 mentioned at line 3?
No, what I've done here in this and the paragraph that starts on the preceding page is to break down the 2017 to 36 period into 2 periods, the history up to 2023 and the expected future from 2023 to 2036. So the 10 million refers to the future.
Okay. next, again, on those lines, I was going to ask you about the increase in costs. What time period were you referring to?
Yeah, again, that's from now till the 2036, the various elements that are included are, the operating period for Four Corners and the extended period for the reaching the 20-year horizon. for
Okay.
the analysis.
And then again, on the same page at line 7, you mentioned, as noted above, this course is uncertain. Can you please expand on what you mean by this course?
Well, if you break the harm analysis into 2 periods, the history one we have, all the numbers are in the books. So we know what natural gas prices were. We know what the plant's operating characteristics were. We know what, loads and all that stuff was. If we want to say, what does it look like going forward? We're back to some of the same problems we discussed about the prudence analysis, which is the realized costs for either the Four Corners plan or the alternative gas plant. We don't have them yet. We have to have a forecast, and there's uncertainty surrounding those. And again, as I mentioned just a minute ago to Mr. Ryan, the gas number is the biggest uncertainty there, or maybe to Mr. Ellison. But in any case, that's a big number, and if it were to be higher, as is a possibility, then that could significantly raise the cost of having a gas plant, which would make even less harm to customers from choosing Four Corners.
Okay,
I'm
thanks.
sorry, which would make?
Less harm to less apparent harm, or less assessed harm of the having chosen Four Corners. I actually don't believe there was harm, so I'm using the term harm, whether it's a positive or a negative number. If it's a positive number, there's no harm, it's a benefit. If it's a negative number, then it's a consequence to the customers.
Okay, thanks. Turning to page 8 of your testimony,
Okay.
lines 2 to 10.
Yes, I have it.
Okay, and in it, you discuss full recovery of prudently incurred investment costs when economics drive early plant retirements. Do we also refer to this as full recovery of stranded costs?
Yes, that's essentially the same thing.
Okay, it's just a clarification question.
Yep. It's very helpful.
Okay, and again, regarding this testimony, do you believe that there are considerations other than those mentioned at lines 5 to 10 regarding whether utilities should recover 100% stranded costs upon early retirement of a utility plant?
If we assume the question of why they decided to retire is settled, and that's deemed prudent, then I think I don't have other qualifications to the rest of that paragraph, because what I'm saying there is, for utilities, for the utility compact to be honored, in which utilities have an obligation to serve and only the opportunity to recover costs, they need to have that cost recovery sustained, even if an asset is chosen or it is discovered to not be as attractive at some point in its life as it was initially believed to be. As long as it was prudently chosen, you need to keep allowing full cost recovery. Otherwise, it's infeasible for the utility to expect to earn its cost of capital, which puts you back in a world where incentives fail, access to capital starts to decay, things like that.
Okay, my next question is, should the determination of whether a utility gets full recovery of prudent investment upon early retirement of a plant include a consideration of utility risk?
Well, you would hope that question would have been asked when you decided to retire it. If you're asking about if you've decided to retire it and now we need to evaluate utility risk, The risk is that if you don't allow full recovery, then you are per se making it infeasible for the utility to recover its cost of capital, which is a risk, but it's one that's being created by the policy, not by the decision.
Well, what my question really encompasses is if one assumes that the plant is early retired,
Okay.
then there is a consideration that the commission must make about whether or not to fully recompense the utility for stranded costs. And in making that decision, should the commission take risk into account, saying that it's a surrogate for the marketplace, and if this was a privately owned utility, nobody would recompense it. So why should one recompense a regulated utility if plant is early retired?
Yeah. Okay. I understand your question now. Well, the reason is there's a huge difference between a regulated utility and an unregulated one or an unregulated business, which is that the unregulated one doesn't have to build and doesn't have to, even in many cases, price on a cost of service basis. So they can pick and choose their markets and they can choose when to exit. And as a result, they have a mechanism for bearing the risk of assets becoming obsolete before they expected. And they have a mechanism for making extra money if they build an asset in a place where it's super valuable. None of that applies to a regulated utility that has cost of service rate making and an obligation to serve, because they can't choose when and where to build. They have to build. And then if the thing they build turns out to be great, they still only recover the investment costs that they put into it. And some assets over a very long time of their operating lives will almost inevitably turn out to not be fully attractive for their entire originally intended life. And that's actually perfectly normal. It's just impossible to pick all winners. And we do want people to pick choices when they are expected to save money, not when they're guaranteed to save money. So at some point, assets built under a regulated obligation to serve, some of them will turn out to not be as attractive as you hoped. And if you at that point say, we're going to use some use and useful or 50-50 cost sharing or some other rule to not allow full cost recovery, you've created a world where the utility can only recover its costs if nothing goes wrong. And if some of the time, hopefully rarely, something doesn't live up to its intended original view, you don't get your money back. Then on average, you don't get your money back. And that's a setting you don't, that's an incentive you don't want to create for utilities to say, you have to make long range bets, but we're only going to let you break even on the good ones. If it was prudent when it was chosen, you should keep paying for it. And that's why you should have full stranded cost recovery.
But isn't there a countervailing consideration that in order for a regulated utility to be efficient, it must make prudent decisions? And if some of they must make decisions, they have to serve utility customers, and some of them go wrong, they should bear some of that risk, just like a private industry would have to bear some of that risk in order for the utility to regulated utility to remain on top of managing its business.
Well, again, it's not a good analogy to say just like a private company would, because it's not just like a private company would. A private company has lots of other mechanisms that I mentioned for choosing when and where to invest and how to recover its money. So they are stuck bearing the full consequences of bad decisions in ways that we can't extrapolate to regulated utilities. Now, there's a little bit of an incentive to say you might not get to keep recovering all your money if something goes wrong, so you should be really careful. But there's also an incentive that's a perverse incentive created if you say, well, if anything goes wrong, we're not going to give you your money. Now the utility knows that it on average can't recover its money with an expectation. And so it's going to tend to say, I'm going to do the safer thing, not necessarily the more economical thing, because this game is stacked against me. So I will not build assets when they first look like they would save money. I won't look around for things to improve because they might make something else look bad. Because now you've created an incentive for me to be cautious, not to be efficient.
Okay, my follow-up question on this line.
Sorry, Mr. Harris, you're breaking up. Could you start again?
Okay, my follow-up question is that if the commission were to decide that under these circumstances, the utility gets to recover 100% of stranded costs, would this impact the return on equity?
Well, in a cash flow sense, of course, they'll have more money coming in so they'll earn more of their allowed return. Do you mean, would it affect the allowed return that they need in the future?
Yes. Because the risk is removed.
Well, this gets into a fairly arcane issue of finance, but as a general rule, financial markets don't price in insurance-like risks because they're not systematic. They don't rise and fall with the size of the economy. And the way the methods for estimating cost of capital don't capture it. So what happens is if a utility thinks it's going to, or any company thinks it's going to bear a loss, and it's a one-time bad luck outcome, it lowers their cash flows, and that reduces their earnings and reduces the value of their company. But it doesn't make the market say from now on they need a higher or lower return, because it's deemed to be a one-time too bad thing that doesn't change the fundamental risk characteristics of the business. So I would say as a general rule, it won't affect the allowed or measured cost of capital. It might affect bond ratings because creditors are very sensitive to the probability that they're going to get paid. And this would be a signal that they're likely to get paid because the regulatory compact has been honored. So you would probably be able to sustain a higher debt rating than you otherwise would.
Thanks. Turning to page 13.
Okay, I have it.
Okay, lines 13 to 19.
I see it.
Okay, leaving the question of prudence aside, were the hearing examiners correct in their findings in case 16-276? The strategist runs did not include Four Corners' ongoing capital expenditures, and that the analysis conducted between May of 2012 and October 2013 was not updated.
Sure, I agree with that.
Okay, and I believe you mentioned that the commission, let me make sure that I'm on the right. Okay, I am. That the commission final order did not adopt the hearing examiner's findings, relying upon those findings as a flawed approach. Why do you say that relying on those findings would be a flawed approach?
Well, in part, not because they weren't describing the situation factually, but they didn't, and it wouldn't have been aware that was an incomplete description of what else was not done in the analysis.
And what else was not done? Go ahead, finish.
Which had some offsetting effects. If they were
and those things would have been available in the either, or would have been available to those executives had they just thought of those things, right?
Sure, those are things that could have been done at the time.
But they weren't.
Correct. But all I'm saying is
Okay.
your record wasn't aware of that gap, as I understand it.
Well, we were looking at what they actually did
Sure,
and didn't do.
right. I understand that.
And if you add more things that they could have known and should have applied, as I said before, doesn't that make the decision just look that much worse? That they didn't think of these other factors that they should have researched that you bring back in your counterfactual?
It certainly makes the process look that much worse. It doesn't make the outcome look that much worse.
Okay, okay. The process is even worse than the bad process that you described in 2017 then.
You know, I guess just to be a little bit more accurate, I'm a little uncomfortable with the word worse process. There's incompleteness to it, and it would have been perfectly sensible to have included other ways of doing or additional information in the analysis. There's always things that are missing in anybody's analysis because it's too hard a problem to look at every variable and to know. So there's judgment, and I would say it certainly was more incomplete than you would have desired. Whether it's worse, I don't know.
That's my task and hearing examiner Ryan's task in the Ray case.
Sure.
It's just what you described. There's just so much, and you hope you don't miss. You're hoping you don't miss the big things, and that
The
you
main
don't miss
ones.
everything, because you know you're going to miss some. It's inevitable, I guess, at least for me. So I'm certainly
Certainly as a
very
planner,
far from.
I'm sorry, as a long-term planner of the industry, I'm completely convinced you're going to miss something occasionally.
That's a certainty. All right, thank you. I paused you, Mr. Harris. Go ahead and start. I paused your cross-examination because I interrupted. Go ahead.
Thank you, Mr. Medeiros. Yeah, I mean, to me, this is the heart of the issue on prudence. Turning to page 14, lines 13 to 16, where you pose a question.
Have it? Mhm.
Okay, so the question is, should a finding of prudence be based only on information that is available at the time? The question I have, does the answer to this question mean that the commission can make its prudency decision based on information that was available when PNM made its decision to extend participation in the plant, but it is not bound to the evidentiary record that was in 16-276?
Well, I think that's more of a legal question than a economics question. It may well be that there's a restriction in New Mexico to use only the evidence in the proceeding, in which case my supplemental analysis doesn't inform things, I guess. But if the question is, was the decision supportable by of information available at the time, possibly more than was used, then that's the question I've tried to answer. And
okay, the question I'm asking is, well, I guess you've answered it. The answer, am I correct in the answer, is that the commission can now consider information that was available but not in the record?
Well, as again, I'm not offering a legal opinion, but if you want to know whether what was done was reasonable, I think it's almost essential that someone else recreate what a reasonable approach would have looked like, and they may not do it exactly the same way. And if they reach the same conclusion, essentially, then that is helpful to supporting the original approach.
Okay.
Can I interject? Can I ask a question, Mr. Dahl, a follow-up question real quickly?
Certainly.
Mr. Harris, excuse me. What you're talking about sort of gets back to the point that I believe Mr. Medeiros was making. It's making me think about it. If regulation is intended to function as the proxy for market forces within the regulatory field, and a decision is made, and we absolve the decision maker of any consequence. So, for instance, to take your analysis and say, had they made a decision, the outcome is still a wash anyway. I mean, aren't we then omitting that the regulatory sort of obligation necessitates some sort of negative penalty? Otherwise, you effectively have the utility functioning in a completely risk-free environment. Is that an accurate conception?
It's an overstatement of what I was hoping to convey. What I was arguing is that thanks to the cost of service and obligation to serve context, you need to recognize continued cost recovery for prudently chosen assets. And that decision should be evaluated relative to what was known or knowable at the time, using reasonably standard and good methods. That could easily find that you blew it, that you didn't do it right, and then the consequences are harm that should be remedied, and often are remedied at the time based on the analyses that were done with the disagreement in the analysis. Here we have a problem, and we're looking back 11 years later saying, maybe that wasn't a good decision. So how do we reconcile the assessment of it at the time and whether we agreed with that to the consequences, which have actually unfolded in a very different environment? So that's why I've distinguished those two. But I don't think it's a get out of jail free card. You could lose the prudence test, and then there could be harm. So it's not a riskless environment.
But I guess that's what Mr. Harris is sort of pointing towards, is like, well, do we look even, can we look outside of what they knew at that time? And it seems like on some basic level that question is fundamentally concerned with ensuring decision-making is done competently, regardless of outcome. We
Right.
always need to incentivize a thorough and beneficial decision-making process for the very reason, which is that we want that to continue into the future. And that's like kind of the entire regulatory field, really. That's what it's all about. So if you waive the penalty for a bad process merely because the outcome wasn't as bad as it could have been, you're not really doing something necessary to a process. That's I guess what I'm trying to argue, and see what you think about that.
Yeah, fair enough. I agree with you. You want to incentivize good process. Here, I don't think it's just that the outcome wasn't as bad as you'd hoped. I don't think the decision was bad in the first place, because in my reconstructing it, although I reconstructed it differently, I confirm that it appealed, or that it was a close to a tie with the gas plant. So I don't find that there was a failing at the outset.
Okay.
I only do the harm analysis to say, just in case you don't agree with me, or you want to know, notwithstanding whether it was a good or bad decision, how have we fared under it? That's why I do the harm analysis. But I agree with you that you want to incentivize good methodology. If you don't use good methodology, but you get or ideal methodology, but you get a good outcome, it's not obviously what the penalty for methodology should be, because it's not related to the dollar value of the decision that was made. It's more of it's more like punitive damages in a sense than valuation of the harm.
Right.
Has this harm analysis ever been conducted by you or anyone else that you're aware of in the context of a prudence review, like involving utility decisions like this one?
It's a great question, and I wondered about that myself. I'm not familiar with any other similar assessment, because normally the question of prudence and committing to a resource or abandoning a resource are evaluated roughly concurrently, and the value of whatever you choose to do at the time, if you made a bad decision, is the value of the future harm that you then expect from not having made a good choice. So normally we just decide whether you did a good job or not at the time, and we do it pretty close to the time the thing happened. Here again, we've got this huge lag and immensely different circumstances surrounding the assets, so that it's more like a civil case where somebody discovers they've been harmed by something over many years, they establish liability for it, and then there's okay, what were the consequences? So
And
I did it.
You did it in,
I did it in that analogy, and it's not, to my knowledge, rarely or has not at all happened in the utility industry because of it's very rare to have this long lag.
at Brattle Group, you consult and testify in civil litigation as well as the regulatory sphere, right?
Sure. Mhm.
And
Myself.
you've conducted your harm or damage analyses, as I recall from 2021, in civil cases representing what types of companies or litigants?
Oh, yeah, many. I've done several myself related to failed power plant performances, botched construction, bad hedging decisions that didn't work out. And when we do it for all kinds of things, product liability, all sorts of.
And how many of these analyses that you've authored and presented in civil litigation involved vertically regulated monopolies? Utilities.
You mean in my own personal experience or for broader?
Yeah,
Yeah.
that are subject to a regulatory compact, like utilities in New Mexico are.
Not zero, a fair number, but you know, a handful. I don't do these terribly often. I'm much more involved in utility planning and prudence, but several of them have involved utilities.
The damage analyses?
As I recall, yes. In particular, where there's things like a utility that wants to get a power plant built and the power plant is being developed by somebody else who fails, and then the utility sues for damages, or the developer sues the utility for damages. That's a fairly common circumstance that I've been involved in a couple times.
Okay, I paused you again. Thank you. Thank you, Mr. Graves. I paused you again, Mr. Harris. Go ahead.
Thank you, Mr. Medeiros. Mr. Graves, aren't what we're touching on these discussions what lawyers we refer to as finality? How, shouldn't cases be over rather than going back 10 years and saying what could have been done versus what was done, and basing analysis on what was done versus what could have been done?
Well, certainly this would be a lot cleaner if it had happened sooner. There's no doubt about that. The only reason for looking back is if it's a two-part question. One, was there imprudence? And if there was, what is the harm that's ensued? And so we kind of have to look back a fairly long ways for the first part.
Okay, let's turn to pages 9 to 10, the last line in page 9 going on to page 10, where you address the position taken by Mr. Sandberg. Do you agree? I mean, this is what we've been talking about. Do you agree with Mr. Sandberg's position that the decision-making process is the only consideration that matters in determining prudency in this case?
Well, sure. I don't think that's any different in some ways than other cases, but because in general, if I'm reviewing the prudency of some other utility doing some other decision, building a nuclear power plant or whatever, you want to evaluate whether they did it reasonably well, in the sense that another person considering the same problem at the same time with available techniques would have reached essentially the same conclusion. However, that reevaluation almost certainly won't be done identically to the original one. So the point isn't that the alternative viewpoint has to be identical and confirm everything that the other company did. It just has to show that it was within the bounds of reasonable analysis that somebody else might have done.
Okay,
And so in that regard, I guess I disagree with Mr. Sandberg that it can't be just about what PNM did, because we have to think about it in context.
so your position is that the commission is not bound in this case to the record that was made in 16276, but can introduce other evidence to consider what was done, rather than just depend upon the record in 16276?
Yeah, I guess that is my position, that they should at least evaluate other evidence, because to decide if it was done prudently, you need another perspective.
Thank you. Now we have clarity on what's at issue. Turning to page 10.
I'm on 10. Mhm.
Okay, the lines 12 to 14 where you discuss the goal of review.
Okay.
Okay, do you believe the hearing examiners in case 16-276 improperly substituted their review of how the analysis of PNM's continuing participation in Four Corners should be conducted for how PNM actually conducted its analysis?
Well, first of all, I'm not commenting on any specific person here. I'm talking about a principle. So that's not meant to be, implied assessment of anybody's view. But I think the hearing examiner mostly and accurately described what did go on. Sorry, what was the rest of your question? I think.
Well, it was just a question of on this, the goal is not to substitute, one's own views for an analysis versus what was actually done. And so you answered my question, that you thought that they accurately reflected what the record was.
Oh yeah, completely. I'm here offering a general viewpoint from my experience in prudence cases all around the country, that the point isn't to say, yep, we would have done it identically to that. It's to say, our view is that reasonable analysis similar to addressing the problem at a similar time would have reached the same conclusion.
Okay, let's turn to page 16.
Okay.
The lines 4 to 6 that states a remedy should be based on how customers should be held harmless from any imprudent decision making.
Right.
Okay, assuming that this is a true statement and the ratepayers have been injured by an imprudent PNM decision to conduct continuous participation in the Four Corners power plant, how can the harm be accurately determined now if the plant continues to operate for another 8 years?
Well, if the allegation is that it's imprudent because the next best alternative that the company didn't choose is what people believe they should have chosen, then we can compare, as I did, what has happened to what would have happened, although we can't be 100% accurate in that, but to what would have happened had the alternative resource been chosen. So it's certainly feasible. It's, analytically a little bit messy, but it's no worse than resource planning.
Yeah, but isn't this a sort of a woulda, coulda, shoulda situation where you don't know exactly what the best alternative would have been? We don't know exactly what the costs of continuing to operate that plant would be. So it appears to me that this is just pure speculation and making this type of determination.
Well, I certainly wouldn't claim it's exact. I'm not, in any way saying that this is down to the decimal place as to what the world would be like. But first of all, even to allege imprudence, you have to say that something else should have been chosen. You can't just say, we don't like what you chose, but we don't have a better alternative. We're just pretty sure it wasn't that. Then we have no basis for criticizing the analysis or deciding that there's any harm. So what I did here is I assumed the next best alternative is the thing that was competing with the coal plant for consideration at the time, which was this 252 megawatt gas plant. And then I can replicate, with some inaccuracy, no doubt, about what that would have cost versus what the coal plant has cost.
Right. And Mr. Harris, you're in overtime or injury time or added time. Would you like to continue? And I'll have to deduct from another witness cross-examination time from the Water Authority.
I think that that would aggrieve Mr. Herman, which I don't want to do. So,
No,
thanks for reminding me. I will end my cross at this point in time. Thanks a lot, Mr. Graves. I appreciate your answers.
Sure, happy to chat with you.
Okay, Mr. Harris, thank you so much. It's really great to see you.
Same.
All right, we're at 10:38. Let me ask the Attorney General, Mr. Elliott, do you have 15 minutes across?
I do have 15 minutes of cross, and I was going to let you know that I was hoping to move some of my time for Watson to Mr. Graves. I have 10 minutes.
Right. What would you like to do?
I would like to move it to Mr.
All of
Graves.
it?
Yes.
Okay, then let's, the reason I'm asking is not because I care where you move your time around. It's that I think it's time for our morning break for 15 minutes.
Yes.
That's why I'm asking. So it's
Understood.
10:40. Let's come back in 15 minutes.
Thank
All
you.
right. Thank you very much. Thank you, Mr. Graves,
You bet.
For
Thanks, Greg.
bearing
Appreciate
with me.
it.
Thank you. All right. See you in 15 minutes. We're in recess. Hey, good morning. We're back from our morning break on this third day of hearings in PNM's rate case. Mr. Elliott, you have 25 minutes with Mr. Graves. Is that correct?
Yes, sir.
Please proceed.
Thank you. Good morning, Mr. Graves.
Hi, how are you?
Good, thank you. How long have you been with the Brattle Group?
I'm one of the founders, so 27 years, something like that.
And I reviewed your resume, but where did you work prior to the Brattle Group?
I was with a similar firm, much smaller, called Incentives Research, which merged with a similar small firm in 1995 to form the Brattle Group.
And I saw that you filed testimony on behalf of PNM in case 12-00317. That was October 5th, 2012. And that case involved incentives for energy conservation activities. Was that the first time you filed testimony on behalf of PNM?
Probably, I don't recall anything before that. It would be on my resume if I did. I think it's a ridiculously long resume, but it's supposed to have everything that I did.
It is 40 pages.
Yes.
And I do have some other questions about it, but the next case that I saw was 19-00018. That was in 2019. Is that right?
Sounds correct.
Okay, and then the next case was in March 21, and that was the 21-00017. That's the
Right.
four. That's
The
the four
one before
corners.
was San Juan, and this one, that's the first Four Corners one. Yes.
Okay,
And that's the Four Corners?
The 21 is the Four Corners case. The 19 was San Juan.
and prior to that case, did you file any testimony on behalf of PNM relating to issues involving Four Corners?
No. This was my first involvement.
Okay. And on page 2 of your direct, where you just say that PNM retained you to evaluate the prudence of PNM's prior investments, specifically PNM's participation in the decision by joint owners of Four Corners Power Plant to extend the coal supply, so forth. When was the first time you were approached by PNM to testify on issues relating to Four Corners?
I couldn't put a precise date on there. Sometime in the summer of 2022, probably.
Okay.
Yeah. Sorry, in this proceedings, summer of 22. In 21, boy, I don't recall.
The testimony was filed in 21, so.
Yeah. 6 months before the filing, or maybe 9 months, something like that.
Okay. And did you provide any consulting services for PNM other than filing of testimony before that?
Do you mean in regard to advising them on what to do with the plant, for instance, or what do you?
Certainly, that would be one. Did you advise them on whether to extend participation in Four Corners?
No, I had no involvement in any of those decisions.
Okay. And you provided no consulting services in 2015 or 16 when it got closer to the time to extend the coal supply agreement and the joint ownership agreement, right?
Correct.
Okay, and during the period of 2013 to 2016, did you provide any consulting services to any of the other owners of Four Corners?
Not in regard to Four Corners. I have worked off and on fairly frequently with SCE and with APS occasionally. And I think I did some in that time frame, but not much. And for SCE, I was extensively involved, but in regard to their own nuclear plants.
Okay. And SCE, for the record, is Southern California Edison.
Correct, yeah. I assisted them on their Songs nuclear plant shutdown decision.
Could you spell that nuclear plant name, please?
It's the San Onofre Nuclear Generation Station, which they shortened to SONGS, SONGS.
And are you currently involved in assisting PNM in evaluating whether it should continue to operate Four Corners or exit the facility?
No, I've done no planning analyses for them other than the types of studies you've seen in this testimony.
Okay. And then just, do you recall the net book value for Four Corners, what it was in 2013?
Wow. No, I don't.
Does somewhere between the range of 58 to 60 million sound right?
That's believable, as I think by 2020 or so, it was around 200 and some million, of which about 180 was new spending since over that time frame. So 60-ish is plausible.
The company estimates the undepreciated investment in Four Corners would be 271 million by December 2024. Does that sound right?
Yes.
Okay. Just turning to some of the questions that hearing examiner Medeiros was asking you about your prior work on behalf of litigants and also in the utility planning and operations. If you wouldn't mind turning to page 12 of 40 of your resume, that's
Sure. Hold on one sec.
thank you.
Okay, I think I'm there.
Okay, the third bullet down. Would you mind reading that for the record?
No problem. Yeah. Beginning with for the board, or is it the air quality one?
Air quality one.
Okay. Air quality and other power plant environmental regulations were tightened considerably in the period from about 2014 to 2018. Mr. Graves has co-developed a market and financial model for determining what power plants are most likely to retire versus retrofit with new environmental controls, and how much this may alter their profitability. This has been used to help several power market participants assess future capacity needs.
Could you slow down just a bit?
Yeah.
Happy to. I'm
Please,
sorry.
for the core reporter, sir.
Of course. Are you caught? Should I start with this has been used? Is that okay?
Certainly.
Okay. This has been used to help several power market participants assess future capacity needs, as well as to adjust their price forecasts for the coming decade.
This sounded apt. What was this something that you discussed with PNM?
Well, you mean, were they one of the parties that we looked at in that analysis?
Certainly that. Yes, if you would start with that question.
They were not a direct participant in any of that analysis. That was.
Were they an indirect participant?
I suspect the coal plants that they owned would have been included in our sample, or that they co-owned would have been included, but it wasn't done for the sake of PNM. This was, nor really for the sake of some of this for the sake of any individual owner. It was really just looking at plant viability as a whole.
And Do you still use that model?
No, I would say not. There's kind of two types of models embedded in that description. One is we had a general evaluation of the exposure of the industry to environmental shutdowns. And here and there, utilities asked us to do a much more detailed analysis of their particular market region, just adding detail to the model. And we did that a couple of times in that time frame. But since then, environmental compliance has not been as big an issue. It may become so with regional haze emerging as a strong question. But more the problem of late has been just economic viability and economic competitiveness compared to renewables, especially compared to renewables and somewhat natural gas. So the problems have shifted, and so we haven't really reused that model that much, if at all.
So it's not a model, or there aren't findings that you shared with PNM with respect to.
Correct.
Cohorts.
Yes. We didn't have any direct communication with PNM at that time.
The other item on your resume was on the following page. That's page 13 of 40 of your resume. And it's the 1, 2, 3, 4, 5. It's the fifth bullet. Begins with the several utilities.
Correct. Yep, I see that.
Would you mind reading that for the record?
Okay, this is a longer one. Apologies to the court reporter. Several utilities with coal-fired power plants have faced allegations from the US EPA that they have conducted past maintenance on these plants, which should be deemed major modifications, which is in quotes, because that's a term of art, thereby triggering new source review standards for air quality controls. Mr. Graves has helped one such utility assess limitations on the way in which GADS data can be used retrospectively to quantify comparisons between past actual and projected future emissions. For another utility, Mr. Graves developed retrospective estimates of changes in emissions before and after repairs using production costing simulations. In a third, he reviewed contemporaneous corporate planning documents to show that no increase in emissions would have been expected from the repairs due to projected reductions in future use of the plant, as well as higher efficiency. In all three cases, testimony was presented.
Could you tell us where those cases occurred?
Yes, one of them was Duke in North Carolina. One of them was West Virginia. And I believe I'm not positive of the without really going into the archives of, I think one of them was in Kentucky.
Okay. The contemporaneous corporate planning documents, the review of that seems relevant here in terms of the review you conducted.
Okay.
So it caught my eye. I guess the only other question I wanted to ask is, so going back to the prior item on your resume that we looked at, the 2014 to 2018, that was the Clean Power Plant, the Obama administration's Clean Power Plant plan. Is that right? When new emission standards were being issued?
That's about the right date for that, yes. And it went through a couple of variations. There was also the MAT standards for toxic emissions, mercury controls.
Mats? standards?
MATS is what it was called, MATS. And there might have been a couple others also changing at that time. There was quite a suite of moving air quality requirements.
It occurred to me just listening to the testimony yesterday in terms of discussion of capital spending plans, that in some ways increased environmental controls and SCR itself was an opportunity to invest in capital, to make capital expenditures, which the utility would earn a return on. And so wasn't the utility, I mean, was there really an incentive for the utility to second guess the need for those investments?
Well, a couple of things. One, at least as I recall, at least one of the plants we looked at was a merchant plant. It was operating in PJM, and so it didn't have a cost regulated.
Right.
So for it, extra expenditures simply ate into the operating margins of the plant. But even for the others, which were regulated, or mostly regulated, the regulations themselves weren't cast in stone at some of those points in time. And so there was a risk that you would choose to comply in a way that might look unnecessary or imprudent after the fact. If you chose a scrubber when a SNCR would have been good enough, or maybe fuel treatment would have been enough, and or maybe it was appealing to do some transitional strategy while you waited to find out what the final rulemaking was going to be. So there were risks, and regulatory reviews were involved in all of those as well. So they needed to be able to justify their decisions.
Thank you. I've asked all my questions. So thank you, Mr. Hearing Examiner. Thank you, Mr. Graves.
Sure.
Thank you, Mr. Elliott. Okay, up next with Mr. Graves is Mr. Marks, Sierra Club, 40 minutes. Is that correct?
I think it's correct that I'm up next with leave of the hearing examiner. I'd like to, excuse me, move 5 minutes from that to Mr. Heffington.
So you want 35 with Mr. Graves?
Yes.
Okay. Go
And
ahead.
aside from whatever I've got in my throat, is my audio okay?
Yeah,
It's a little
you're
low.
very faint.
I'm sorry, Mr. Lee.
It's I'm hearing him very faint.
Yeah, it's
Yeah.
low.
It is.
You have a headset, Mr. Marks, by chance?
I do.
Say this often, but the microphones built into most laptops or PCs, the factory built-in is they're just a joke. So it's always useful to have a separate mic and audio source.
Hopefully it's gonna figure out it's attached. And then
Yeah, maybe Mr. Ryan, you're saying that because of music orientation. I'm a violinist, and every so often I try to record or perform things. And if you use the PC-based mic, it sounds like garbage.
Yeah,
It's really terrible.
it's cost savings. They're low quality, the lowest
Yeah.
quality they can put in.
Mhm.
Okay, I can hear you folks in my headset. Can you hear me?
That's
You are
better if
very-
you can. Yeah, can you
you're very-
volume? Can you increase the volume on the mic? Do you know how, is that a possibility?
I'll try.
Much clearer.
Yes, way clearer for sure.
Okay. How's this? Better volume? Any distortion?
No, just increase the volume, please, a little bit.
I'm trying. Says it's increased. I'll go up more here. Is this better?
Yes.
Thank you.
Okay. Well, think, and Mr. Maderos,
Yes,
could we
sir.
restart my timer? I don't think I'll use the 35 minutes, but
Well, this is where the pre-hearing order comes in about just this issue. I have to take this from your time.
okay, let's. Mr. Graves, good afternoon. In case 210017, you acknowledged that you had never omitted ongoing CapEx from a resource selection analysis, and that was standard practice in the industry to include that. Is that still your testimony?
Yeah, that would be consistent with my recollection of all my experience, yes.
Okay. And I think you may have also testified that you were unaware of any utilities other than PNM which had ever made that error. Are you aware of another utility making that same omission?
No, I can't say that I've studied the behavior of modeling, in some comprehensive way, but in my experience, I haven't run across it.
In cross-examination in case 210017, you acknowledge that being distracted by BART, B-A-R-T, matters at San Juan would not have been a good reason to renew Four Corners without conducting a thorough analysis. Is that still your opinion?
Sure, I have no knowledge that distraction occurred, but if it had, that would be, I think, irrelevant to the valuation of what you should be doing at San Juan. I mean, at Four Corners, except insofar as it affects your total resource pool. If it was a question of will you have San Juan or not, then it matters to Four Corners. If it's
In case 210017, you acknowledge that if PNM had included ongoing CapEx and made other fixes that you did in 2013, the decision would have been a close one. Is that still your testimony?
Yes, the analysis I reproduce here is virtually the same as in that one, and that's the sort of tie that we discussed with previous examiners. It's very close to a break even between the two choices.
Thank you. I've compared the damages analysis that you did in case 210017 and the one in the current case.
Okay.
And it appears that the claim savings from PNM renewing Four Corners decreased from 40.1 million to 6.0 million. Does that sound about right?
Sorry, can you need to point me somewhere a little more precisely. Are you referring to the prudence analysis or the harm analysis, or what are we talking about?
I'm talking about the harm analysis, and you came out with a $40 million benefit to customers in the last one, and now it's 6 million.
And the last one,
And now it is 6 million.
I can't vouch for sure for the 40. That sounds about right. But in that case, we were evaluating a different disposition for Four Corners, that it would be transferred to NTEC. And so it didn't have the same future as is now evaluated here.
Okay. And so you're agreeing those sound like the correct numbers, and 6 million is correct in your current analysis.
Let me just check that. Hold on one second. Yes, 6 million. You can see this on table FCG 1 on page 25 of my rebuttal. The 6 million describes the benefit or the non-harm. If you evaluate it from a 2012 perspective, it's a bit more from a more current perspective.
Thank you. And I think you just said you identified the 2025 exit as being a major difference Would you agree that that's the major part of the narrowing in the negative harm?
Well, it's certainly material because it's evaluating a completely different strategy for the disposition of the plant. Other things have changed that I have also updated. I don't know what the relative share of those is in relation to 40,
Right.
but that was a material change.
Right.
It looked at the time that the selling it to Entech would be a net benefit, and so that would have further reduced harm from having four corners if you had decided it was imprudent.
Between the two analyses you did, the price of natural gas went up, didn't it?
Yes.
Okay, so that made the Four Corners, stay in Four Corners case more favorable.
You're right in the interim, and it's a little different going forward too, but that's right.
Okay, and yet the two cases narrowed because the stay in Four Corners got more expensive staying past 2025, correct?
Essentially, yeah, but I mean, again, other factors changed, but you lost the benefit of the potential sale to Entech, which looked like it was going to be a further improvement in the resource plan.
Okay. If I told you that when we compared your analysis in the last case and in this case, that the stay in Four Corners scenario increased by more than $75 million, would you agree that's true?
What are you comparing it to? I'm sorry.
Comparing your stay in Four Corners present value cost in the last case to the one in this case, and that staying past 2025 has increased that by more than $75 million.
I have no idea. I haven't seen your work papers or that calculation, so I can't vouch for it.
And you haven't recently reviewed your previous testimony.
Only generally to be aware of the qualitative differences and similarities.
Okay. In both the Four Corners abandonment case and in the present rate case, your damages analysis assumes that the hypothetical gas plant is dispatched so as to produce the same amount of energy each year as would have been produced or as would be produced by Four Corners, correct?
That's correct.
Okay. In the real world, isn't it true that increasing gas prices would impact the utility's decision on how and when to dispatch a gas combined cycle plant?
Abundantly correct. Yeah, in a more time and resource rich environment to evaluate this, you could have reevaluated future dispatch, and maybe the gas plant wouldn't have run as much. Possibly some other things would have gotten built eventually. So I didn't do a system analysis. I did a equivalent replacement analysis.
Yeah, all right. Sounds like you're reading from my notes here because that was my next question. Capacity expansion models such as Strategist, which PNM used back in 2013, or Encompass like it uses today, those models take into consideration fuel prices and the availability of other resources, model unit dispatch, and they arrive at a cost for a portfolio. They could arrive at a cost for a portfolio with and without Four Corners that reflected those factors, correct?
That's the type of refinement that type of modeling brings. Yes, that's correct.
Okay. But your damage analysis spreadsheet does not consider the interaction of fuel prices and dispatch or any of the other resources available to PNM during the study period, correct?
Yes, I guess another way of saying that is, again, it's a replacement in kind analysis that says if you took what you were going to get from the coal plant as now understood, because that we do have modeling for, and you replaced it with what you could have gotten from a gas plant, what would your difference have been? And you're correct, there are adjustments that would be likely made if you actually did have that gas plant to the way you're going to operate it and so on. And that's an analysis we didn't do, nor would we have had time to do, I think.
Thank you. And earlier this morning, discussing with Commissioner Ellison, you said it was a horse race at this point between Four Corners and the hypothetical gas replacement turning on gas prices. Do you recall?
Sure, I don't think it meant turning only on gas prices, but the net effect of various changes showed that it was not a large present value of difference one way or the other as to which plant you chose.
But gas prices are very material to that.
Sure, yeah, I totally agree with that.
And you'd agree that today in the real world, PNM has an opportunity to buy cheap solar and wind energy to offset gas and to mitigate higher gas prices?
Well, sure, in principle, that can be done. In fact, the cost of replacement or of renewable resources also changes. And I think, in fact, the market is a little tight right now. So they're actually more expensive than they would have been a while back. But sure, in principle, they could buy them and get rid of gas, which, might have been what they would choose to do. If they had the gas plant now, they might still be saying, you know what, that wasn't as good as we had hoped either. We'd like to get out of it and move to something even cleaner.
Well, they wouldn't have to get out of it. They could still have it around for capacity, and they could have added wind and solar for cheap energy, correct?
Yeah, they might not abandon it. I agree with that. And in fact, that's the way I treat it in the tail of my remedy analysis from 2031 to 2036.
And I don't know if you know this, but if you do, isn't that what PNM has been doing? They've been adding solar and renewables at a pretty good clip over the last 5 years or more.
Sure, I think they're aggressively chasing their own decarbonization goals that are a little bit faster or stronger than the ETA requirements.
Okay.
And they've added or will be adding several hundred megawatts of renewables and storage.
But they're also acting prudently to bring on low-cost energy and insulate themselves from some natural gas price risks too, aren't they?
Yeah, well, I would hate to overextend my assessment of all the work they've done lately, but I assume they're being careful and that but as I say, I've not been advising them on resource planning recently, so I can't vouch for it, but it's a thing that lots of utilities are doing, and they seem to be active in pursuing it.
Right. The flexibility we've been discussing to dispatch or not dispatch natural gas combined cycle to substitute other resources, that doesn't exist with the Four Corners option, does it, when the coal supply contract requires PNM to make minimum purchases?
Well, the minimum purchases aren't for the maximum output of the plant. I forget what the threshold is, but it's they certainly can and do operate in the more variable portions of the CSA contract. So some of it has different prices at different levels of utilization.
But it has a floor.
Yes.
Okay. In pre-file testimony responding to Dr. Fisher in case 21-0017, you stated, I'm going to quote, "I do agree that an adjustment is needed to put the total capacity of the two plans on a more equal footing through either some kind of cost reduction in the 2017 combined cycle plan or an avoided future capacity credit given to it." Do you recall that testimony?
Yes.
Okay. When you made your new remedies or damages analysis in the current case, did you make any adjustment for the capacity difference between the proxy plant and the 252 megawatt plant?
I think you misworded that, but I did not adjust for the differences in installed or UCAP capacity in the two alternative worlds. So the answer is no, I didn't adjust it.
Okay.
Did you say UCAP?
UCAP, yeah, that is an acronym, UCAP, for the value of capacity once it's derated for the likely outage and weather-related limitations on its performance.
Okay.
Thank you.
And I think you can help me there a bit. So it's really the difference between the 200 megawatts of Four Corners and the 250 megawatts of the replacement gas plant. There's a value to that extra 50 megawatts of capacity at PNM, correct?
Yes, that's right. But again, if you were being formal about it, you would do it in UCAP terms rather than so-called ICAP terms, which is installed capacity. So it wouldn't be 252 minus 200. It would be more like 200 minus 160, because once you derate the two plants, or 210 minus 160, it wouldn't be exactly 252 minus 200.
But so you recognize that that was an adjustment that should have been made, or but you didn't do it when you replicated your analysis this time.
That's right.
Okay. In your direct testimony at page 54, you state that Four Corners is not a bad plant per se, citing the decision of other owners, including Tucson Electric and APS, to stay in the plant in 2013, and that they continue to be committed to Four Corners. You see that?
Okay, I see it around line 12 through 14.
Okay.
Mhm.
Did you make a review of the decision-making process and quantitative analysis that Tucson Electric used in deciding to continue its participation?
Not closely. I scanned it, but I haven't studied it at
Okay.
the level of reaffirming it.
Okay. And then you cite in the footnote a 2019 APS study. Did you look at APS's contemporaneous analysis?
Same thing, I'm aware of it, but I didn't study, source documents and things like that.
Okay. Are you aware that the coal supply contract for Four Corners has provisions that would permit the owners, when acting unanimously, to retire the plant before 2031 with relatively modest penalties, but that if they are not unanimous, a utility that wanted to exit early would be subject to paying the full cost of their remaining coal share through 2031?
I don't recall whether I explicitly saw that or not. I accepted it's the situation. I just don't recall seeing it.
Okay. If that was true, wouldn't that be a reason why the minority owners might stay the course, even if it was a per se bad plant, so long as APS remained committed to Four Corners?
Well, there's sort of two ways of saying that, which have the same consequence, but quite a bit different connotation. You could say they would do that to avoid being stuck with those costs. The other way of saying it is, if they chose to leave, they would still bear those costs. So the costs of an alternative are higher because they can't avoid those ongoing CSA costs. So it actually makes the next best alternative look worse if they're stuck with it. So it's not the same as saying they would just prefer to stick to it because they already have those costs.
No, I think you're agreeing with me that when there are penalty provisions in the contract, the fact that they're staying with it reflects more than the basic economics of the plant. You would agree with that?
Sure, when you switch to something else, you have to pay all the exit fees, and that makes switching less appealing. And that should be included in an evaluation of such decisions.
Okay. Doesn't the fact that PNM found material savings from abandoning and replacing Four Corners in its 2021 analysis indicate that Four Corners is a demonstrably uneconomic resource for PNM?
No, I don't think I can reach that conclusion. In 2021, they had an alternative to which they could compare it. And it did look better to get out of it at that point. Lacking that, it's not clear there's a better alternative.
Right. And that wasn't to rephrase my question, doesn't it indicate that for P&M, absent the penalties for an exit, an early exit, without having an exit plan or a buyer, Four Corners is not an economic resource?
I'm leery of making that generalization. You would need to do an analysis that just looked at the to-go costs of Four Corners as though you had no transaction fees for adjusting from it. That's a strong assumption. And then see if that compared to replacement was something new. I haven't seen that or done that analysis. So I can't confirm or support your conclusion.
But P&M did an analysis like that in 2021. They found there was savings.
But they had an alternative which did allow them to mitigate some of the exit fees.
And I think you just said that's the hypothetical we're looking at. Without those exit fees or with less exit fees put aside, just looking at the ongoing costs, Four Corners is not the most economic resource for P&M. Don't you agree?
Well, that was a 2021 analysis, and I assume you're asking about today, and I don't know that answer is still true, or would it be reproduced if today? And B, it's a hypothetical that doesn't arise. There are exit fees, and so it's not useful to say what would it be like if Four Corners was emancipated from all the architecture that it takes for it to operate, and then we could just enjoy it as a marginal resource with no strings attached. That isn't the world we're in, so it's not a very interesting question.
Are you aware that P&M was unable to find a buyer for its share in Four Corners in 2020 other than the owner of the coal mine?
That's my understanding, that there haven't been.
I'm sorry, sir, you're breaking up. Could you answer again, please?
That's my understanding, that there have not been interested alternative buyers.
Okay. Is that an indication that it's not a attractive plant? Economically attractive?
No, it more likely an indication that other people are configured with assets they're already happy with. I mean, you wouldn't go buy a shirt that was on sale if you already had plenty of shirts. Doesn't mean there's anything wrong with the shirt, but you just don't need one. And the market isn't that large because a utility or a power manager in, let's say, St. Louis can't really use it very well because it can't reach their service territory. So there's only a handful of people and they're configured the way they like to be. Doesn't prove there's anything wrong with it for P&M.
Thank you, Mr. Graves. Appreciate your answers, and that would conclude my cross-examination.
Okay, nice job.
Thank you. Thank you very much, Mr. Marks. Let me read something into the record so for future reference. I know the Zoom video conferencing platform is not a perfect device, although it works quite efficiently for our hearings. However, sometimes problems arise. So in one of the orders that was incorporated and made part of the pre-hearing order, the hearing examiners say, in addition, to avoid or limit problems with audio echo feedback or other excessive ambient noise during the hearing, each party shall ensure that its active participants are using a single audio source, and in the event of a problem caused by their setup or environment, have available a suitable headset or earbuds with a microphone. It goes on to say, in other words, a party's unfamiliarity with the Zoom video conferencing technology will not be permitted to delay or otherwise interfere with the proceeding. That's the order on Zoom exhibit and witness protocols issued August 16, 2023. It was incorporated by reference expressly into the pre-hearing order issued in this case on September 4, 2023. All right, moving right along. Who is up next? We have Ms. Nanazi, right? Is that
Yes,
correct?
sir. Yes, sir.
And you have 84 minutes by my count. Is that correct?
It is, but I would like to move 14 minutes of my time to Mr. Watson. So only have 70 minutes.
34 with Watson, 70 with Mr. Graves, correct?
Correct. And I might make you happy by not even having that much, but so that's the plan.
Well, please use all the time you're allotted.
Thank you very much, sir.
With Mr. Graves. I'm going to restart it at 70 now, 70.
Thank you.
Go ahead.
Mr. Graves, do you have New Energy Economy Exhibit 8, the one that I filed yesterday via email because there was an objection by an anticipated objection by PNM. So we have a New Energy Economy Exhibit 8. Do you have that before you?
Just getting it now. Thank you. Give me 1 minute. Okay.
And if you could open that and go to the question, the interrogatory that New Energy Economy asked, and it is NE 5-1. And then the other one that's also included in this exhibit is NE 5-3. Do you see that?
I do. I have a redacted answer to 5-1, so I don't see any text there, but I do have text on 5-3.
Well, actually, that was the redacted portion is to NE 5-2. There is a portion there that you answered. And actually, basically what it does is.
Oh, it says C5. Yeah, you're right. I'm sorry.
It refers to 5-3. And so you gave the answer, the sworn answer to 5-3. Is that correct? Along with some other PNM witnesses.
Yes, it's co-sponsored, right?
Okay, thank you. Now, what I wanted to talk to you about was in 2117, regarding the prudence of PNM's past investment at Four Corners, you provided testimony, correct?
In 21, I did not.
2117, 21000.
2100, yes, okay.
17-UT.
Correct.
And the Brattle, PNM paid the Brattle Group a total of $438,769 for your testimony. Is that correct?
That sounds right.
As of July 31st, PNM has paid Brattle Group $144,245 for your testimony and expects that you will be paid up to at least $400,000. Is that also correct?
Yeah, I have no reason to dispute it. I don't have a forecast of our total billings, so I don't know if the 400,000 is a good number or not, but there is allowance for more costs than had been incurred by July.
And up till $400,000 that at least PNM and you told New Energy Economy in answers to interrogatories. Is that correct?
Right. I'm just saying that wasn't a forecast of our costs. That's the contractual headroom we've agreed to.
Is it your testimony that long-standing and economically well-justified principles and standards in the utility industry strongly indicate that prudent investments should be fully recoverable from customers, even if they eventually prove less economic than when originally intended?
Sure, I endorse that view.
And is the converse also true, sir? That if a utility imprudently invests in assets, that ratepayers should be held harmless for the imprudent acts of utility management?
Sure, but with a caveat that that should be done in relation to the size of the imprudence, not the sheer outcome. So if a decision is made and it was not as good as something else, it's the differences in the quality of the decisions, not the absolute cost of the decision that matters.
And with Mr. Harris, you agreed that in order to make that calculation, there should be an evaluation of other evidence that has come to light. Isn't that right?
Well, I think we were referring then to what I've dubbed a harm or remedy analysis in this, which is a little different than establishing the prudence. So when the remedy analysis is pursued long after the decision, yeah, I think you have to use intervening information to
Okay, well, thank
ascertain
you.
what happened.
Thank you. I'll circle up with that in a few minutes, but
Okay.
thank you for that answer. You agree that PNM's May 2012 analysis was the only strategist analysis that was performed before PNM committed to renew its participation in the Four Corners Power Plant in December 2013, correct?
Yes, that's my understanding.
And the strategist analysis, the May 2012 strategist analysis PNM performed at the time found a $33 million benefit from its decision to remain a participant in Four Corners over a 20-year period, correct?
That's my understanding.
You acknowledge that PNM did not include the cost of increasing capital expenditures needed at the plant for environmental, regulatory, safety, and performance and reliable requirements to keep the plant operational. Is that also true?
Sure. I didn't have a list of specific expenditures that should have been included for those purposes, but the reason ongoing capital expenditures are made, is for fostering of those miscellaneous goals. So to that extent, they didn't include those needs.
When you say miscellaneous, you don't mean to minimize that. You understand that those are requirements: environmental, regulatory, safety, performance, reliability. Those are standard industry goals and requirements for operations of their plants, right?
Oh, of course. And they wasn't as if they were implying that or expecting they wouldn't have to do so. They just didn't think it would be differential across the alternatives, so they didn't do it.
We will also get to that later.
Okay.
The strategist analysis did not include the cost of increased decommissioning costs either, did it?
Right. That's an out of, that would be intrinsically difficult for strategists to include. That's an out of strategist calculation.
And they didn't do a supplement to that strategist analysis, did they?
Not that I'm aware of.
Even though you argue that Southern California Edison, also known as SCE, and El Paso Electric, also known as EPE are different utilities, which of course they are. You do acknowledge that the decisions by SCE and EPE to exit Four Corners should have prompted PNM to re-examine its decision in 2013 to extend its participation at Four Corners.
Are you talking about decommissioning recognition now, or just saying they should have reevaluated because SCE and EPE did?
Correct.
Well, I don't recall saying it quite that way or in the past, but I would say this: if the changes in ownership changed their responsibilities for the plant, then yes, that would trigger a need to reevaluate whether you still liked it. If it's independent, then it's like, well, they decided what they like and we decided what we like. You can, so I don't, it depends on how interactive their responsibilities are with the ownership decisions of the other parties.
But you acknowledge, sir, I mean, in cross-examination with Mr. Elliott, that coal was embattled during that 2012, 2013, 2014 period, including the fact that back in 1918, when I cross-examined you, you admitted to me that you helped certain utilities exit at that time, during that same time period. Isn't that right?
Sure, I agree with that. There was a stress time for coal resources, and it has remained. Coal resources are still under, and now gas plants are under some tough pressure as well.
Do you agree or disagree with this statement? We observe that there is a meaningful relationship from the perspective of the ratepayers between the consideration of alternatives and the cost of the chosen generation resource.
Sorry, I got a little lost in that. Could you read that again to me, just so I'm responding to the right thing?
Sure. We observe that there is a meaningful relationship from the perspective of the ratepayers between the consideration of alternatives and the cost of the chosen generation resource.
Well, it's a sort of an awkward statement. I hope it's not attributed to me, but it's, I think it's almost tautological. It's saying that the cost of things that are being evaluated ultimately determines the cost to ratepayers. So that's a relationship for sure.
And tell me if you agree or disagree with this statement. The goal of the consideration of alternatives is, of course, to reasonably protect ratepayers from wasteful expenditure.
Well, that's a minimum condition. The usual concern is not waste, but it's finding the best alternative among several that would be functionally fine, but maybe not the least cost or maybe not the least risk for whatever your criteria for an attractive decision was. So it's not about saying, well, we got to trim the waste out of decision A. Is decision A versus decision B more cost effective and more tolerable from a risk perspective?
The failure to consider alternatives, is that a fundamental flaw in a decision-making process?
I think it has a lot of sensitivity to what you mean by alternatives. There are different types of decisions for which there aren't many alternatives, and maybe those are evaluated narrowly, and there are others where there are lots of alternatives. For instance, to comply with environmental regulations after BART technology has been defined, there aren't usually very many choices. So you don't evaluate dozens of alternative arrangements. If you're making very long-term strategy decisions, then there's lots more room for a bigger menu.
I completely agree with that. And it's also true that the failure to reasonably consider alternatives, whether that's many or few, is a fundamental flaw in decision-making.
Well, sure. Again, somewhat true by the way you've posed the sentence. If it's a failure to consider them, then that is a flaw. If they're understood to not matter, then it's not a flaw. So it's, but by hypothesis, it's a flaw.
I'm sorry, did you want to say anything?
No,
else?
sorry. I was just clarifying that. I think it's embedded in your question is that it is a flaw. So I agree with you.
Those were statements all from the New Mexico Supreme Court, just so you know.
Okay.
If the hearing examiners and the commission find that that PNM's failure to demonstrate that it reasonably examined alternative courses of action was imprudent, then would you agree the issue at hand is what remedy should there be?
Sure, that's very true. And it gets back to whether a resulting consequence was a decision with a bad outcome or a decision that was an acceptable outcome and you might have made that decision anyway, but you don't like the way it was made, in which case you're penalizing the decision process, not the decision outcome. And they could be very, very different.
You provided a remedy analysis via a spreadsheet, updating the key assumptions in PNM's May 2012 strategist analysis. And your ultimate conclusion is that overall, PNM's decision preferring to stay with Four Corners in late 2013 resulted in a $5.5 million benefit for customers, correct?
In $2012, yes, that's right.
Your analysis never considered any other resources besides a combined cycle gas plant. Is that also true?
That is completely true. And I guess I'm not uncomfortable with that because if you don't specify what the alternative is, we can't do a harm analysis or a prudence analysis. And
or a prudence analysis.
Or a prudence analysis, right? There's no basis for, as I mentioned earlier, saying that something imprudent was done or that harm occurred if we don't know what the but-for alternative is. So we have to have something. And the only one that was ever evaluated was that surfaced in the system planning models was this 252 megawatt alternative gas plant. So that's why I evaluated that one.
But that was in May 2012, right?
Right, but no one has since provided any demonstration that anything else should have been considered. That's the only thing that's been in the list.
Well, that's what I want to get into next.
Okay.
Which is, it was true that during the same time period in the fall of 2013, PNM was also concerned with its San Juan generating station abandonment proposal and replacement power plan and the case number is 13-00390 UT. You know that to be true, right?
I am aware of that, yes. Mm-hmm.
You have learned that as PNM was getting ready to file its San Juan generating station abandonment proposal and replacement power plan in 13-00390 UT, it was running strategist analyses to help provide the justification for its abandonment of San Juan units 1 and 4 and procurement of more coal from exiting California coal co-owners in San Juan units 2 and 3 and procurement of previously excluded unit 3 nuclear at Palo Verde Nuclear Generating Station, correct?
Yes, I'm aware those were on the table. They certainly needed something to replace whatever they lost in San Juan.
The strategist analyses that PNM ran for its abandonment and replacement power plan in 13-00390 UT included wind and solar and market purchases. Is that also true?
I believe so, but I don't recall the details.
Despite that PNM was actively evaluating and ultimately procuring solar and wind in 2014, there wasn't solar or wind in your remedy analysis mix. Is that correct?
Objection, that misstates the facts in 2014.
So it certainly is true. I did not evaluate any alternatives other than the gas plant because I'm trying to determine if the prudence failure was not choosing the gas plant, then that's the harm I want to assess as well. Not could you have done something completely different without any specification of what it was. So, but I didn't, and as a result, I didn't look at any other reconfiguration of the world. Now, the San Juan circumstances, changed how much they needed and when they needed it. So, of course, they were evaluating replacing it.
But at that time, PNM had to abide by the renewable portfolio standard, isn't that right?
Sure.
And did you read Mr. O'Connell's testimony in the 16276 case that said that he would have been considering gas and solar, and that was reflected in his testimony, and it was also reflected in the hearing examiner's certification of stipulation that what was being considered at that time, I believe what they said is gas, solar, and market purchases.
Objection, compound question.
Sustain.
So, but just want to say that your spreadsheet analysis did not include market purchases either, did it?
No, again, I'm comparing the use of the coal to the use of a gas plant and not allowing either alternative to include modified use of either plant under evolving market conditions. So yeah, I don't know whether that would have favored, if I had done that, would that have favored coal more than gas? You bring up, lots of variables at that point. I suspect those are second order to the calculation I've done, but they are a factor that I didn't evaluate.
But they were what was known and knowable both in May 2012 and in December 2013, right?
Well, yes and no. It would have been, you could have had a forecast for what market purchases might have allowed, or the model could have simulated it. As a general rule, it's my understanding that in New Mexico, the utilities are not allowed to rely on market purchases or sales as a boost or basis for choosing their resources, that they have to show what they would own and control is cost effective. And so, and in any event, even if that weren't a restriction, essentially no utility would say, I'm going to rely on market purchases indefinitely here just because they look pretty good. So that might have been a bridge, and it might have adjusted the utilization factors a little bit on the various resources, but it wouldn't really change the question of whether you're evaluating a coal plant versus a gas plant.
But solar and wind might have, wouldn't it? Especially if your calculation is $6 million difference. You know how cheap wind is and how cheap solar is, even then.
Yes, that's true. But as you know, they don't perform the same way as a coal or a gas plant, since you only get them when the sun's shining and the wind's blowing. And they also dilute their own value the more of them you have, because they crowd each other out. And so their load carrying capability goes way down, and your system support services requirements go way up. So even if the cost per megawatt hour of a solar resource is cheaper when it's running than the to-go cost of another fossil unit, doesn't mean it's cheaper on average.
But we don't really we just have no idea because that wasn't done at the time and it wasn't done even now with your, post hoc analysis, right? We just don't know.
Yeah, I guess that's fair. That analysis has not been done.
So you said that Mr. Elliott, when he asked you questions, that you were hired somewhere between 6 and 9 months before you gave testimony in the 21-00017 UT case, correct?
I think that's right.
So when you were given this case to review, did you ask P&M to run a strategist run using the known and knowable inputs that P&M was using in its strategist analysis that it was running in 2013?
Let me object. I think the question is confusing. It's not clear whether the question relates to the 21-0017 case or the present case.
Could you clarify, please, Mr. Nasi?
It doesn't matter. It doesn't matter. I'm just asking him, did you ask P&M to run a strategist run at that time? So that would have been 6 or 9 months in. So that would have been either like the spring or summer of 2020 when he was reviewing the case. Did you ask P&M to run a strategist run using the known and knowable inputs that P&M was using in its strategist analysis that it was running in 2013?
Overruled.
Okay, so the answer is no in both cases. I did not ask for a alternative that would have been based on other runs from that time. Again, I had taken as a premise that the complaint here is that the decisions that surrounded committing to the CSA and the life extension of the plant and renegotiation were also the ones that were being used to define whether there was a prudent decision or not. And so that's why I use the reference points of the gas plant and the coal plant. If there's no reference point and just says maybe there could have been something else, then of course that's, I suppose, always true. We just don't have it. So it's not possible to compare. And I don't know that it would have been comparable to use the strategist runs of the 2013 if they weren't posed in the context of saying, let's get rid of Four Corners and see what the model chooses after that.
But we did know the inputs that they were using at that time because P&M was was running strategist runs for its San Juan plant. We know that, right? So we have those inputs, correct?
Yeah, well, I don't have them, but yes, they exist, I'm sure.
And so we would know, for instance, the gas forecasting that they used at that time, right?
It's presumably in the record for that decision. Mm-hmm.
Okay, and so if our complaint, one of the major ones, but if one of the major ones is that the May 2012 strategist did not use capital expenditures, did not incorporate capital expenditures, they could have used the inputs from that were known and knowable from 2013 at the time of decision making and added capital expenditures or any other things that could have been adjusted. Is that right? And explained.
Yeah, I think that's what my report actually demonstrates, is those were knowable things. And had they been added, it would have altered the numbers, but perhaps not reversed the decision.
Mr. Nazi,
Yes,
you're
sir.
running really strong, but the rest of us are kind of lagging a little bit. Would you mind taking the lunch break now? I'm pausing you
Thank you,
at
sir.
12:10. Is that okay with you?
Yes, sir.
Mr.
Thank you.
Graves?
That would be
Graves, does that
welcome.
work for you?
I'm getting hungry, so that would be good.
Okay. All right. We'll be back. 10 after 1, we will start again. We are in recess for the lunch. Have a good lunch, everyone. Thank you.
Thank you.
Thank you.
them since we're on break. Mr. Aldebeatros, I was just curious where you're putting the transcripts. Did you hear me? No.
I can hear you, Kelly.
I'll ask when we get done with Mr. Graves, I guess.
Thank you.
Good afternoon, everyone. Can you hear me okay? Great. We're back from our afternoon, we're back from our lunch break. And before we continue with the cross-examination of Mr. Graves, I'd like to go over a couple of things very quickly that I departed from to allow Commissioner Ellison to do his examination of Mr. Graves. And that is, I'd like to follow up to point out that in EE Exhibit 13, that Ms. Nanazi indicated that she had emailed to this yesterday or today. That has been fixed and uploaded to Dropbox, as well as the NEE Exhibit 8. Moreover, now in the administrative notice folder for the issue of prudence matter in Dropbox, I've uploaded Commission Administrative Notice Exhibit 76. That's my examination by my examination or colloquy with Mr. Graves back in 2017 in case number 21-00017-UT. You'll see that it's redacted to include only my examination of Mr. Graves in that case. I will, after PNM has had it and the parties have had an opportunity to review it, I will request the parties' positions on that before the end of the day. Same for fixing the Ortiz stipulation testimony. That's PNM Exhibit 7, the June 16, 2017 testimony. I added the pages that PNM had designated for administrative notice. Cross-reference that to Commission Administrative Notice Exhibit 55 on the list. And that list, of course, is the one set forth in the order establishing format for Commission Administrative Notice exhibits. Moreover, and the same purpose, that Commission AN Exhibit 61, that's the Olson direct testimony, as New Energy Economy requested. I added page 1 and parts of pages 62 through 66. I retracted a little bit of it, but 62 through 66, the relevant portions are in there. Although I would note, curiously, in Ms. Nanazi, and I went back and looked at the joint request, and you had requested pages 64 and 65, and then now, more recently, you asked for 62 through 66. So I just wanted to point that out for the record that I didn't miss something there. So I've been more over inclusive than your original request. Let's put it that way. So all those things now are taken care of in Dropbox, hopefully. And I will come around particularly to confirm that all those things are accurate later on in the day. And with that long-winded side route conversation, let's get back to the exercise at hand, and that is the cross-examination of Mr. Graves by Ms. Nanazi. Ms. Nanazi, good afternoon. Are you ready to go?
Yes, sir. Thank you very much.
Thank you. Please proceed.
Good afternoon, Mr. Graves. In your sworn testimony in 21-00017 UT, I asked you, this is not a debate about the thoroughness of P&M's analysis. It's a debate about whether the analysis was an honest evaluation and if it was performed on in a contemporaneous period. And you testified regarding P&M, you answered, and you testified regarding P&M's Four Corners analysis that it was, quote, incomplete compared to normal analyses. Is that still your testimony today?
Excuse me, Mr. Hearing Examiner, may we see the document from which Ms. Nanazi is reading?
Could you please at least reference it, Ms. Nanazi?
It's the transcript of proceedings for 21-00017 UT. I could send it to you, but if he doesn't recall it, or I don't know what that objection is, but.
Well, could you at least reference the page number, if not the pinpoint citation?
Sure.
Can the document be shared on the screen?
No, it doesn't need to be shared on the screen. That
it is page 1197 of PRC hearing day, September 7th, 2021, in case 21-00017 UT. And the exact answer was, well, those are certainly allegations that couple with the observation that the analysis was incomplete compared to normal analyses, and that they may have been reflected in the views of interveners to a bias or indifference. I could continue on, but
yes,
rather not.
please do. I'd like to, we're entitled to see what you're referring to.
you're also entitled to pull it up. What you should have.
Well, we weren't.
The witness is not necessarily entitled to see what he said before, because earlier he forgot that he had described P&M's process as a bad process.
Well,
so he doesn't necessarily need to see on screen what he said before. He can be cross-examined about what he said before,
and we're
to see if it's. Wait.
I will.
Thank you. To see whether, because he provided testimony in the past case and now this one, to see whether his testimony completely syncs up.
Your Honor, okay. Let me know when I may speak.
I will. In an ordinary hearing, would we put the transcript in a cross-examination on some big screen for the witness to see?
I've seen it done many times.
Do I have to? Are you?
We do need to. We are entitled to see what it is she is reading from, so that we can verify what we're talking about. You know, her first question did not accurately state the exact testimony or the complete testimony, and it still has
That's why I asked her to go to the testimony.
and still hasn't provided the full answer.
Well, okay, let's make sure we're working off the same sheet of music. Okay. Obviously part of that transcript is now in the record for administrative notice, only my examination, but that's later on on that day. So going to case number, let's all go there. Mrs. Nazi, could you point out again where we are in that transcript, please?
21-00017 UT, page 1197, September 7th, 2021.
And that's day, that's September 7th.
Correct, it was day 5. I don't believe that I need to read everything that Mr.
No, but
Graves
you do need to be accurate. Mr. Alvidrez is absolutely correct. You need to be precisely accurate.
I think I was precisely accurate when I said quote, and then I did.
Go ahead. 1197, what line?
5. So, Mr. Graves, did you testify regarding PNM's Four Corners analysis that it was, quote, incomplete compared to normal analyses, unquote?
I object. That completely mischaracterizes what he testified to. I now have the transcript in front of me. And this is a flat accusation.
Okay, why?
Because it says, well, those are certainly the allegations that couple with the observation that the analysis was incomplete. So he's talking about allegations, not his statement, not his testimony as Ms. Nanasi is characterizing it.
Mr. Hearing Examiner, I believe this could be redirect if he wants to me, but I don't think
but
that
he's actually right, Ms. Nanazi. Sustain. Sustain. Be careful. Be very careful. Please, we don't need to go backwards in time to earlier problems. All right. We've done well. Let's stay on a good course. Do not do that again, please. Thank you, Mr. Alvidrez. I frankly, never mind. Go ahead.
Mr. Graves, do you believe that the analysis that PNM conducted was poorly done and presented?
You're talking about May 12th specifically, or what?
Both, yes, May 12th, and also how it was presented by PNM to the hearing examiners in the rate case that we're talking about, 16-276, 16-00276.
Objection compound.
Sustain.
Sir, do you believe that the analysis that PNM performed was done poorly?
No, I think the analysis they did was done perfectly well. I don't think it was all the analysis that would have been helpful.
Do you endorse the rigor of the analysis that was done between May 2012 and the end of 2013?
I'm not familiar with any incremental analysis done in that period, so I can't speak to imaginary rigor or rigor of an imaginary analysis. I'm not aware of any that was done.
But aren't you doing an imaginary analysis yourself?
Well, if she's asking about my analysis that describes what could have occurred in that time, I feel pretty good about the rigor of that. But
it's still imaginary, isn't it?
Well, it's retrospective, but it's the type of thing.
I know. You're very good with words, Mr. Graves, and I'll come back to some of them, like lamented, about the hearing examiners lamented.
Okay.
Okay, so you're very good with words, but imaginary would fit that hypothetical analysis as well as your counterfactual, wouldn't it? Imaginary.
Well, I guess
Let's, if we're parsing words, you're very good with them. I don't like it thrown around for one derogatory way, and then you say yours is perfect or yours is right? There, if it's imaginary, it's imaginary.
Well, I don't know what it means to be imaginary. Mine is completely.
It's your word.
It's well
It's
documented.
your word. It's your word. You said imaginary, didn't you?
No, she asked me if it was imaginary. Or
We have
never
real
said-
time.
Oh, I'm sorry. What I'm saying is what would have been imaginary is a putative analysis that PNM did between May 2012 and later. There was no such analysis. So of course I can't, but I didn't mean my analysis was imaginary. I'm
Right.
wondering what she's referring to when she says, how good was the rigor of their analysis between May 2012 and December 2013?
Well, just to be clear, we have real time, so we have recorded what everybody is saying, and unfortunately, including me. So, go ahead, Ms. Nanazi.
At the critical time in 2013, there was declining performance of the plant that could impact availability and cost, and that the decline in maintenance expenditures would have to be remedied. Is that correct?
I believe I have an exhibit that shows there was a declining availability of the plant. It wasn't way below industry averages, but it had been sliding a bit. And, if that goes on too long and it's because of low investment, then you have to catch up.
At the critical time in 2013, coal, oh no, strike that. I already asked you that. You are aware that in 2017, New Energy Economy did ask PNM to run a strategist analysis that included Four Corners Power Plant and capital expenditures, and one that forced Four Corners Power Plant out, but included capital expenditures, correct?
Yes, I recall that.
It showed a $445 million benefit to ratepayers of exiting Four Corners Power Plant.
I believe that's true. I addressed this in the 21017 case, that I felt that was an improperly structured analysis, but I don't remember all the details. We could look back at my testimony and find it.
But you didn't testify about that in this case, did you?
No, I think that only came up in 21017. As I say, I didn't think it was a good analysis, so I didn't think it was informative to this case either.
You testified in 2021, and it is your testimony today, I believe, that climate change is real and that burning of fossil fuels, particularly coal, is a major contributor to the climate crisis we are experiencing.
Undeniable, sure. Or I certainly don't question it. Some do, but not me.
You understand today that PNM knew in December 2013 that Four Corners might close if no other co-owner agreed to buy El Paso Electric's exiting shares, correct?
I think that was a possibility. I don't remember studying that closely, but I believe that's right.
So the magnitude of PNM's decision regarding continued participation in and reinvestment in the plant not only impacted PNM ratepayers, but kept the Four Corners Power Plant open.
Objection, speculation.
Sustained.
Your Honor, can I follow up on that then?
You can ask a different question or a rephrased question, of course.
Sir, could you please go to administrative notice, document 14, and let me know when you're there, please.
And what document is that?
It was at the time New Energy Economy Exhibit 6.
Thank you. And who, could you, go ahead.
This is, I will just say for the record that this is a series of pages, including the first page, what is on the first PDF page, it's page 3 and 4 of P&M's response to the July 25th, 2017 bench request. Then it is a P&M document entitled P&M Exhibit 7-25 bench request -6, which is 2 pages. Then it's the continuation of that, page 3, 4, and 5 of that document. And then the thing that I would like to focus your attention on.
Sorry, can I just interrupt here? I'm not seeing a document that mirrors what you just described. What I have for NEE Exhibit 6 is interrogatory NEE 4-27.
That we're looking at a different folder. Do you have it, your attorney nearby? We're in the administrative notice folder for case number 16-00276.
Oh, I see, for a different case, yeah. So
Yes, sir.
Thank you. Sorry about that. I'm in the
That is now a piece of evidence in this case, pursuant to commission instruction back in January 2018, to eventually include the record, the administrative notice, taking administrative notice on the issue of prudence in P&M's next rate case, which happens to be this case, not 2117 where you testified.
Okay, we're looking here. I'm not sure if we're succeeding or not. Do you?
If you have the Dropbox exchange, the exhibit, excuse me, it was an email that predated that. It was shared by Dropbox, all of the administrative notice for the Four Corners Power Plant. There'll be a whole bunch of documents that went out to all the parties. And then there should be something there called NEE Exhibit 6, P&M response to July 25th, 2017 bench request. That's that correct, Ms. Nanathi? That's the one?
Yes, sir. Yes, sir.
And
I'm sorry, was it P&M response to July 25th? Did you say? Is that what it was?
Yes.
Okay, we do see.
And that's commission administrative notice exhibit 14.
Okay,
and
it's a response to Mr. Ortiz.
Right.
Yes.
So while you're looking that over,
Mm-hmm.
I'm going to ask the parties' indulgence about whether they would mind if I go in so that we're synced up on this. Go into the Dropbox folder for administrative notice and number all of those exhibits there 1 to 76. Would you mind if I do that? If I go, I'll try not to mess it up. I know we're skipping one number, so we have actually 75, which is where I wanted to end up anyway.
I don't know if it's a good idea, but what we could do, Anthony, and you tell me, I'm just thinking on the fly here, is leave the original title in like parentheses and have the AN as the leading. I mean, I don't know if that's useful or not, or do you just want to kill it and go? I'll label them AN1 through AN76, skipping the one that I skipped. Would that be okay with the parties? Does that make sense? So that we're not flipping back and forth?
I think that would be very helpful.
Thank you. Okay, sure. I'll do that. I'll do that at some point.
Sir, I don't.
What?
I'm trying to instruct the witness.
Go ahead. You start.
Sir, I don't need you to read the whole document because that pertains to lots of other. I'm just trying to instruct you to look at one portion of actually the second to last page of the PDF, which is page 8. And it is the third paragraph. And just as a means of explaining what this is an email from the Senior Vice President and General Counsel, Patrick Apodaca, on Wednesday, December 18th, 2013, the year. And it's to the P&M board at the time, as well as CCing it to the P&M senior management. And the subject is called Four Corners -- privileged and confidential A/C communication. Are we on the same page, Mr. Graves?
I believe so, right? It's a memo, dear board members during the December board, et cetera.
Okay.
Yes. Okay.
Yeah, so could you actually read that first paragraph, and then could you then read the third paragraph?
Sure. So the first paragraph reads, during the December board meeting, we briefed you on an emerging issue concerning the continuation of Four Corners Units 4 and 5 plant operations beyond July 2016. When the current lease, coal supply agreement, and participation agreements expire. This will update our meeting report.
And then
So
could you read
that's for
the
sure.
third, thank you. Could you please read the third paragraph?
Yes. After El Paso's announcement, APS took the position that two options are available for units 4 and 5. : 1, either a third party, possibly an arm of the Navajo Nation, or the remaining owners must purchase El Paso's 7% interest, or 2, units 4 and 5 must be shut down by 2016 with decommissioning activities to begin as early as next year. APS also viewed coming to a decision by the end of the year as critical in order to be able to close its purchase of SCE's interest.
And then could you read in the next paragraph, the sentence that begins with although? It's like near towards the end.
Yep, I see it about 5 lines from the end, right? Okay. This says, quote, although documents will need to be finalized to execute on APS's acquisition of all the El Paso megawatts, APS believes it can finalize this transaction next year and still close on the SCE purchase on December 30th of this year. We believe this is a positive outcome for PNM. Among other things, maintaining our same level of ownership at Four Corners avoids a possible distraction with our BART filing with the PRC next week and our negotiations with the owners at SJGS, which is San Juan.
Did you happen to notice that that last sentence that you just read was repeated twice in both the hearing examiner's certification of stipulation in 16-2-00276 UT and also twice in the final order of the commission in that same case?
And I certainly remember seeing it in more than one place and perhaps multiple times. I couldn't have given you the head count.
Okay, thank you. Now, may I ask that question again, Mr. Medeiros? And the question was, so the magnitude of PNM's decision regarding continued participation in and reinvestment in the plant not only impacted PNM ratepayers, but kept the Four Corners power plant open.
Objections, speculation again. This doesn't address PNM's participation.
Overruled.
Well, I can only extrapolate from the letter or from the memo, which seems to say the whole plant had to be co-owned by somebody, or else they were going to shut down the last 2 units. So PNM was one of those parties, but it's not at all clear that there were the only way it could be done, but that's true. They were an owner.
And it was also clear that from that letter, though, that El Paso's exit was potentially already going to close that plant. Is that correct?
I think they're equivalent in the sense that anybody's defection required somebody else to pick up the rest or a new owner to be found. And of course, that's what happened. So again, it's not the case that leaving per se shuts down the plant, but it does require changes of ownership.
if P&M's reasoning for its continuation and further investment in the Four Corners plant was for its own business interests at San Juan and had nothing to do with any benefit for ratepayers, you would agree with me, would you not, that that would be unlawful and imprudent?
Well, for one, I don't know that that's true, and I don't know that if it was done for that reason, it still would have meant that there was a problem at Four Corners. So, or would have proven whether there was or wasn't. So it seems like a very strong predicate in your question.
But if it was true,
So if it was true that they did Four Corners just to protect their interest in San Juan, somehow, not obvious to me how that would have happened. And that otherwise it was a bad idea to have Four Corners, then sure, that would be bad for customers and it would be bad for regulatory approvals. But that's I have no evidence to the effect of any of those assumptions.
if the evidence demonstrate P&M's imprudence and there is an imprudent finding, we are back to the question of harm. You agree that if there is an imprudence finding, the disallowance should equal the amount of unreasonable investment. Is that correct?
Normally, that's the case because usually a prudence finding occurs shortly after the decision is made. And if it's been made badly, then the harm is the size of the error, and that should be the correction. In this case, we have a very long lag, and so I've suggested that it's actually better to consider whether that upfront correction would actually overcorrect or miscorrect the actual harm that has been done, if any.
You seem to be concluding in your testimony that P&M should have performed a better analysis, but if we add capital expenditures to both a gas plant and a coal plant, that the costs would be about equal, right?
No, that's, I think, the reason P&M didn't do it is they thought they were comparable, or they assumed that. My chart shows the adjustments I recommend to the May 12th analysis, shows the costs omitted from the coal plant were much larger than the costs omitted for the gas plant, but it wasn't the only adjustment.
But you say ultimately that even if they were, if those were both added in, I think you've used the word tie a couple of times during today's testimony. Is that right?
Yes, but you don't get the tie just by adding those two things, and you need to do the other things as well.
Isn't it a false equivalency that you're asking the hearing examiners and the commission to ignore, like adding capital expenditures and a nicer radio to a 1970s Chevy or AMC Gremlin versus a 6-year-old Tesla?
Objection, argumentative.
Sustained.
Well, aren't you really testifying that there is no harm to ratepayers between being supplied energy from a mixture of a 5 or 6-year-old solar and gas facility compared to a 53-year-old non-performing climate altering coal plant?
Objection, argumentative, and also assumes facts not in evidence.
Sustained.
Have you seen the difference in P&M's actual capital expenditures for its gas and solar plants compared to Four Corners?
You mean since 2017, for instance, or what time frame, or what are you talking about?
Since July 2016.
Well, I haven't made that comparison, but I wouldn't expect them to be comparable. They're repairing or sustaining assets of different character with different engineering, different stresses. So there's no reason to believe that one should mirror the other. And there's really nothing, about your notion that you shouldn't try to keep a 47-year-old coal plant alive if you have the chance to get a 6-year-old Tesla new plant, so to speak. It really matters what their costs are, not how old they are. But coal plants and many plants can live 70, 80 years. That's a fairly common expectation that plants can be sustained for longer than their original lives. And that doing so is a perfectly fine thing to do when it's more economical. So that the age alone doesn't inform whether it was a good or a bad idea.
That's correct. But that's also ignoring, is it not, environmental implications, water implications, other lots of other implications. Isn't that true?
Well, not entirely. The coal plant was, and both plants in my analysis were, and PNMs were penalized, for instance, for CO2, perhaps not at a level that you would agree with, but they had a recognition of that. And they were meant to be in compliance with prevailing air and water quality standards. So there were either controls or NOx and SOx and those kinds of penalties assumed. So yeah, there are environmental consequences, but either their costs or their solutions were embedded in the comparison already.
Somewhat.
There's probably some that aren't included, but at least to the extent they were regulated and there were laws about how to anticipate those problems, they were in there.
You would agree with our Supreme Court that the purpose of a prudence review is to hold ratepayers harmless from any amount imprudently invested, and that a disallowance should equal the amount of the unreasonable investment.
Sure, I'm okay with that. Again, usually that is readily accomplished because the harm occurs at the time the decision is made and it's remedied shortly thereafter. Here again, as I mentioned, there's been depending on how you measure it, a 7 to 11 year lag, and we're still debating what should have been done and what the consequences have been. So I think in this case, a look at a longer time period is more equitable for the parties.
And so that what you're saying there is that it's that we should evaluate other evidence to discern the magnitude of the harm, because quantifying the impact of the utilities' imprudence has been hindered by the very actions that underlie the finding of an inadequate analysis during the decision-making period. Isn't that right?
Objection, it mischaracterizes his testimony.
Can you rephrase it, Mr. Nazi? I'm tired of saying sustain.
Isn't one of the problems here that we don't have the actual, it's hard to quantify the actual harm because we don't have the analysis that should have been done at the time, right?
So if you're alluding to the idea that maybe more analysis would have shown that a different plant other than the gas plant would have been better or preferred, we certainly don't have that analysis. And I can't dismiss that might have happened, but in light of all that was available at the time, and as we can reconstruct, the prevailing concern is that they could have chosen a gas plant and didn't. So if we just say, well, maybe something else would have been better, I don't know. I don't have any basis for saying how much better or how or why or when. Would the benefits have occurred right away, or would they have been in the future? Were they all coming from intangibles like the externalities of carbon pricing that actually nobody in New Mexico ever pays? Those are just flavorization analyses that are put into the analysis to give it a tendency to choose cleaner resources, but they're not costs to customers. So we don't know what that other thing is. And I guess you can imagine there is another thing that should have been better.
Sir, I really have only 9 minutes. I have just a few questions left. So if you could just shorten your answers. Just to that question, that was the law, right? That was the requirement of the commission. So whether you agree with it or not, that the law was that they had to have a carbon price. Isn't that right?
Oh, yeah, no, I agree with that. I'm saying if some other alternative were chosen, we don't know how much of its benefits would inure from that versus from its fuel costs versus its capital costs. We don't know. So we can't really we can't even find that there was imprudence relative to that thing because it's hypothetical.
If PNM omitted capital expenditures and decommissioning costs before it made the December 2013 decision, And we know now what those capital expenditure costs between 2016, July 2016 and December 2022 was. Isn't that one way to calculate the disallowance, is to stop the actual harm that ratepayers are experiencing right now and have been and will be?
Objection compound.
Could you break it down, please, Ms. Nanazi, without me having to say the S word?
Thank you. Okay. If P&M omitted capital expenditures before it made its December 2013 decision,
Okay.
and we now know what the capital expenditures are and have been since July 2016 to December 2022, isn't that one way to calculate the disallowance?
Well, it certainly provides some numbers that you could consider, but the omission of the capital expenditures didn't by itself make the original decision flawed. It changed the relative amount of value it had, but it doesn't prove that it was an imprudent decision. It was a bad process, but the result, which was also assessed in a fairly normal but limited way, was sustained in my view. So you can't just say, well, here's a chunk of what they didn't include and that must have been the harm. I don't accept that.
Okay, but I'm asking you post a prudence determination. Let's say the commission decides P&M was harm. P&M harmed ratepayers.
Okay.
And was imprudent. Okay, so one of the ways that you've decided is I've done this spreadsheet analysis and there is no harm. And so I'm asking you now, since you haven't looked at the capital expenditures that actually took place between July 2016 and December 2022, isn't that one of the ways to protect ratepayers, which is to say, okay, let's take this out of rate base. Let's not charge you any more for capital expenditures and decommissioning. You left that out in your analysis. Let's leave that out going forward from what ratepayers have to pay, even though ratepayers have been paying that.
Whoa.
Okay.
There's a question in there.
Okay, that's the first question.
Objection compound. I didn't hear a question, actually.
I was trying to help with that, unfortunately. I'm sorry, Mr. Alvidrez. Forgive me.
This is a complex issue. And then if I say something too narrow, then it's like, well, you left out all these things. So now I'm trying to be inclusive. And
I'm not gonna say you left out all these things. I'm gonna look at the record, but I'm gonna make sure I come back to something in a minute that I do not want to see in any record ever again. Go ahead.
If there was a imprudent decision already, so that let's just assume that. Is that okay?
I follow you. Yeah. Presumably based on process at this point, just not based on the outcome.
This is the remedy.
Yeah, but the imprudence is based on process. You're saying it was an unacceptable process in your view or in the commission's view, and so it's imprudent. But that's all we've concluded. We don't know what the next best thing would have been.
This is the remedy question.
Okay.
P&M left out capital expenditures, and we now know what the capital expenditures were from July 2016 to December 2022. Isn't one of the ways that the prudence remedy decision is to stop charging ratepayers for capital expenditures?
I think I follow you. So you're saying if this thing was deemed imprudent, then we should quit allowing recovery of the stuff that sustained it and expanded it thereafter. Just don't allow any of that, which I understand your logic. The only problem is there's two things that make that probably too heavy a penalty. One is they do have the plant, so it is performing, and they're getting some benefits from it. And the other is, if they didn't have that and they hadn't spent that, they would be paying for something else. So it's not like it's just, well, if we had quit paying for this, we'd be fine. There's an alternative. And that's why I did the harm analysis to say, well, if that other thing was the gas plant, then it wouldn't have been as big, if any, as much as you just suggested as the disallowance.
In another instance where PNM failed to do a comparative analysis, the hearing examiner found the utility to be imprudent and the asset was removed from rate base. And to your point, if ratepayers are still using that asset, ratepayers must be charged fuel and O&M. What about that remedy analysis?
So what is the adjustment you're proposing when you say they must be charged fuel and O&M? That you mean only fuel and O&M?
Correct.
Well, that's, I think, a stronger version of your other remedy, which would have just done the incremental expenditures. But now you're saying throw out all the fixed costs, all the sunk costs entirely.
Yes.
Is that what you're proposing?
But because, like you pointed out, they are getting the benefit to the extent until they don't.
Right.
Going forward, ratepayers must pay the fuel and O&M charges associated with that continued use of the energy.
Well, that's a minimum condition, yeah, to just even have it there to supply the benefits that it does. So yes, that you'd at least have to pay fuel and O&M. I guess again, this gets back to saying your penalty is not grounded in any measure of harm or degree of imprudence. It's just saying stuff, if for some reason we don't like what you bought, we're not going to allow costs on it from then on. It's a concept of, it's a punitive concept and it may have some precedent, I don't know, but it's not grounded in how much worse off customers are or how bad the mistake was at the time.
Sir, this
the mistake wasn't equal to all the value of the cost that you're disallowing.
But sir, this isn't about what we like, right? That's not what this is about. Or what we prefer. This is about a finding of imprudence, if that were to happen, and to protect ratepayers from the harm that they are suffering for the decision making of utility management. So there is a question of accountability.
Right, I follow that. Well, I'm not disputing that if there is a finding of imprudence and it's based essentially entirely on process omissions and errors, it's reasonable to expect some sort of penalty. I think all of those types of process concerns have gone. I don't know there's anyone who believes that the company is still evaluating things in that same manner, or that it's sustained analytics approaches are like that. So in that sense, the methodological problem is cured. It feels to me this is more like a penalty to reflect that there's, I don't know how to put a penalty on a process error, but it's not the value of everything that ever happened since then. I don't think it's a small, and maybe it's on the order of the penalty that's already been assessed, where there's a return on debt only for the sunk costs from 2016 on.
Thank you, Mr. Graves, for your testimony. I'm out of time. Mr. Medeiros, I move the admission of New Energy Economy Exhibit 8.
Mr. Hearing Examiner, well, I guess we don't object to any E8.
Thank you, Mr. Graves.
Sure.
Hearing no objection, any E8 is admitted. I just want to make sure for everybody, it's not just Ms. Nanazi, we need to keep the administrative notice exhibits separate from this. They're admitted through administrative notice. So to the extent we go back and forth, let's be careful not to refer to those exhibits and seek admission what's already in the record. That's partly for me too. Okay. Now, before we go to the next cross-examiner, I want to point something out that I do not want to see ever again in briefing. I'm going to be very aggressive in striking misleading information. I thought I was trusting what was being read when you were reading, Ms. Nanazi, something to Mr. Graves that he apparently said back in September 2021. And that was that the analysis was incomplete compared to normal analyses. Okay. I was very curt because I'm trying to move forward as fast as possible. I was very curt with Mr. Alvidrez on that. Apologies, Mr. Alvidrez. I thought I was trusting an accurate representation of what the witness said. That was not, not what the witness said. And I've seen issues of this in briefing where people misrepresent what other witnesses said. I don't want to be caught or have hearing examiner Ryan caught endorsing stuff that is inaccurate and taken out of context. So this is a warning. If that is done in briefing in any of my cases, especially this one, I will make sure that I excise it with a razor and then say so that I did that in my recommended decision. Is that understood? Thank you. All right.
Mr. Medeiros,
Please
can I
do-
ask a follow-up question from Mr. Nass's
Yeah,
questions of
But
Mr.
I think, but hearing examiner Ryan, you understand the import of that. We can't have misleading, out of context quotes taken out of context. And that caused two problems. One is I jumped on Mr. Alvidrez because I thought he was just, interrupting your cross-examination when he wasn't. He was asking a very reasonable request. And so to the extent that this ever carries forward into briefing, everybody is advised, do not do that. Be accurate with what you quote and what you represent. All right. Hearing examiner Ryan, with that,
Mr. Grave.
Go ahead.
Yeah, just a quick question, Mr. Graves, won't take long. As you and Mr. Nassi were discussing during that last exchange, perhaps the last 10 minutes, I sort of found myself reflecting on the concept of moral luck. And it seems like you've said that it's problematic, and hearing examiner Medeiros and I have discussed the fact that it's problematic that we find ourselves so far from the point at which PNM had to make the determination about what it was going to do, because it causes all kinds of problems. And I just want to know from you, isn't somehow when a prudence determination is rendered, and theoretically it's rendered at the time the imprudence or close in proximity, one of the important consequences of that is that the future remains unknown. The utility is exposed to unknown circumstances. And in some ways, when you say, well, look, we can go back in time and see now that nothing has happened, you immunize them in a problematic way from the teeth of the prudence determination.
Mhm.
Do you agree with that conceptually?
I think it's an overgeneralization. I understand why you're asking it, but it's not necessarily the case that what has occurred in the interim since the challenge decision would make the problem less painful than it was feared. It could have gotten worse. So the point of the harm analysis is not to say, maybe this is a way of getting out of jail free. You could be getting a longer jail sentence in a sense, if it turned out that things had really gone afoul in a way that made having the coal plant even worse than was misunderstood at the time, allegedly misunderstood. So it just happens in this case that because of the ETA and because of the ability to potentially have gotten out of the Four Corners in 2024, and the now painful lens that's being put on gas plants, it's not so evident that there was any harm. But it's not that harm is that it always erases whatever the prudence problem was. If you make the prudence decision, if you find an imprudence problem at the time, the present value of the error is also the present value of your expected future harm. So when you correct it at the time, you're doing harm and prudence at the same time.
Within the context of a future that's entirely unknown.
Of course, yeah, and here too.
And the value of unknown is in fact significant, right? Because no one knew then what we all know now.
It's a messy problem. That's partly why I'm saying it looks like a tie to me at the time, and I don't know that you can declare somebody was imprudent because of sticking with a plan that was tied with an alternative. And it also is a point that I think underlines my point that even well-chosen plants sometimes are going to end up not looking as good as you hoped, and that doesn't mean the size of the outcome was proof that they were badly chosen.
Okay, thank you for the exchange. That's all.
Sure.
Mr. Borman, you have 10 minutes, is that correct?
I have reserved 10 minutes for.
That's correct.
I'm sorry, I didn't hear the rest of Mr. Borman's statement. I have reserved 10 minutes for.
I didn't complete it, that's why. But I had reserved 10 minutes for Mr. Graves. But I think my questions have been answered, and in order to expedite this process, I have no questions to ask him now.
That's Mr. Borman's way of saying, let's move along.
Fair enough.
Point taken. Unfortunately, you know me. Let's see. So, Mr. Graves, in your PNM Exhibit 18, the rebuttal testimony,
Okay, hold on one sec.
page 14, on line 8.
All right, I have it.
So there you say, and I'll go back up to line 6 and read this into the record. You say, therefore, although the hearing examiners, and it's apostrophe S, determination on imprudence was based on the information available to them at the time, once corrected, the items the hearing examiner, singular, lamented did not actually support a finding of imprudence. So I highlighted lamented in red.
Okay.
Because I kind of, being a little, sometimes a little bit sensitive, I took a little bit
Umbrage at that.
a little bit, but then I went back and I
It was,
just looked
sorry,
at,
yeah, by the way, it wasn't intended to be,
I
critical
understand.
review. It's just my way of saying you didn't like it.
Right. So I went and I just had you confirm what is in my earlier examination of you, where you said it was a bad process. You agreed that PNM's process was a bad process at 1:50 p.m. today. Didn't you?
I think I had a caveat to that, but if you want to cite me back to where it was, it's possible that's. I think I suggested that the term "bad" was overstated. All that what they did was okay. They just didn't do enough, and the things they omitted didn't change their decision. So, but it's a. Yeah, let's put it this way, it's not an entirely bad process. It's I like incomplete process as a better description.
Okay, but so looking at the definition of lament,
Okay.
it's to express regret or disappointment over some, and this is the American Oxford English Dictionary.
Pretty credible.
To express regret or disappointment, this is the verb with the object, was transitive, over something considered unsatisfactory, unreasonable, or unfair. So you'd agree, I think it's fair to say that a bad process is an unsatisfactory process, isn't it?
Sure, that sounds consistent.
A bad process is an unreasonable process, isn't it?
I'm going to object, and I hate to do that during a hearing examiner's question, but I think bad has some moral connotations to it, which I don't think that's.
And whose word was that back in 2017 and then used here again? Bad. Who used that?
Yeah, I don't know.
Your witness. Overruled. Stop now. Thank you.
Well, I guess I would just say the term bad is very broad. It could mean done with malice. It could mean incompetent. It could mean incomplete. There's a whole nuance of things you could say were bad about it, and they don't all rise to the same ultimate criticism. So it's just a pretty powerful term, and perhaps that's the word I used. I'm happy to not dispute that. But I guess whether it's unreasonable then depends a little bit more on what are the elements of badness in the bad process.
Okay, page 1326. Let's pull it out. So we're all on the same page again. September 7th, 2021. Page 1326. Line 20.
Sorry, I don't know where to find
Mr. Hearing Examiner, could you just say the page again, please?
1326.
This is not in my exhibits, in our exhibits.
It's Commission AN 76. It's in the Dropbox folder.
Okay, thank you. In here.
It's the very last exhibit there at the bottom of the administrative notice
Thank you.
folder.
Yeah. Actually, ours goes to exhibit 75 is where our last one is. AN 75. Did you say it's AN 76?
Yeah, look in the Dropbox folder for administrative notice. It should be there. Please.
I'm going to let the experts do this. I think that's what I'm doing, but it seems to me that there's only 75 in this.
Well, there's a miscount, but it's at the very bottom. It says TR Volume 5, Hearing Day 5, 7 September 21. Hearing examiner examination of Frank Graves.
I have the paper
Commission.
now, so we're good.
Okay, thank you.
Okay, so I'm sorry, can you point me to where I'm looking here?
Page 1326.
All right.
It's a
I have that.
I'll take it.
line 21. And Mr.
Yep.
Graves, you do say on line 20 that I don't think it was an imprudent decision. It was a bad process, but it wasn't an imprudent decision. Is that your testimony?
That's accurate. Yep. Thank you for
Some-
pointing.
I'm trying to understand what bad means according to you. But it seems like what you're saying is, yeah, it was bad, but there was no harm.
Well, no, I'm saying something a little stronger than that, that it was bad, but it didn't, that a better analysis wouldn't have reached a different conclusion. So the result was prudent, even though it wasn't prudently evaluated.
That's telling. It was not prudently evaluated. Is that your testimony today? You just said it was.
Well, I'm sorry, I get that.
It wasn't prudently evaluated is what you just said.
Yeah,
correct?
but I'm trying to explain.
Whoa. Did you just say it wasn't imprudently evaluated? Yes or no? I have drill time right here.
Yes, of course, those were the words. I get that. I'm saying.
No. Did you say that?
I just said I did. Yes, I'm not disputing that. I'm disputing your interpretation of what I meant.
Okay, we're going to play logic games.
No, these are contextual. It matters what.
Yeah,
the-
I'm going to get to your circular logic. Okay, don't worry about that. Go ahead. Well, try and
What's your
clean up your answer. Clean up your answer. It wasn't prudently evaluated, but
Even if it wasn't imprudently evaluated, I'm not saying it's not a conclusion of mine, but I'm saying the result was the same as a prudent evaluation would have reached. And what was done, just to give you a better, more fulsome description of my understanding of it, is the work that was done was within normal standards of the industry for the types of models, data sources, et cetera, used. It just didn't include every other dimension of the problem that people often look at. And so in that sense, it was clearly incomplete. And in that sense, it was a bad process.
and in the first part of your analysis, not the damages analysis, but in the first part, you helpfully fill in those things that P&M could have known if at the time, correct?
Right.
And then that you then bootstrap that or bolster P&M's decision by saying it was out there. And then we get into the discussion later on about, well, they should have known, right? They should have known those things. Because that's the legal standard.
Sure, yeah. I don't know that they didn't know them. They didn't evaluate them. They had beliefs about them and didn't include them in their analysis. But what I'm saying is trying to distinguish here is in this sentence you quoted, the harm and prudence thing I'm trying to keep separate.
No, you're not.
I'm not saying
It doesn't matter
Okay.
whether they are prudent or not to you, because there was no harm.
Well, that's an outcome, but it does matter to me. I believe they were prudent in the sense that we don't have any information about a better decision they should have made, and they were using prevailing methods that were reasonable and actually included things the way they'd been doing things for years. But at that time,
but that was a bad process. How could that be reasonable if it's a bad process? We just agreed that, well, you didn't agree it was unreasonable because that was the objection to my question. Please don't do that again.
I'm not
It's,
sure.
it's a waste of time.
Okay.
But no, I'm not talking to you about the objection. I'm talking to your counsel. But you did say it was a bad process.
Yes,
Today
it's
and back
clearly-
in 20.
Yep, it's right there. I agree with that.
Okay. Do you agree? Do you know philosopher Bertrand Russell? Have you ever heard of him?
Sure, yeah, at a certain level. He's famous for the barber's shaving paradox. If you
Right. And he also, let me see if you agree with his observation that the method of postulating what we want has many advantages. They are the same as the advantages of theft over honest toil. Have you ever heard that statement?
I have not. I don't know what context he's referring to.
He's referring to it in the context of circular reasoning.
Okay.
Starting with the conclusion and ending up in the same place. So let's assume that it was a bad process. Let's just assume that P&M was imprudent in making the decision it made. And we go through all of that we lamented about in the certification of stipulation. See?
Okay.
Okay.
Yep.
But in your estimation, doing the damages analysis, the customer, the ratepayer, is actually better off, as I understand it, for P&M's imprudence. Therefore, it doesn't matter.
The only part I don't agree with is therefore it doesn't matter. It does matter, and they should fix that. And perhaps there is some modest penalty that's reasonable for the error, the methodological errors. But if you said, let's give them $100 million penalty and then also let them enjoy the fact that they never incurred $100 million loss, the customer is actually better off from that outcome of saying you got a penalty for a decision that was made and you got the benefits of it working out better than was expected.
Yeah,
They're better off than if the decision hadn't been made.
But there's evidence there may be evidence in the record that your methodology was flawed in certain respects in the damage analysis. Isn't that true?
Sure, Mr. Fisher and I disagree on several elements of that, but I'm unpersuaded by his corrections. He may have the same view of mine.
Fair enough. Okay.
Mr. Banaros, can I ask a follow-up question on that? Just real quickly?
Please.
Mr.
Please.
Graves,
You take-
so here's my question then to you, sir. If you're not arguing, and I'm not trying to force you into an answer. I legitimately want you to know. I want to know, are you saying that your harm analysis is the only principled one?
Well,
In other words, one more statement.
Yeah.
Could one formulate a very different resolution to the quote unquote harm analysis that would be radically different than your own, but still based on logic and reasoning?
Sure, I think so. What I'm really trying to explain here is I don't regard them as circular. I think they're separate, staged, iterative questions. The first one is their imprudence, and if so, then the question is harm. Much like, was there liability for some corporate, performance failure, and if so, what are the damages? Then those are two separate questions. And if it turns out there's no damages, even if there's liability, then there's no award. And it's not erasing the fact that there was a liability.
I understand. But so if I were to say to you that, well, no harm, and then I'm not trying to be cute about this, but it's sort of, we could just kind of encapsulate all that within no harm, no foul, right? But let's assume for the sake of argument that the law, for whatever reason, concludes that that's not a defensible position, because where there is a foul, there must be harm. Right? That's not illogical. That's not an illogical result.
Fair enough. So it's possible that it's not no harm, no foul. It's no harm but foul.
Right.
is another way of describing that, and that's certainly a possible interpretation here. But in that case, the harm isn't just a big number taken from one.
Well, and so the question becomes: is it just a loss of possession, or is it a 15-yard penalty to mixed sports?
Right.
What is the penalty, or is it just a jump ball? What you're the closest one in this analogy is the jump ball, isn't it?
I suppose so. Yeah, at least in terms of the. Well, I'm not diminishing the complexity of the problem for you guys, but I think it maybe no harm but foul is the right way to characterize it. Which all that means is that any penalty shouldn't just be a big chunk of whatever happened, because we haven't shown that is either what was the size of the mistake or the size of the consequences.
Yeah, but it seems to me, yeah, and then I understand exactly what you're saying. So if we couldn't arbitrarily punish them, like, because this imprudent determination, you must pay for things entirely unrelated to any of this. I mean, that no one is suggesting that. I don't think. I think where you really get action is, how do we? Your sort of gloss back on history to say, well, if we just think about it as unfolding in this way, therefore we see there's no problem. I think you can conceptually come to that and reach a very different result. And do you at least accept that?
I think I'm generally in agreement. I don't know that we would agree on the size of the.
Yeah. Okay.
Memories, but
fair enough. That's all. Thank you.
Here, let's go back to try and assess what the harm was. It's very difficult, isn't it? And
yes, it is. Yeah, no doubt.
Let's see if you agree with this postulation. Now it's my postulation. Let's assume that National Pandemic Strategy Handbook hadn't been burnt or torn up and thrown in a gold toilet.
Right, exactly.
And Rochelle Walensky was in charge at the CDC in March 2020.
Okay.
And the strategy in that handbook that was shredded was followed. So in other words, there was a more
Orderly,
prudent.
yeah, preparations were in place and all that sort of thing.
What are the odds that the harm to to Americans and potentially others would have been mitigated from the disaster of the pandemic? Is it possible that we would have achieved a better outcome? All that's in there, as
Yeah,
opposed to the ridiculousness that ensued.
My suspicion is yes, that, and I don't know the magnitude, but at least the experts I have heard to say things like, well, we had mechanisms in mind for preparing and creating inventories and, creating capacity at hospitals and sharing resources. And there could have been, it wouldn't have been the case, there wouldn't have been a pandemic, but.
No, but lives would have been saved.
I think so, sure.
Lives would have been saved.
Yep, and disruption would have been lower too, I think.
So lives were lost because of what happened.
Well,
or what didn't happen.
Yeah, I
Okay.
suspect that's true. Yeah.
Okay, thank you. Mr. Alvidrez, Mr. Ryan, do you have anything further?
No, thank you.
Mr. Alvidrez, redirect.
Yes, Mr. Hearing Examiner, as a preliminary matter, because this may impact whether you're done with your examination, PNM does object to the proposed administrative notice of your examination from case 21-00017 UT. We believe you were quite clear in ruling on PNM's request for administrative notice that the analyses were different, that the analyses were to rise and fall based on the facts in this specific case, and for that reason, we object to the administrative notice. So
well, you know what? I'm not going to allow you to have a red herring on appeal. So I'm going to pull it out. I think I made my point today along the same lines, and the standard still applies. So you know what? I'm just going to pull it out myself because I don't want you to have a red herring on appeal or for another party to do it. So I'll just keep it out. So there.
Okay.
But
yes.
I want to go back to something though, because just Mr. Graves, I have here on 199, line 16. You say,
I'm sorry, what?
of your testimony today.
Okay.
I'm reading the real-time transcript. We can sync it up later. And I do have to remember to go back and pull out that
I see.
exhibit. but
Okay, yeah.
I'm not concerned about that because everything I said there and we talked about there was reaffirmed here today in spades.
Okay.
So 199.16, let me go to the sentence before that at 199.13. It changes the relative amount of value it had, but it doesn't prove it was an imprudent decision. It was a bad process, but the result, which was also assessed in a fairly normal but limited way, was sustained in my view. So that was a straightforward statement that it was a bad process when you said that, correct?
Sure.
Okay. Mr. Alvidrez, go ahead with your cross.
Yes, redirect.
Redirect. Sorry, that was a Freudian slip too.
I hope it's not crossed. That would be unexpected.
That
Mr.
was a
Graves,
flashback to last night.
you were asked some questions about the relative difference in values of your analysis between customer savings in your remedy analysis between the 2117 case, 0017 case, in this case. And I think Mr. Marks had asked you and noted there was a delta of around $75 million. Do you recall that?
Yes, I do recall that discussion.
And do you recall that whether PNM shareholders were contributing with respect to the proposed sale of its assets, its interests to NTEC.
Yes, I'm not sure I recall the exact details, but my recollection is they had to pay a fairly substantial sum, pretty close to maybe 70 million itself, 70, 75, as a buyout to mark the coal contract to market going forward. And so there was some of that exit and transition fee kinds of costs that we were discussing were in fact incurred in, and yet it still looked beneficial because the shareholders were picking it up.
Okay. And Ms. Nanasi asked you about the proposed San Juan abandonment. I think she said abandonment of units 1 and 2, but case 13390 actually involved the abandonment of units 2 and 3. Are you familiar enough with that case to know what the replacement resources were with respect to San Juan units 2 and 3?
Yes, my recollection is that was moving parts of Palo Verde 3 into rate base, so it was mostly nuclear, as I recall.
Those are my questions.
Thank you, Mr. Alvidrez. And for the record, that Commission AN 76 that I placed in that Dropbox folder for administrative notice, I've now deleted it. So we're done with that. Okay. Mr. Graves, could you please be available? I was going to say stand by, but I don't want to get in trouble going any further.
A poison.
So yeah, in case just for the commissioners' benefit until the end of the day, if they have time to come back and have any questions for you, would you mind being available until the end of the day?
That would be fine. Yeah, which would be like 5-ish or so or thereabouts. Anything.
Yes, sir.
Just wondering what you had in mind.
Hopefully 5 o'clock and no later than. Thank you so much, sir. Appreciate your testimony.
Yep.
Thank you.
Thank you for discussing it.
Thank you. Okay, let's move on to the next witness. PNM, could you please call your next witness?
Yes, Mr. Examiner, Ms. Terwilliger will be presenting our next witness. Mr. Watson, it's going to take a couple of moments to switch out our witnesses. I don't know if you want to take a break now or.
Let's take our break now and come back at 2:45 or 2:46.
Thank you.
And Mr. Alvidrez, thank you for putting up with with me today. I appreciate it. 2:46. Thank you.
Thank you.
We're in recess.
Mr. Lee, can you hear me?
Yes, ma'am.
Great, thank you.
You bet. Are you up this afternoon?
I am.
Ms. Twilliger, good afternoon.
Good afternoon.
Would you please call PNM's next witness?
Yes, sir. PM calls Mr. Dane Watson. May the witness be sworn.
Will you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not penny should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Can you please state your name for the record, spelling your last name and who, your title?
Yes, Dane Watson, Watson. I am managing partner of Alliance Consulting Group.
Thank you, Mr. Watson. And do you have in front of you what's been marked PNM Exhibit 15?
I do.
And that version of PNM Exhibit 15, that was circulated in corrections to your direct testimony was circulated yesterday via email. Is that right, Mr. Watson?
Yes, that is my understanding.
Okay. And the corrections reflected in PNM Exhibit 15, do those reflect or are they made because of an errata you filed previously or you caused to be submitted previously to the commission?
Yes, we noticed one minor change that we needed to make based on an earlier data request that we responded to, and an errata was filed based on that.
Okay, and the corrections made yesterday just carry forward that number into other calculations, is that right?
Yes, that's correct.
All right, and it doesn't change, or tell me if it changes anything about the cost of service or what we are asking for in terms of a depreciation.
No, it makes absolutely, it has no bearing on what we requested in the depreciation study or had any impact on the cost of service.
Okay, so now I'm going to go through the normal questions. I just wanted to make sure we had that squared away. So that PNM Exhibit 15, which is your direct testimony, was prepared by you or under your direction. Is that right, Mr. Watson?
Yes, it was.
Okay, and any corrections you have to that exhibit have been circulated to the parties as of yesterday. Is that right?
Yes,
And based on those corrections, is that testimony true and accurate to the best of your knowledge?
it is.
If I asked you those same questions today, given the corrections, would those be the same?
Yes, they would.
I request admission of PNM Exhibit 15 as circulated yesterday.
Is there any objection?
I just had a
PNM
question. Sorry. What is the errata number where those corrections are?
The corrections made yesterday,
Yes.
we
I
didn't.
thought that you,
We did
I
not.
thought-
Sorry, go ahead, Ms.
I thought that you had said that they were based on an errata that PNM filed, and I was just curious, the errata number.
The original errata was filed as PNM errata 1. That changed a number from 7 to 10. That was the only change. Mr. Watson, when he was looking at his testimony again yesterday, realized that change kind of carried through to some calculations. And so the corrections that are reflected yesterday are a result of the errata number 1 that Mr. Watson made some time ago. Does that make more sense? Okay. All right.
Yes, thank you.
Is there any objection to the admission of PNM Exhibit 15? Hearing none, PNM Exhibit 15 is admitted.
Thank you, hearing examiner. And Mr. Watson, do you have what's been marked as PNM Exhibit 16?
Yes,
And that's your prepared rebuttal testimony, is that right?
it is.
And was that prepared by you or under your direction?
It was.
Do you have any corrections to PNM Exhibit 16?
I do not.
And is that testimony true and accurate to the best of your knowledge?
Yes, it is.
And if I asked you those same questions today, would your answers be the same?
They would.
I request admission of PNM Exhibit 16, please.
Is there any objection? Hearing none, PNM Exhibit 16 is admitted as well.
Thank you. I tender Mr. Watson for cross-examination.
Thank you, Ms. Terwilliger. Ms. Gould, I have you down as estimating 15 minutes with Mr. Watson, is that correct?
That's correct.
Please
Would I be,
proceed.
thank you.
Oh,
Would I be able to
no.
use this?
Go ahead. I'm sorry.
Would I be able to use the screen sharing function during my cross-examination?
And Examiner Ryan, can you make it so?
Yeah.
Thank you.
I think I can. I'm just asking permission.
Sure. Yeah, you should be able to.
Okay, great. Thank you. Good afternoon, Mr. Watson. My name is Kelly Gould. I represent New Mexico Affordable Reliable Energy Alliance, also known as NM Area. How are you doing today?
I'm fine, thank you.
So I want to get a little bit more clarity on what PNM is proposing for the depreciation on account 391.3.
Okay.
Can you please tell me the full title of this account?
Computer hardware is what I have in my studies. I think there is a fuller name for it that is actually on the accounting system.
And do you have the full name?
I believe it, I do not have it here. Wait a minute. I believe it's spoken to in my rebuttal testimony.
Is it office furniture and equipment dash computer hardware?
Yes, I
And
believe
which-
that's its official name.
Okay.
We titled it in my study, just computer hardware.
Okay. But Mr. Meyer refers to it as office furniture and equipment in his testimony. Is that correct?
Yes.
And what is the current approved life for this account?
I'm sorry, would you please ask again?
What is the current?
The current life?
Yes.
It is currently 10 years.
Okay. And Mr. Meyer is recommending that it stay the same. Is that correct?
It was,
Excuse me. Mr. Meyer is recommending that it stay the same. Is that correct?
I'm not exactly sure what his recommendations were. He talked about splitting into different categories, but his primary recommendation, I believe, is not to accept the movement to 5 years.
So keep it the same.
Yes, absent the extra nuances of wanting to split into 3 categories, this account for some reason.
Was that in this case or maybe in a future case, that recommendation?
He wasn't very clear on it to my memory. I don't know.
Okay, and you already stated that PNM is recommending that the approved life change from 10 years to 5 years. Is that accurate?
That is accurate.
Okay. So I am going to screen share if I can do this. Let's see. Hopefully, if I do this correctly. I'm hoping you all are looking at NM Area Cross-Examination Exhibit 5. Is that what you all see?
Yes.
Which is the Public Service Company of New Mexico's objections and responses to the New Mexico Affordable Reliable Energy Alliance's 5th set of interrogatories and requests for production of documents. Is that accurate?
Yes.
Okay, great. Mr. Watson, this is NM Area's 5th set of discovery to PNM. Is that your understanding?
Yes.
Okay, and now I'm going to scroll to page 9 of 12 that continues on to page 10 of 12. I'm looking at interrogatory NM area 5-4. Are you there with me?
Yes, I am.
And I'm going to read this. Referring to PNM exhibit, oh, are you a, excuse me, sorry. Are you a, did you answer this question? Are you one of the witnesses that sponsored this interrogatory?
Yes, I am.
Okay, great. Referring to PNM exhibit DAW-2 for account 391.3 computer hardware showing a plant balance of $52,492,561 as of 12/31/2021, please provide the following. A, as of 12/31/2021, what percentage of the investment in account 391.3 was investment in personal computers, laptops, or notebooks? And the response says, please see NM area exhibit 5-4. That's the beginning of the response. Do you see that?
Yes,
Okay, and NM area, PNM exhibit NM area 5-4 is an Excel spreadsheet. Is that accurate?
yes.
Okay, so I'm going to move to that. So this is what I have in Dropbox as NM area cross-examination exhibit 5A. Would you agree that this is PNM exhibit NM area 5-4, which answers the interrogatory NM area 5-4?
Yes, it does, to the degree possible. A explained why there were some things you couldn't classify down to that level.
Okay. And this spreadsheet lists the assets that are included in account 391.3. Is that an accurate statement?
Yes, it is.
Okay. I am now going to go back to NM area cross-examination exhibit 5, which is NM area's PNM's objections and responses to NM area's 5th set. And I'm going to direct you to interrogatory NM area 5-2. Are you there with me?
Yes,
Okay. And you are the sponsor of this interrogatory, is that accurate?
that is accurate.
Okay. I'm going to read A. Please explain the source of the proved life of 7 years for account 391.3. And your response is regarding account 391.3 parentheses computer hardware. The company's proposal in case number 15-00261-UT was 7 years. The life as approved by the commission in 15-00261-UT was 10 years. The 7-year approved life shown in Appendix C for account 391-3 is incorrect. The correct life is 10 years. PNM will file an errata with this information. Did I read that correctly?
You did.
Okay. Was PNM incorrectly using the 7-year depreciation in rates?
No, that 7 years was simply a holdover from a previous file from the depreciation study. The correct number is 10. The rates used by the company are based on a 10-year life.
Okay. And you performed the depreciation study in 15-00261 UT, correct?
I did.
And you state in this interrogatory that in 15-00261 UT, that PNM proposed to depreciate this account over 7 years, but the commission did not agree with you. Is that accurate?
Yes, that's what I stated, that they left it, I believe, at the 10 years that it previously was.
Okay, that is all of my questions. Mr. Hearing Examiner, I would like to move for admission, but I am going to need some guidance on how you want me to label these documents. I would like to move for admission into evidence NM Area Interrogatory 5-2, 5-4, and PNM Exhibit NM Area 5-4, which is the Excel spreadsheet, which we will have to PDF.
These are not in the Dropbox folder already?
They are, so this is, if I could just get a ruling first and then I could talk to you about the logistical issues.
No?
No? Well,
Explain what the documents are.
what's in Dropbox is
Please.
this entire fifth interrogatory set. And from what I understand from the hearing examiner's prior rulings, you would only like us to admit the portions of this exhibit that we've actually asked questions on. So I don't want to move for admission of this entire exhibit because I will need to cut out just interrogatory 5-2 and 5-4. And then I will have to email those portions to the parties. And then I have a question on how you would like me to label that exhibit. If I continue on with the numbering that we have, which would make it NM Area Cross-Examination Exhibit 42, or if it would then instead replace NM Area Cross-Examination Exhibit 5. And then the question for the Excel spreadsheet is that is labeled NM Area Cross-Examination Exhibit 5A, but it is an Excel spreadsheet. And so I will need to PDF that Excel spreadsheet so that it can become part of the record.
Hearing Examiner Ryan?
I don't know. I
Did you
think
follow that?
I think I did. I can read it again. I mean, as to the question about, I'm so hearing Examiner Medeiros, I mean, if that's the preference we've stated for just having the portions of the document, I think Ms. Gould could just go back and excise and, right? That seems the simplest.
Right, so let me, the ruling that you requested is that, is there any objection to the admission of what is it, 3 exhibits, Ms. Gould, that you're seeking the admission of now?
Well, it depends on how you would like me to. I don't know if 5-2 and 5-4 would be one exhibit, or if you'd like me to separately label them.
Why don't you just label them one exhibit?
Like all 3
Right.
together as one.
All 3 together. And then if this makes sense, we could label it, you could put it in Dropbox as New Mexico Area Cross-Examination Exhibit 42, as you suggested.
And hearing examiner, can I just have one request? All right.
Sure.
Just I would ask Ms. Gould to do, make sure the cover page and then the affirmations at the end are all reflected. The self-affirmation are reflected in that response for 5-2 and 5-4.
Yes, thank you for that reminder.
So,
And then just real quickly, hearing Examiner Medeiros, one of the things that we talked about early on in the proceeding was not messing with the Dropbox as exchanged by the parties as we did preliminary. I mean, that's kind of changed as we gone. It's fine. It doesn't matter. But I think the parties should email each other when you're just talking about single exhibits in the course of the proceeding. So, I mean, if we want to just do both, that's fine.
well, I've just gone in and cleaned up things.
Yeah, that for you and I to do that, that's fine. But like when the parties all start collectively shifting all the puzzle pieces around, then confusion ensues. I've had it happen,
Yes.
and it just.
So my suggestion, and I'll do whatever hearing examiners require of me, but my suggestion was to just create the exhibit, label it NM area cross number 42, email it to all the parties and Mr. Lee, and then I would leave it all up to you to do the Dropbox so that I'm not involved in that, if that is acceptable.
Right. And so what is in this 42? It's 5-2, 5-4.
Yes, and what is called PNM Exhibit NM Area 5-4, but what is called in our Dropbox NM Area Cross-Examination Exhibit 5A, which is an Excel spreadsheet, which we would PDF, and obviously PNM would make sure that it is PDF'd correctly and accurately, and we would include the PDF document in that exhibit.
Okay, now, the benefit of a long hearing is that we can get this fixed, but providing the document to Mr. Lee does not necessarily mean that's the document. It has to be the same document that ends up being the Dropbox folder, because the Dropbox folder is the repository of both admitted exhibits and exhibits that have not yet or may not be admitted, but have been placed there by the parties. So let's be careful with that. But subject, Mr. Williger or anybody else, subject to the arrangement or the protocol that Ms. Gould has outlined painstakingly for this particular NM area exhibit 42, is there any objection to its provisional admission?
No, hearing examiner.
Okay. NM, this new NM, new yet to be seen NM area cross-examination exhibit 42 is provisionally admitted.
Thank
Subject
you,
to
hearing
fix.
examiner.
You're welcome.
And I'll just note, not to further belabor the issue, however, you know, due to time and really unknowingness, we've uploaded our discovery. We don't exactly know which questions we might need, and so this might happen again if we only refer the witness to one portion of the discovery set.
Well, we can't have extraneous materials in the record, though. I'm sorry.
I'm not requesting extraneous materials. I'm just.
No, I know you're not. I know you're not. I'm just saying by happenstance or by accident.
Yeah, I'm just stating that as we proceed after cross, we might have a updated exhibit that is just what we crossed on, so that there are no extraneous materials in the record.
Right. Okay. Thank you, Ms. Gould.
So let me stop my screen share. Thank you.
You're welcome. Thank you. Right. We, Mr. Herman, Water Authority, are you there? Good afternoon, Mr. Herman. Sorry. Good afternoon, Mr. Herman.
I'll just note that me and Dal Harris switched spots at the last break.
Yes.
Sorry, me and Dal Harris.
Switched positions at the last break.
I hope you're feeling better today than yesterday and than the day before. And
Thank
recovering.
you. I'm better every day, but still maybe a little congested. So I apologize if I'm not speaking clear enough for Mr. Lee.
It's not your fault. Let's I bet you estimated 25 minutes with Mr. Watson. Is that correct?
Yes, I don't think I'll use all of that time. I'm not requesting to move it, but just for sake of the other parties who might be after me.
That's nice. Thank you. Okay, please proceed.
Good afternoon, Mr. Watson. How are you today?
I'm fine, sir. Thank you.
My name is Keith Herman. I'm here on behalf of the Albuquerque-Bernalillo County Water Utility Authority, or Water Authority, and I had some questions for you about your rebuttal testimony. And just for sake of reference, we have 2 witnesses in this case with the last name Garrett. And I believe you only responded specifically to Mr. David Garrett. So.
And as far as, yes, as far as your position, that's correct, I believe.
So if I reference Mr. Garrett, it'll refer to Mr. David Garrett's testimony.
Yes.
So first, starting around page 19 at line 16, you discuss the simulated plant record or SPR analysis that was used in 15261, correct?
That's PNM Exhibit 16.
Yes, if you could clarify a bit, this talks.
I'm sorry.
Is that the 1915 rate case or 2015 rate case you're just talking about?
Yeah, so I might have said the wrong page number. I believe it was page 19, line 16. If I misspoke, I apologize.
Yes, I talk about the analysis I did in that was filed as part of the 2015 rate case. The specific case number is not. It may be on the next page. You're right. It's a 1500-261 UT.
Yes.
Okay. Yes, I do.
And at that question, starting at line 16, you state that an SPR analysis was, an actuarial analysis was used to a limited extent in 15261 due to a limited amount of data, correct?
Yes, the same as it was in this case. That's correct.
And we now have 7 more years of data since the 2015 rate case, correct?
Yes, 6 or 7. I can't remember what the study year end was, but 6 or 7 years. That's correct.
And moving back to page 14, line 15. You state that PNM is going to be moving towards a more actuarial analysis in the future, correct?
Well, and we did use more this time because there was a couple more accounts that were statistically valid in this case that weren't in the last one. So I would anticipate as we get more and more years of actuarial data that that we will be able to start seeing some of the shorter lived accounts, at least maybe having a little bit of information available from the actuarial accounts or the actuarial studies.
Now I'd like to direct you to page 40 of your rebuttal.
I'm there.
Specifically figure 21, or your reproduction of ABCWA witness David Garrett's figure 21.
Yes.
Am I correct in that nomenclature that that's Mr. Garrett's identification and not your identification? I just want to be clear for the record.
I'm sorry, would you repeat what you're asking?
I'm just trying to be clear that, is that Mr. Garrett's figure 21 or is that your figure 21? I just asked because I know it's a reproduction of Mr. Garrett's figure. I just don't want to confuse the identification.
I understand. I believe it's a reproduction or a copy of his. It actually, yes, you can find it on that same graph on page 99 of Mr. Garrett's testimony. So it is his graph, not one that we created.
And it's his 21st figure, not yours.
Yes, it's the graph he put for this account in his testimony on page 99.
Okay. And hold on, sorry, excuse me. Just to confirm, the triangles in that figure represent the company's data, correct?
Yes, it's the points on the what we call the observed life table. So the actual company experience.
Mm-hmm. And the orange line is Mr. Garrett's Iowa curve, correct?
Yes, that's correct.
Mr. Garrett's Iowa curve?
Iowa is in the state.
Correct.
And the dotted line is that your Iowa curve?
Yes, that's our recommendation in this case. That's correct.
And you agree that Mr. Garrett's curve is closer to the actual data than your curve, correct?
In parts where they actually are relevant, I don't necessarily agree that's always the case. If you look between year 1 and year 20 or 25, when they become irrelevant, I don't believe his is a better match than mine. Beyond that, there's not enough data to use that. You use the analysis for any rational decision. So in the points that matter, I would not say that his curve matches better than mine. No, sir.
You mean from years, let's say 0 to 30?
Well, I would say if you look at about year 25, that's when the statistical validity of the curve starts to fall away. And so through year 25, I would suggest that if ours is not, my recommendation are not better, they are comparable through that short point. But be that as it may, all the theoretical text would say you cannot make a judgment call on a life from an observed life table that is of this shape.
So what would be the logical extrapolation of the those triangles on PNM's data if that were extended beyond year 80?
It would go to 0 shortly after. I don't think we addressed that for this particular account. It would go to 0 probably 90 years, where Mr. Garrett's probably is 120 or 130 years.
Maybe I'm not following because I'm looking at the triangles from, let's say, year 65 on out, and they look relatively level.
Oh, the statistical validity of the observed life table fell off back in maybe year 25 or so, because you can see the curve should be turning downward and it's not. And that's one of the signs that you don't have a statistically valid sample. And both NARUC and all the text will tell you that if you don't have a curve that is at least 70, NARUC says 50% extended down to 50%. It's not predictive. And that's one of the reasons that in this count, I wouldn't use the actuarial data because it's just not predictive. And all the theoretical text will tell you that that's the case.
So going back to the source of your information here, you selected a 49-year average lifespan?
Yes, a 49-year life with an R2 dispersion. That's correct.
I'm sorry?
A 49-year life with an R2 dispersion is what I selected for this account for PNM.
And how did you select that 49-year average life?
I used the full SPR analysis data to choose the 49-year life, moving from a 42-year life that was existing out to a 49-year life based on the SPR analysis, which includes many, many years of data.
Could I direct you to page 41, lines 15 and 16?
I'm sorry, would you say it, the number again?
Page 41, lines 15 through 16.
Page 21, line 15 through 16. I'm there.
41, excuse me.
Oh, 41, I'm sorry. Line 15 and 16?
Yes, specifically there where you're asked, what information did the SMEs or subject matter experts give you that incorporated your lifeline recommendation? So that 50-year or 49-year period, that was provided by PNM, correct?
I'm sorry, my speaker here is not very good quality. It's really hard to hear. I apologize. Would you repeat the last part of your sentence again?
I was just asking you if it was in fact that PNM and their subject matter experts provided you with the 50-year estimate.
No, they provided, okay, so what they provided me was a number of things. The 50 years was only their expectation for a normal life for transformers that would be in this account. But they shared, if you can read my interview notes, they shared a great deal more about their expectations for the different types of assets that they manage, everything from relays to SF breakers to oil circuit breakers to anything that's in the account that they would normally operationally see being replaced on a periodic basis. They would share their expectations on the replacement periods. And so the 50 years was their estimation for that one particular component that's in the account. And frankly, from my years of experience with working as an engineer and studying these things, that's a very reasonable time frame to estimate for distribution transformers.
Isn't it true that shorter Iowa curves result in higher depreciation expense and additional cash flow for the utility?
So a shorter life curve combination, for example, a 40-year life with an R2 curve versus a 50-year life with an R2 curve. The 40-year life would say it's an average service life, would suggest a shorter remaining life to recover the remaining assets. So depreciation expense in the case where the estimate is shorter would have more depreciation expense. And I guess when that factors into your cost of service filing and everything would create, would all else equal create cash flow.
And moving on to page 44 of your rebuttal. There we have another reproduction of David Garrett's figure 22 that also shows from the years 25 forward, his line is closer to the actual data than your line, correct?
Yeah, subject to the fact that the company's data is not statistically valid, neither one would be a match that anyone should ever make. They only match it all through 10 years in this case.
All right. Thank you very much. That concludes my examination, or my cross-examination.
Thank you, Mr. Herman. Mr. Nazi, are you there? Yes, you're there, of course. I'm sorry. You have 34 minutes, I see here with Mr. Watts. Mr. Williger, you have your next on deck person in case we get there.
Yes, that should be Miss Mendez. But we'll have to switch attorneys again, unfortunately.
Well, I'm sorry. Okay, Ms. Nanazi, are you ready?
Yes, I am, sir.
Please go ahead.
Hello, Mr. Watson. My name is Marielle Manassi. Good afternoon.
Good afternoon.
You conducted a depreciation study for P&M, correct?
Yes,
You were required by P&M to exclude Four Corners Power Plant from that depreciation study. Is that also correct?
yes, it was outside of my scope.
And you have testified in more than 300 different proceedings before more than 35 different regulatory bodies, including before the New Mexico Public Regulation Commission, right?
Yes,
You testified before this commission for SPS, Southwest Public Service, in case number 22-00286 UT. Is that right?
I'm not good with the numbers, but yes, I filed testimony with for SPS in New Mexico.
In November of last year and May of this year. Is that right, sir?
Yes, that sounds reasonably correct. That's fine.
And you did that to align the depreciation of their utility assets with its service life, correct?
Yes, that's the purpose of any depreciation study, but yes,
But that was the purpose of your testimony, I'm asking you.
right, as it is with any depreciation study. That's right.
You made certain assertions that I'd like to ask you about, and tell me if your position differs now from the sworn testimony you provided last year in November and earlier this year in May. Is that okay?
Hearing examiner, we were not told that Mr. Watson should be prepared to have his SPS testimony and have reviewed it. I don't know if Ms. Nanazi is going to share her screen. I think it's a little bit, he's not testifying on behalf of SPS right now. I'm not sure. I guess we could have him ask the questions and see what his memory is, but I don't know that it's fair to make comparisons when he doesn't have the testimony in front of him. And I don't know. I assume he does not.
Is it in Dropbox, Ms. Nanazi?
Yes, it is. Both his direct and his rebuttal. So it's been there for days. This is cross-examination. I think it's totally appropriate.
No, what you're cross-examining on?
I'm cross-examining him on his testimony.
Go ahead and ask a question.
Thank you. When you use the term depreciation, you define it as a system of accounting that distributes the cost of assets less net salvage, if any, over the estimated useful life of the assets in a systematic and rational manner. Is that correct?
Yes, I believe I used that definition as well in the current case.
It is a process of allocation, not valuation. Is that also true?
Yes, it is.
Is it also true that the longer time horizon a utility depreciates an expense on its books, the longer it can claim a return on those assets?
Your words are a bit inelegant. I don't know that they depreciate expenses, so I can't agree with. If you'd reword it, it's not accurate what you said.
So is it true? Thank you. Is it also true that the longer time horizon a utility depreciates an asset on its books, the longer it can claim a return on those assets?
Well, return on assets is the net book value, basically, of the asset. And so the longer it depreciates, that means the longer there will be some level of net book value remaining. So, of course, that is functionally true from the way the calculations work.
And just to respond to what you just said, that means that as long as that there is net book value that's on the books, the utility can claim a return on equity for that asset.
Well, you know, I used, long ago, I testified on cost of service, and I have a problem with they will be able to look at the net book value or the rate base, which is a lot more than that, at any particular time when they file. But outside of that time period, you don't claim ROE on an asset. I mean, you have an opportunity to earn on it, but it's only during the test year. So I'm very careful with my words, and I can't really totally agree, but that's my understanding.
So outside of the test year, could you please explain your answer more fully?
Well, I mean, my understanding is that a utility has an opportunity to earn a rate of return. It's not guaranteed. So, you know, I mean, from the standpoint of you have extra assets on your books, that lowers your rate of return. So it's not clear and cut definition. I mean, there's a lot of nuances to rate making.
Could you please explain Commission Rule 17.3.340.10 and MAC as you understand it?
Do I quote that rule in my testimony? I'm not familiar with the numbers specifically, so.
You did quote that in a New Energy Economy response to interrogatory that was cited in Mr. Sandberg's testimony about depreciation and how assets should match useful life. Do you recall that?
Not particularly, no, I'm sorry. I mean, if you'd like to show it to me, I'd be happy to respond.
Okay, I might show it to you later. You would agree that the objective of any sound depreciation philosophy should be the matching of expense with revenue over the life of the asset.
No. Depreciation philosophy is to fully recover the cost of the asset itself and any removal cost net of salvage over the life of the asset.
I'm sorry, and any?
Net salvage minus any, I'm sorry, removal cost minus any net salvage over the life of the asset. I think that's what I said. That's the definition that I would use.
Sir, could you please turn to New Energy Economy Exhibit 19, which was your direct testimony in case 22-00286.
This appears to be my direct testimony in Southwestern Public Service from a previous period. I have it up.
I'm just trying to get to it myself. Excuse me for a minute. Excuse me for 1 second. I'm so sorry.
What are you looking for, Ms. Namazi?
I am looking for this page on page 10 of that testimony. Could you look at line 17? And do you see that here you say the objective of any sound depreciation philosophy should be the matching of expense with revenue over the life of the asset?
Yes, I do. You're right. I forgot I'd put that there. Depreciation expense should have been included in that. Anyway, I forgot that was there. My preferred, the depreciation, I mean, cover the remaining amount over the remaining periods is depreciation philosophy. That's a little bit unartful, I think.
Inelegant.
Inelegant, thank you. Okay. But because really depreciation expense or the depreciation studies don't deal with revenues. So it's a little bit unartful to have that in there. Although, the matching principle is known, I know, across the board for utilities.
Depreciation rates can be changed at any time. A utility has the ability to go before the commission and align depreciation rates with the useful life of a plant, like it's doing here with its gas, with a number of its gas plants, correct?
Yes, I believe in New Mexico, it requires commission permission to change depreciation rates, but they could request that as they are here.
Is it your expert testimony that in general, the life of the asset is determined by several factors, including the rate of physical deterioration, obsolescence, weather, maintenance, or in some cases, the economic usefulness of an entire operating unit?
Yes, I would say that those are all certainly what we call failure modes or factors of retirement that could affect an individual asset. That is, I would agree with that.
The function of depreciation is to spread the cost of an asset over its useful life, correct?
Yes, and any removal costs associated with that would be necessary for the asset net of salvage you receive. That's correct.
The objective of computing depreciation is to ensure that customers using the assets pay their pro rata share for the investment, including the cost of retirement, while the asset is in service. Is that correct?
Yes, that is the basic principle, and that we use a remaining life approach means that that future customers will all pay their ratable share of the cost and spread it over the remaining life. That would be the way we would want that to happen.
This objective is achieved by allocating the cost or depreciable base of a group of assets over the service life of those assets by charging a portion of the consumption of the assets to each accounting period. Is that also correct?
Yes, but that describes a whole life approach instead of a remaining life approach, but the concepts are similar.
The NMPRC Commission has a long-standing practice of establishing depreciation rates using a depreciation method based on the actual historical data of the utility. Is that correct?
Yes, where it's available. That is correct.
Is it true that when depreciation rates are set at a level that does not reflect the most current actual life and retirement characteristics of a utility's assets, the cost of the asset will not be recovered on a pro rata basis from the customers that benefit from the use of the asset during its service life?
Well, simply speaking, mathematically, if you are spreading the cost of an asset over its average service life or its remaining life, and instead you spread it over a different period, then the recovery would not be ratable over the remaining life of the assets for the customers. I mean, it's just a mathematical fact. So you're correct in that.
Did you
what's
say ratable?
Ratable,
Ratable?
ratable or rate, yeah, ratable, I mean, I don't know if that's the right word.
Or rate,
Ratably-
or rate,
Ratably over
or-
the remaining,
or rateable for some of us, right?
could be, yes. I am. from-
Same, it's the same word, different pronunciation.
Yes.
Yours is the technical one.
No, ratably is the way I would call it. In other words, spread evenly over the, and if you call it ratably, that's, I would agree. I'll learn it better. Thank you.
No. Your way is better. I just learned. I have to pause, Ms. Nanazi. I just wanted the record to be clear that it was ratable. It is, sounds like rateable. Go ahead.
Is this a potato moment?
I
It
think
was,
is, yes.
totally.
If the life for certain assets change such that there is insufficient depreciation expense under current rates to fully recover the cost of the assets over their remaining lives, then the utility is at risk. It will not fully recover the cost of those assets. Is that correct, sir?
Well, there's a lot of assumptions in your question. So if the life of an asset changes, how do you know it changed? You know, how much did it change? And so if and how long it has left under the remaining life methodology, it really, next time you go in and change your depreciation rates, then you'll start balancing it back out so that there's not the risk there. So I'm not sure exactly how to answer your question. I think there's so many nuances that it's hard to say yes or no to that.
Okay, sir, could you look at the same exact document that I was just referring to? And could you go to page 12? Line 14, I believe.
Mhm.
And do you see that you said exactly what I just read, which is if the life for certain assets change such that there is insufficient depreciation expense under current rates to fully recover the cost of the assets over their remaining lives, SPS will not fully accrue the costs of the assets by the end of the lives of the assets. Do you see that?
I do. I think it was a little different context than the question that you asked, though.
Please explain.
Well, this is specifically addressing, we need to adjust our depreciation rates and we need to adjust our lives. We have studied the lives and we recognize that there is a difference. Therefore, if the commission doesn't allow us to change this when we request it, then there is a risk of over-recovering or under-recovering in the short term. Your question was much more general and I had to respond in a much more general way.
Thank you. Thanks for that explanation. And do you, in that case, weren't you asking to change the useful life of a coal plant?
Yes, I believe that is the case. We were Tulk, I believe it was.
If the commission allows a utility to collect past the terminal date of an asset, even though future ratepayers won't have benefited from the energy from those assets, it would mean that future customers would pay a disproportionate share of the costs to make up for the payment deferrals.
I'm not sure I followed you, and you know, and I don't deal in the collection side of this utility world, so I'm not sure I'm the right person to ask that question to anyway.
Could you
go ahead?
Could you please look back at the same document and to the next page, and just following what we had just discussed, you said this in turn means that future customers would pay a disproportionate share of the costs to make up for the payment deferrals. Can you explain that?
And it's a slightly different question again than what you asked me. It's along the same lines. It's that if you're going to spread the cost of an asset over its remaining life, you know the remaining life has changed. You're asking the commission to change the life, and the commission, for whatever reason, doesn't. Then there is a intergenerational inequity that could incur for the depreciation expense. So yeah, I mean, that also is just, math.
Perfect, because that's what I was going to ask you about next, which was intergenerational inequities. Do you believe that artificially extending the life for depreciation purposes past the time period for which an asset is being used is in direct violation of sound depreciation practices?
I do, because depreciation is to recover the asset cost over the remaining life of the asset, not a longer period as suggested by another witness in the SPS case.
And that would apply to P&M as well, right?
Well, I know I did a bench request to move the life of 4 units longer than what P&M is asking for. So to the degree that, that movement is not based on the life of the asset, it would violate depreciation theory and policy, but that's a policy decision, not then a depreciation decision.
But determining the life of the asset is the rub, isn't it?
Yes, to some degree. In P&M's, I'm sorry, in SPS's case, the interveners didn't object to the life. They just said, we want you to move it out anyway.
And move it out, you mean the Toke station?
Yes, to a longer life than what the company actually was planning to retire at. I'm sorry.
That station is spelled TOLK?
Correct.
Go ahead, Ms. Manaz.
Could you explain what the problems are if there is not symmetry between the terminal date of the asset and the depreciation schedule?
I mean, so so you're asking what problems are created if your depreciable life and your actual life are different?
Yeah, like one of the things that you just said is it would lead to intergenerational inequities, right? That's one of the things you said, correct?
Well, since we're talking about SPS, I guess, and the plant Toke, the intervener wanted to move, I forgot how many years out, the recovery period, not objecting to understanding that the life really was what it was, but they just wanted to move the period of recovering the assets out. In that case, there's multiple problems. Once the unit retires, then you have to flip it to the remaining amount to a reg asset in order to finish recovering the cost. So there's a lot of challenges, and the true up of the decommissioning costs. So I'm not sure where you're going, but there's a lot of different factors, accounting and otherwise, that would be required. In addition to people that, in the case here, where they're artificially moving the period of recovery out, would have people that didn't get used to the asset having to pay for it. And that's a policy decision, not a depreciation decision.
Correct. And so isn't one of the other things with if the asset has a terminal date that's like in 2031, but the depreciation rate is till 2041, doesn't that also artificially deflate the current rates?
Not necessarily. The rate is a static, a rate is is static when you create it, but it changes as soon as any fact and circumstance changes. So therefore, if investment, if you take sort of a generic generating unit, the further it goes toward the end of its life, the higher the depreciation rate needs to be, because it's got a shorter term to recover it. So it wouldn't necessarily deflate the rate. It all depends on the facts and circumstances and the specific calculations. So it could
But
go.
can I just ask you something? But can I just ask you something? I'm sorry.
Let the witness finish his answer. We can't cut him off.
I know. I was just trying to.
I know. I just, let's
Go ahead,
be
please,
polite.
please.
I'll try and be polite too, because
Please answer.
be-
Please finish your answer, sir. I
Thank
just
you.
was trying to ask you about that first part of your answer, but go ahead.
So I mean, absent specific facts and circumstances, yes or no to it, that may or may not be correct. I can't speak to that without other facts.
Okay, so what I think you just said in the first part of your answer was that there are some situations where at the end of the useful life, the depreciation rate will be higher because you have a shorter period of time to finish payment. Is that correct?
I didn't say it that definitively. I said it can be shorter, it can be higher, it can be lower. It depends specifically on the facts and circumstances, and there are a number related to resetting depreciation rates at the time.
Correct. But if the terminal date of the asset is defined, but the depreciation goes past that asset life, doesn't it mean that the previous rates up until the terminal date have been artificially deflated, meaning it doesn't account for the entire life of the asset?
Not necessarily. It depends on the facts and circumstances in the last portion of the life, whether the rate would be higher or lower than it needed to be otherwise. It's not a generic statement that you can say definitively.
What objective do you recommend a regulatory authority seek to achieve in setting depreciation rates?
I think I've probably quoted it 2 or 3 times in testimony. I could find it for you so that I don't misquote it again. But I mean, our goal is to recover the cost of assets and their removal costs over the life of the assets. I mean, that's a depreciation study goal.
I have no further questions. Thank you so much, sir. I really appreciate that.
You're welcome.
Thank you, Ms. Nanazi. Hearing Examiner Ryan,
Yes.
anything for
Oh,
Mr.
for
Watson?
Mr. Is Ms. Nanasi our end of our, just one question for Mr. Watson.
Yes, sorry about that. We've concluded the cross-examination.
Um,
And while Hearing Examiner Ryan's looking for what he's looking for, Mr. Watson, would you be available to testify later on in this proceeding if the commissioners have questions of you?
Yes, I certainly will. I have 2 or 3 other cases that I'd have to work around that have hearings in the next couple of weeks, but I am at your disposal if necessary.
Thank you, sir.
You're welcome.
So going to your direct testimony, Mr. Watson, page 17. Beginning down there at line 19. So as I understand, I just want to make sure I understand correctly your part in this process. P&M management, whatever term you want to use, that made a decision about increasing the depreciation rates for some of those assets. And you're acknowledging that that's what you're doing?
Well,
The terminal retirement dates for the
changing-
various generating? Yep.
Yes, in depreciation studies dealing with generation fleets, I will rely on the company to be the primary judge of when those assets are planned to be retired. And the company is who provided me with those retirement dates.
And those are the gas-fired legacy units that PNM's proposing to have earlier terminal dates, is that correct?
Yes, they provided those terminal retirement dates to me to calculate depreciation rates based on those expected dates.
Okay, so they give you the numbers and you got your marching orders and you crunch the numbers.
Well, it sounds like we don't do any work, but we actually do. I mean, we do talk to them about it to make sure that, we're comfortable that they have a good process and they're thinking about it. But they do, in the end of the day, tell us, here is our expectation for the retirement date of the generating units. And then we do the rest of the work to calculate depreciation rates for those units.
Yep. Okay. That's all I wanted to know. Thank you.
Thank you, Mr. Ryan.
Yep.
Mr. Williger, any redirect?
Yeah, just a few questions if I can.
Sure.
Mr. Watson, yeah, you were asked a question by Mr. Herman with the Water Authority regarding input from the subject matter experts. Do you recall that question?
Yes, I did.
And just generally speaking, not for any specific account, but when you're provided information from the PNM subject matter experts, does that change your recommendation or just inform your recommendation in terms of depreciation?
It informs my recommendation. What I typically think of and I teach is that a recommendation should be based on a three-legged stool. One of them would be your analytics. And that's very important, especially here in the few cases where you do have a statistically valid sample, to have that. So we will see, for example, a life changing, moving upwards or downwards. That's one part of the stool. The second leg of it would be talking to operations people about what's going on operationally to make sure that if we see a life changing, we want to be able to understand what operationally is happening that would make that life change. In other words, let's say your life is going longer for transformers. Well, are they starting to do more oil testing and fixing problems before? There's a lot of things that can drive lives down or up. And part of the operational, I guess, what we talk to them about is there something that would, if we see the statistics moving, does it make sense from an operational standpoint as well? So it informs and helps to I guess, prove what the appropriate life is by understanding operationally what's going on with the assets as well.
Okay. And questions from Ms. Nanasi, you said that you answered a question about practice, whether the commission has a practice of using actual lives. Do you recall that testimony to set using the actual lives to determine depreciation? Do you recall
Yes.
that? And you
Yes,
made a
sir.
qualification of saying where it is available. Can you kind of explain why you made that qualification of where the actual information about the lives of the assets in a certain account, why you made that qualification of where available for that?
Certainly. So there are some accounts that frankly have very few retirements, like land rights, and there's some that very seldom get touched. And when that happens, there's not actual data, in other words, to analyze. In other cases, like 7 out of the 8 that Mr. Garrett had challenged, there wasn't sufficient data to have a statistically valid sample to be able to do actuarial analysis. So you would want to discount that. Fortunately, in some of those cases, we did have enough to do SPR analysis. But so there are different times and different places where there's a different amount of information available. Sometimes all you can do is rely, if you have nothing, on me being an engineer, my understanding of the failure modes of the different assets within an account, what the mix of assets is in the account, and the expectations for the life of the different types of property within the account. That's sort of if you will, the least case scenario where you have nothing, you have no real data to use to analyze.
Do you know if the commission has used your SPR or adopted the use of your SPR analysis in prior cases?
Yes, in repeated cases. In the last case here before this commission for PNM, we used PM, and the commission understood well that that was the appropriate analysis methodology at that time, and hopefully they understand this time it's the same.
Okay, and sorry, one more, it might be two questions, hearing examiner, and then I'll be done, I promise. You were answering questions about account 391.3 with Ms. Gould. Do you recall that?
Yes, I did.
And she pointed you to a data request, which now will become it. It was the response to NMA area 5.4, and now for hearing purposes, that will be cross-examination exhibit or NM area cross-examination 42. Do you recall that?
I do, yes.
And you stated in response to her questions that there were some limitations on data in that account. Do you recall?
Yes.
And I think it referred you to a prior discovery request, your response to NM area 1.6. Do you remember what the limitations on data are in the account, or do you need to refresh your recollection by looking at your response to 1.6?
I know, I remember.
Okay.
I believe it was the same response, only part A instead of part B.
Okay.
If it's 6 or 4, whichever one the spreadsheet came from, it was, and it spelled out the many of the things in the account have specific either in some cases it may say a software name, but it's the hardware associated with the software. And so that was sort of a limitation in understanding what it is in some cases. In others, the company has moved to something called AR-15, Countering Release 15, which is FERC allowed, and this commission has allowed in the past as well, where certain accounts like that one, they don't have to keep what we call retirement unit listings to the detailed degree that they had in the past anymore. So a piece of hardware, computer hardware that's capitalized into account 391.3 doesn't necessarily have to have a detailed description on it. And so that was one of the reasons we couldn't fully respond to the request. They asked to break out laptops from servers from the other hardware in the account. We couldn't totally do it because those detailed descriptions were no longer required to be a part of the CPR, the continuing property record for that particular account.
Okay, that's all my questions. Thank you, hearing examiner.
Thank you, Mr. Williger. Mr. Watson, thank you very much for your testimony. I thank you for remaining potentially available for examination by the commissioners later on in the proceeding. It will be discreet, and we will work out your availability if you are available with counsel for PNM. Commission and the hearing examiners truly appreciate your testimony in this case. Thank you, sir.
Thank you.
You're provisionally excused. Thank you. All right. PNM attorney, not Ms. Terwilliger, but Ms. Terwilliger. Yes.
Yeah, Mr. Alvitris will come on, and then I just think that Mr. Watson's going to have to leave that witness room and be replaced by Ms. Mendez. So
Okay,
you
that
could just
sounds
give us
good.
a few minutes, please.
Okay. Well, how long do you think it'll take? Should we take a 5-minute break?
Guys, if we
Or
could
is
have
it-
10 minutes, I would appreciate it.
10 minutes, of course. We're in recess for 10 minutes. Sorry, Mr. Alvitris.
No, thank you.
10
Thank
minutes.
you.
Hearing Examiner Ryan. I noticed that Commissioner Aguilar is here.
Yes.
Oh, and yes. Oh, so you know that we might not be putting on another witness. Just one of the other ones. I don't know.
I don't know. I don't know if Commissioner Aguilera had particular questions for,
One of the other two.
yeah.
Okay.
I don't either. At least I should maybe check my email to see, but
I didn't receive any communications. He may just want to attend to, be present for questioning. So.
all right. Mr. Alvidrez?
Yes, Mr. Hearing Examiner,
Are we ready to proceed?
we are. And here is our next witness. We would like to call Sheila Mendez.
Ms. Mendez, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter no pending to be the truth, the whole truth, nothing but the truth.
Yes.
Thank you, ma'am.
If I may proceed.
Yes, sir.
Ms. Mendez, will you please state your name, employer, and position for the record?
My name is Sheila Mendez with PNM, and I am currently the Executive Director of the Enterprise PPMO.
And Ms. Mendez, did you prepare pre-filed direct testimony dated December 5th, 2022 that was filed in this proceeding?
Yes, I did.
And can you confirm that what we have marked as PNM Exhibit 21 is a true and correct copy of your pre-filed testimony in this case?
Yes, it is.
And is your testimony true and correct to the best of your knowledge and belief?
Yes, it is.
Mr. Hearing Examiner, we move the admission of PNM Exhibit 21 into evidence.
Is there any objection? Hearing none, PNM Exhibit 21 is admitted.
Ms. Mendez, when you first introduced yourself there, I just want to make sure, just for benefit of our court reporter on the record, you said you're the Executive Director of the EPMO, is that correct?
Yes, sir.
And that's the Enterprise Program Management Office within
Yes, sir.
PNM.
Yes.
Thank you.
Okay, cross-examination of Ms. Mendez. We have the county, Mr. Albright had 5 minutes, but I don't think he's in attendance. Is that correct? So we're going to skip Mr. Albright and move to the Water Authority. Mr. Herman, you have 10 minutes.
That won't be necessary. Aside from wishing Ms. Mendez a good afternoon, I do not have any questions for this witness.
All right, then I'll delete those minutes. Thank you, Mr. Herman. So next up is Mr. Elliott, the Attorney General.
I likewise have no questions for this witness. Thank you.
Thank you very much, Mr. Elliott. Next, and that's it, is it? Or because, yeah, that's it, because Mr. Albright being unavailable in Rehoboth, Ms. Mendez, that concludes, unless, again, that concludes the examination, unless the commissioner or hearing examiner Ryan have anything for you. Commissioner Aguilera?
No, I do not.
Thank you, sir.
Nor do I.
Okay. Ms. Mendez, thank you so much for your testimony. You're excused.
Thank you.
Thank you. Now, Mr. Aguilera, did you have any questions potentially for Mr. Graves this afternoon?
Yes, I mean, Commissioner Ellison asked a lot of the questions that I, wanted to ask, but I think he also said he might have more. I didn't see him on here.
Okay, so Mr. Alvidrez, would it be possible, is Mr. Graves in the building, literally or figuratively?
Yes, he is, per your instructions. He stayed and is ready to assume the stand if you'll give us just a couple of moments to switch.
Yes. Thank you so much. I appreciate it.
Thank you.
Mr. Hearing Examiner, are we going to be discussing the response from PNM today of the bench request number 3, or are we going to be doing that tomorrow?
Was it just filed today?
Yeah, just a couple of minutes ago.
And what do you mean discussing it?
I don't know that I should answer it, how I can answer that question without saying what I wanted to say, but are we?
Well, why don't you go ahead?
I just want to know if there's going to be a discussion about it.
No, I think what I had indicated to Mr. Gould was when something is filed like this, it's reviewed, and then by the next morning, so Friday morning, if there are issues with it or whatever, we'll discuss it then. Isn't that what I said before?
Yes, that's correct. I'm sorry.
Okay, go ahead. Excuse me. Let's move on. Mr. Graves, thank you so much for being willing to be recalled. I'm going to pass the baton to Commissioner Aguilera. Go ahead. Go ahead, Commissioner.
Mr. Graves, thank you for coming back. I appreciate it.
Happy to help.
So I guess earlier we were talking about in your direct testimony, PNM figure FG4, having savings for retaining.
I'm sorry, Commissioner, I can't understand you. If you could get closer to the microphone.
Let me close my window. Is this better?
Yes, sir.
Okay, sorry, I think it's probably my window being open. Mr. Graves, earlier we were discussing figure FG4 in your direct testimony titled Savings from Four Corner Power Plant as of 2012. And I wanted, go ahead.
We're still getting
Yeah.
some feedback or.
Really?
Yeah.
It doesn't seem to be as present when you look at the screen. It's when you're looking down, it seems to happen. I don't know if that's.
What about now?
Much better.
Okay, I changed my microphone. Sorry about that.
That's great.
Maybe Mr. Alvidrez could put his mic on mute.
Actually, what I want to ask about is with respect to the carbon price outlook, which you discuss, I think, on page 35 of your direct testimony. Can
I have it?
You explain how you came up with that outlook and what variables, or PNM came up with that outlook and what variables were being considered?
Sure. Well, again, what I'm trying to do here is update the May 2012 analyses with perspectives on the drivers of costs that might have changed over the next 15, 18 months. Right. And carbon prices would be one, because PNM, like many utilities, puts a penalty on the carbon emissions from its generation to try to discourage selection of those resources. And what had happened there is that if you looked at the way carbon penalty pricing was happening in May or in early 2012 compared to later in 2013, the industry had shifted to apparently using lower prices or later prices for when they thought carbon would be imposed as or carbon penalty tax would be imposed. So I just basically incorporated that adjustment into the numbers that PNM was previously using, either by just lowering them $5 per ton or by delaying them to 2020 and then starting with a lower rate. And I guess that had to do with emerging beliefs about policy and changes in technology and a lot of things. But across a survey of many utilities, that seemed to be the direction. So this was just saying if you moved in that direction here, you would find less penalty against the coal plant. Some still, but not as much. And also some, of course, against the gas plant, but because it's less carbon intensive, the net effect is to improve the relative appeal of the coal plant.
Okay, I was actually looking at FG10. I think I said FG4.
Oh, sorry, I was looking at FG9, which shows actually the change I did make into those numbers, but FG10.
On page 39.
Yes, I have it now. Yeah, that just simply does the present value calculation of those alternatives.
Okay.
So just to make sure it's easy for you to understand, there's a blue bar there that says 33 in the middle of it, up the next to last bar in the waterfall or progression of bars here. That's the one that says the present value of the reduced carbon cost makes the coal plant $33 million more attractive than it otherwise would have been, and in relation to the gas plant.
Okay. And then in terms of other, I guess, non-economic factors, right? Because we're placing a value here on things like changes in gas prices, carbon price, things that can be projected and somewhat quantified. In terms of other factors that might not be as easily quantifiable, are those considered at all?
Sometimes things, in particular, community impacts are looked at when when you're wondering about things like closing a particular plant. You may recall that there was, or may be aware, there was quite a bit of discussion about that surrounding the San Juan station because of Farmington being interested in possibly taking it over, and just general awareness that there was a substantial labor dislocation problem that would arise. So that is sometimes evaluated and not usually as a monetary adder to these kinds of things, but it's like, well, sort of as a tiebreaker. If we otherwise are close to deciding and there's a side effect that we don't like, then we could, or a side effect we do like, I guess. The reverse is also true. Sometimes you see proposals where people say, well, the good news about building a lot of renewables is there's going to be a lot of new jobs. So that calculation goes both ways.
But that's not the social cost of carbon.
No, these are more qualitative side effects.
Those were discussed extensively in the Four Corners abandonment and securitization proceeding as well. Right, but that's not, we also address though the social cost of carbon, right?
Oh, sure, yeah, and in a way, this carbon penalty is a kind of a watered down version of the social cost of carbon. Nearly everyone who has studied that, who's not a complete cynic about global warming, thinks that the social cost of carbon is quite a bit higher than 10, 15, or $20, more like 60 to 100 or possibly more. It's a very difficult number to estimate because it depends on how quickly you think climate pain and adverse impacts will occur and how readily they can be mitigated. So if you think there's a lot of forecasting here, that really is a big forecast. But usually those are big numbers. And the thinking in these penalties that people add is that we're not quite there as a society to being ready to impose those kinds of fees on carbon. So let's put a sort of a starter penalty on to just see what they do.
Okay. And to provide some context as to why I'm asking is, earlier in the testimony when Commissioner Ellison was asking questions, I was sort of hearing that, there is some uncertainty, and depending on how you look at that uncertainty, the savings to customers are either higher or can even be negative. And so in a situation like that, I'm just wondering, when is it appropriate then to start thinking about other potential benefits that cannot be quantified as easily as you suggest, like jobs or health benefits?
Right.
Yeah, go ahead.
It's a really good question, and I don't think there's a great agreement on the result. In some ways, when we put on an externality penalty like a carbon tax, it's a surrogate for some of those things like health effects and economic disruption that the climate problems could eventually cause. But if you, I think maybe what you're getting at is if there's just a lot of risk surrounding the thing, how should we? Can we do anything about that? And really, there's only, I think, two things to do. One is you can see if there's less risk in some other strategy. All of them are going to have some risk where you say, we think this is what it's most likely to be worth, but circumstances change or we can't predict them all. So it's in some range. Sometimes utilities decide they like the thing that has a narrower range, even if it's a little more expensive because it seems less volatile and more likely to confirm their expectations, and they make that judgment in conjunction with their regulators and interveners. So that's one approach. Sometimes the other is you can hedge out some of these risks to a degree. So you could hedge out, for instance, gas prices for a little while. There's no way to hedge out carbon price uncertainty, for instance, right now. I guess there is in California if you have a market in it, but even those markets get to be quite thin pretty quickly, so you can't hedge a lot of it. The other thing you can do is you can look for optionality in your plan to say, well, what happens if we get towards the tail of one of these distributions and things cost or are just looking a lot different, could be better or could be worse than we expected. Can we cut our losses or can we double down on the things we like if it gets to be extreme? That's a kind of an optionality analysis that sometimes is done. If risk is your main concern, then you would normally add that to your calculations. That's a pretty complicated analysis, though. So it's not normally done unless risk is the thing that's scaring you off.
Okay. Thank you. Where in your testimony would I be able to find so you've quantified, for example, the savings of the plant. Is there a quantification anywhere about the alternative at the time to, procure additional resources? It seems like you gathered information to, calculate the savings, but is there any information that you have as to how you would have calculated going in a different approach and, what the cost or savings to ratepayers would be?
Okay, yeah, so just to make sure you're interpreting my charts right, these are the differences in costs between choosing strategy A versus strategy B, coal plant versus gas plant, under different stresses of different kinds. If gas prices are higher, how big are the savings, or which one is cheaper? So these are already comparative cost numbers, and the only question of savings is if one of them is persistently cheaper than the other, then there are savings from choosing that one. So here there would be savings from choosing the coal plant if the bars ended up above the zero line in the middle, which they happen to do so in this reconstruction that I did. If the bars end up below, then under those conditions, the savings go the other way, and it would be cheaper to have the gas plant. And you can see that could happen in these, even in the chart that I have on page 39.
Okay.
At least with respect to these variables and the ranges that I considered, there were more savings from having the coal plant. Not hugely, but some.
Mm-hmm. Okay. Well, thank you. As I said, Commissioner Ellison earlier asked a lot of the questions that I was, I sort of had in my mind. So I appreciate you coming back. I don't have further questions right now. Hearing examiner, I do see that Commissioner Ellison is on. I don't know if he has a question.
Yes, sir. Thank you, Commissioner Aguilera. Commissioner Ellison?
I just had a thought, given that I unfortunately wasn't able to listen to the questions that have been asked Mr. Graves, and given that I would rather not, go over the same ground, I'm wondering if it would be appropriate that I might be allowed to look at the transcript from today, and given that we're doing this on Zoom, if I have any additional questions, if Mr. Graves could appear once more for a short time on Zoom. I don't think he has to be in Albuquerque to appear on Zoom. Is that correct?
It would be fine with me. It would need to be on particular days. Next Monday through Wednesday are fine, but on Thursday and Friday, I'm traveling to Indiana and Chicago. So, and then the week after that, I'm still available. So I'm sure we could find a time if that's convenient for you.
This is one of the reasons we're getting expedited transcripts. So as soon as we have that transcript, we'll get it to the commissioner.
That would really help me. I just like to spare Mr. Graves from going over the same questions he's already had, and just think about whether I would like to do some more questions or not. That would be helpful to me.
Sure, more than
Abs-
happy to respond. That would be fine. I would like to make sure you understand what I've done, and whether you agree with it or not, that's to be determined.
Great, thank
I-
you.
We appreciate your cooperation very much, Mr. Graves, in this endeavor.
Yeah, no, it's an important issue. I'm happy to help.
We never asked your attorney if this was acceptable
Oh, good point.
to the company. We should do that.
We absolutely have no problem whatsoever. And Mr. Graves has confirmed his availability. We'll work with you all to make it happen.
Terrific. Let's, between hearing examiner Ryan and myself, let's look for this transcript to make sure it's forwarded to the commissioners as soon as we have our hands on it, or at least it's in our inboxes. So with that, Mr. Graves, look forward to perhaps seeing you again. If not, safe travels. It's always a pleasure to have you. You're always agreeable, even when some of us are not as agreeable. So
Well,
we appreciate your good humor, sir.
Thank you. That's very nice. And I appreciate the care you guys put into, thinking about this. So it's, I understand that it's a charged issue.
7 years in the running.
Yes, exactly.
All right. Well,
Maybe
thank
this
you.
will be the last bite at it. Maybe we can figure it out this time.
Right.
Thank
Thank you.
Thank you. Take care.
Thank
You're
you.
provisionally excused, of course.
Yep,
Thank
got it.
you. Okay, thank you. All right, do we have time to potentially? I know, Mr. Alvidrez, I saw that. I'm trying to move us. I'm trying to keep the train moving. We got some progress today with Ms. Mendez. Is it possible that your next witness might be able to? Let's see how much time we have with him. I say him because I think that's, who do we have next?
If he is here, it would be Mario Cervantes. Ms. Terwilliger will be presenting him, and so perhaps she can sign on and let us know. I haven't seen him today, so I'm not positive.
Okay, well, let's just very quickly see. And while we're doing that, Ms. Gould had her hand up. Ms. Gould?
I'll wait till the end of the hearing. I just had a few just questions about random things.
Ms.
I can ask them now. So I'm looking for PNM bench request 1. Has that been distributed? Did I miss it? No? Okay, great.
No, we bench request 3 though today, which Ms. Nanazi pointed out. And again, what she asked about, should we talk about that now? And I said, no, I think the sort of informal rule I set was with your co-counsel was that if you have issues with, or whatever, want to respond to it, need to do so by the following morning after it's been filed in the record.
Right, that's why I
Assuming-
was asking.
Right.
In case I missed it. And then where can the transcripts be found? I know that they're expedited, but I haven't seen any. Has there just not been any yet? And will they be on the commission website or where are they?
Mr. Alvidrez, do you know?
Well, we haven't gotten any formal transcripts at this juncture.
Yeah.
We've gotten the overnight drafts, which, of course, we've been paying for. And I understand, you all being the hearing examiners have gotten those as well.
Right. Okay. Right, but not the official, transcripts. When we get the galleys or the unofficial transcripts, those I don't know the arrangements for that, Ms. Gould, with counsel and the court reporter. So I don't want to step
Judge, if
into
I
something.
may, Judge,
Yes,
if I may,
please.
the first day should be filed later today.
Okay, thank you, sir. Thank you, Mr.
Fi-
Reed.
Filed at the commission and the NMPRC website? Is that where we would find them?
If I can speak off the record, my understanding
Am I frozen?
Mr. Lee is.
See what we do to him?
Yeah, this was all day seamlessly, and then the one time. Oh, there he is. He's back.
Could you repeat yourself, Mr. Lee? You froze.
My understanding is I have to submit them to the PRC and they are then uploaded. Since it's 5 o'clock, I don't think that will happen till tomorrow morning. You get the first one tomorrow, and it's my hope that you'll have the remainder of this week by the end of the weekend.
Okay, and I'm not trying to rush you. I just wanted to know where to find them. So I really appreciate that. Thank you.
You bet.
I have one other question, but I see that Ms. Terwilliger is ready, and so I'll hold my question. Thank you.
I would, Mr. Hearing Examiner, I mean, I do have cross for Mr. Cervantes. It will take us past 5 o'clock. I don't know how late you wish to go.
You have 20 minutes?
I will use at least I would use most of my 20 minutes.
Okay. We did take a break. Mr. Lee, could you go a little bit over 5 to see if we could keep it moving, or would you prefer to stop now? I hate to put you on the spot, but I'd like to try.
Forward. I can go forward, Judge.
Okay. So let's do that then. TNM, would you please call your next witness?
Yes, PNM calls Mr. Cervantes. Mr. Could you state your name?
If I could swear the
Oh,
witness.
Sorry, I keep forgetting that. Go ahead, Mr. Lee.
Mr. Cervantes, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Thank you.
Good afternoon.
Good
Can you state your name, spelling your last name and your title for the record, please?
Yes. Mario Cervantes, Cervantes, and I am the Director of Customer Experience with Public Service Company of New Mexico.
And Mr. Cervantes, do you have what's been marked as PNM Exhibit 29, which is your direct testimony filed on December 5th?
I do.
And was that prepared by you or under your direction?
It was.
Any corrections to the PNM Exhibit 29?
No corrections.
Okay. Is PNM Exhibit 29 true and accurate to the best of your knowledge?
It is.
And if I asked you those same questions today, would your answers be the same?
Yes.
I request admission of PNM Exhibit 29, please.
Any objection? Hearing none, PNM Exhibit 29 is admitted.
Thank you. And you have before you what's been marked as PNM Exhibit 30, which is your rebuttal testimony filed on July 28, 2023.
Yes,
And was that prepared by you or under your direction?
it was.
Do you have any corrections to PNM Exhibit 30?
I do not.
Okay. And is that testimony true and accurate to the best of your knowledge?
It is.
If I asked you those same questions today, would your answers be the same?
They would.
I request admission of PNM Exhibit 30.
Any objection? Hearing none, PNM Exhibit 30 is admitted.
I tender Mr. Cervantes for cross-examination.
And first up is Mr. Elliott. Good afternoon again, Mr. Elliott.
Good afternoon.
I have you down for, where are we? I'm sorry, 15, was it 15 minutes?
Yes,
Okay, go ahead.
thank you. Good afternoon, Mr. Cervantes.
Good afternoon.
Thank you for making yourself available so late in the afternoon. I'll try and make this speedy. The company is proposing to socialize the cost of credit card fees among all PNM customers instead of only charging customers that actually use a credit card to pay their bills, right?
Correct.
And the cost of the proposal, it's about 3.1 million.
Yes.
Is that right?
Yes, roughly.
So if a residential customer signs into the PNM portal and pays their bill directly from their bank account online, there's no charge for those payments. Is that right?
No charge for the ACH payments. That's correct.
That's called an ACH payment?
Yes.
Okay. And ACH, for the record, means?
It's the automatic clearinghouse. So it's the method that's used.
Okay. And if a customer signs up for automatic debits to their bank account, is that also a fee Is that an ACH fee?
There is no fee for automatic payments. That's treated the same as an ACH payment.
Okay.
Yes.
What percentage of residential customers pay their bills online through ACH without incurring any fees?
I believe I have those details included in my testimony. Give me 1 minute. Let me look at that page. That's, we don't have those broken down by method. Those would be included in the electronic payments category that I included on page 22 of my direct testimony. Everything that's considered electronic is categorized under there. And I don't have the specifics on the breakup of those different electronic methods, which again, one of those is ACH.
Okay.
The other one incurs a fee, though. The other method, right?
There is the credit and debit card fee, and then there's also a fee for ACH payments made via the automated phone system or the IVR, and that's also explained in my testimony. So in other words, the only way that customers are able to pay for free using their ACH is via pnm.com by logging in.
And the checking account.
And their checking account via the automatic, payment process.
Go ahead, Mr. Elliott.
And so let me just follow up too, but Mr. Cervantes, if I understand what you've just told us there, you don't know the total number of customers that pay by credit card and incur the fee, or do you?
No, I do know that information. That's actually included in my testimony as well.
Okay.
The information that I don't have available to me now is how much of the electronic payments that are made via ACH. I do have the information on how many are paid with a credit via credit.
Okay.
Can we get a granular breakdown of that, though?
Yes, we can get that. We can break up the.
Yeah, we want to see customers, like certain customers that I know pay that way to avoid the fee, right? So that's one category. And then we have the other categories. Can you provide a granular analysis of that?
I can, we can divide those by type.
Right.
So,
and I don't recall, Mr. Cervantes, real quickly with that, as you're formulating what you're going to provide, the other question I had, and it may be in your testimony, and you can answer whether it is or not, but the percentage of the residential class that pays, I guess we have it electronically, and we just don't know how we get down more granular breakdown. And I guess, okay, so I think what we're talking about is all that we should need to know. My apologies.
No, it's okay. And in case you're interested in the information, page 11 provides the information on volumes for credit and debit card payments. And it's at the bottom of page 11 in my testimony. So it's all listed there.
And those are for annual. Those are annual, right?
Those are annual. Yes. So in 2021, for example, PNM customers made a total of 5,559,000 payments, and 12% of those payments were made using a credit or debit card.
So are you saying this is that information?
No. This is just credit and debit card numbers.
Okay.
Right.
Okay. Yeah, but we want to determine how many customers are using the ACH checking method versus the other methods that incur charges, and be as granular in the categories as you can, please, in that. And Ms. Twilliger, what can you help me out? Is that bench request number 5?
Yes.
Okay, BR5 is issued. Thank you very much, Mr. Cervantes, for agreeing to provide that.
So can I just clarify, you're looking for the most recent data, I would assume we have. And
Yes.
how many customers pay via ACH? Perhaps some people who have their checking account debited, it. Mr. Cervantes can tell me if that's, if he can break it down that for our, that's what you're looking for, the percentage of total.
And
payments?
also the dollar impacts. Put figures around that if you have them.
Dollars in terms of total amount of payments?
For the categories,
Okay.
not for the
Yeah, we may be able to get it to that level, but I would need to confirm.
Okay,
Yes.
thank you. Mr. Elliott, go ahead. Or unless Ms. Twilliger, you have another question.
No, we'll work through the issue and let you know.
Thank you. But that is bench request 5, right?
Yes.
Okay, thank you. Okay, go ahead, Mr. Elliott.
I think maybe some of the questions I was going to ask here might be relevant, Mr. Cervantes, such as, what percentage of customers, residential customers are sending in checks?
So I do have that information in that same graph that I referenced earlier, page 22. And so that's in the category of mailed payments. So those would be the check payments made via check. So you can see there, I think in 2021, there was a little over 20% of payments made via a check mailed in.
Right. And okay, so I'm looking at line 9 where it says 73% of customers opted for an electronic method. Is that where you're?
Yeah, so that's also in that graph. You see the bar graph on the left, the 3 columns there. Those represent the years for the electronic payments. And so the lighter shade is 2021, and that, that's the 73% of payments that were made via an electronic method, which again,
and that would, I'm sorry to interrupt you.
Yeah, that would include credit cards, ACH, paying directly from my account, for example. If I go to my bank and set up a payment, that would be considered an electronic payment as well.
Okay. Well, let me just move on to my other, I have questions such as, what percentage of PNM customers currently pay by credit card and incur a fee?
Yeah, and that's again in the information I provided on page 11. Okay. So if we look at 2021, I don't have the most recent numbers, but again, these are pretty consistent year by year. About 12% of customers that paid in 2021 paid via a credit or a debit card and were assessed a fee.
Okay. So am I right that it's the company's expectation that more people would actually pay their bills if electronically, if the fees were eliminated?
Yes, that is our expectation, and we're basing that on several things. One of those is the customers are demanding it, right? The customers have told us that that's what they would like to have, is the ability to pay for free, and it's pretty clear in the customer research data that we have. And then also the industry data that we have available to us tells us the same thing, that once you make those payments free of charge, then there is an increase in adoption as a result.
So they think it's free of charge, but then it becomes part of rates, doesn't it?
Correct.
Nothing's free. There is no free lunch.
Right.
Okay, go ahead, Mr.
And so I guess to follow on, the company also believes that this would reduce uncollectibles?
We did not include any discussion on that. We don't have the data to really come to that conclusion. So that's not what, part of what I discussed in my testimony. So no, at this point, we don't.
Do you have the, I'm sorry. I want to make sure that the bench request incorporates this if it's not already in your testimony. The amount of the actual fees as well as the overall aggregate dollar impact or amount, the actual current fee. Is that included in here somewhere? In your testimony?
Yeah, are you talking about the amount that the customers are incurring currently?
Yeah.
Oh, yeah, that's
yes.
it there.
Okay.
It is.
Okay, go ahead, Mr. Elliott. I'm sorry.
All right. Mr. Savani, you're aware that the company made a similar proposal in 15261?
I am.
Did you read that corrected recommended decision?
Yes, I did. It's been some time that I read it, but I think I got the gist of it.
Okay, there's one portion of that that I wanted to read to you. It's from page 135 of the recommended decision, and maybe this is the part you probably recall. It's PNM's request for approval of a regulatory asset for costs incurred to implement a credit card program should be denied. Accepting credit card payments is a convenience to those customers who pay their bills via credit card, and the costs associated with accepting credit card payments should be borne only by those customers who pay their bills via credit card. Is that the part that you remember?
Yes.
Okay. So in your rebuttal, you state that customers complain about credit card fees, and you attached the 2 surveys and some email comments. Okay. And I just want to ask you about one of those comments. It's PNM exhibit MAC1. It's your rebuttal, in your rebuttal.
Okay.
And it's page 33 of 35. Let me see if I just want to make sure I have it right here in front of me.
Is it ITSUX?
It's the last comment at the very bottom of the page. And it's where it says, maintain your website free pay options. It appears to be a scam when your website is down, but you can pay with a fee. So I just want to ask, does it go down that often that people cannot pay their bills online for free?
The website, meaning the website?
Yeah. How frequent is that problem?
No, it's not frequent. I mean, our website is pretty reliable. So, that may have been an experience that the customer had at one point, and maybe is using it as a reference to indicate that, he's trying to find a better solution. But that's not a regular occurrence at all.
So if the website goes down, is there still a free option or no fee option, I should say?
An electronic option? No, the customer could go directly to their bank and set up a payment, and that payment would still be submitted. That may take a little longer time. So electronically, that would be the only other option. I mean, I'm guessing they could go into one of the retail payment locations that are available and make a payment that are free of charge. But that would
not electronically. There's not another electronic.
Right. Not for free.
Okay. And just in reviewing the survey questions, one thing that struck me is there wasn't a question that asked people that don't use credit cards how they would feel about paying a portion of other people's credit card fees. Did PNM explain in the survey how the cost would be socialized?
I don't believe we went into details in terms of, what we would be proposing in this case. The survey, just to clarify, did go out to both customers that have paid via credit card and customers that haven't paid via credit card. So it was a random list of customers that we selected, regardless of payment methods that they've used. So there were customers in that population that, perhaps have not paid via credit card, that were asked a question about, their preferences, satisfaction with fees, those types of questions.
Those are all the questions I had for you, Mr. Cervantes. Thank you very much for your time this afternoon.
Thank you.
Mr. Cervantes, one follow-up question before I move to another. Do you know why, at least in the testimony, do you ever explain what is the driver for payments by credit cards that people incur fees? Like, what is it that causes one group of customers to pay that way and another with checks and ACH and avoid the fee? Like, why?
I think it's both, based on what we're seeing and what we're hearing from our customers, and then also what we're hearing from the industry is mostly convenience. Is what customers state is, the fact that they're utilizing their credit card is a way for them to pay electronically. So it's less hassle, right, than having to walk into a payment center or mail in a check. There's less time involved, for most of us, time is valuable. Sometimes you can't put a price to it. So customers look for mainly convenience.
I understand that. No, but so Mr. Francis, what I'm trying to understand is why, okay, if I am a customer and I have an option between I can set up my checking, do through ACH and avoid fees. And I'm like, well, no, I don't want to do that. For whatever reason, it's easier to do a credit card. And even though I incur a fee, I'm just going to eat that fee. I mean, that wouldn't make any sense. I would think there'd be a justification but there could be that these people are unbanked. They don't have checking accounts in which to utilize ACH services. Is that what's going on?
There is, and let me look at I may be able to point you to one portion of the survey that I provided in my rebuttal testimony that may answer that question as to why customers are opting to.
And the reason I'm asking the question is I could say, well, look, I mean, if I'm not proactive enough to choose, I have both, I have checking account and credit cards, and I can, do one and avoid a fee, or I can do another and get a fee. And if I am simply too lazy and just put it on the credit card, and then that cost becomes socialized, well, that seems very unfair to the rest of the rate-paying public. But if I have no choice and I don't have a checking account or whatever happens, that's a very different circumstance.
Right. So I think let me go to that portion. I think I may be able to answer the question just again based on what our customers are telling us. So I'm looking at page 11. So exhibit MAC 2, page 11 of 29. And I think this may get to what you're asking. And let me know if this doesn't answer your question, but here the question to customers was, why would you be likely to pay by credit, debit, or ATM card for free online at pnm.com? And then they list, there's a list of reasons of why customers are, prefer or would like to pay for free using one of these methods. The top reason here is that oh, I'm sorry. No, the question here is why would you be unlikely, not likely, to pay by credit card? And top reason there is inconvenient.
Wait, so Mr. Cervantes, I just want to make sure that I have what you're looking at, and I'm just going to, this was shared in Dropbox. Maybe I just want to make sure. What I see here is, why would you be open bracket QID 7 choice group selected answers -1 close bracket? I'm sorry if that was super fast, Mr. Lee. In other words, what I see in this doesn't say unlikely. It says something very different than unlikely.
Yeah, and that, for some reason, got cut out. Not sure why, but
are you saying that what was actually provided to the customers was, why would you be unlikely?
Correct.
Why would you be unlikely to pay by credit, debit, or ATM card for free? That's an interesting.
Oh, wait. I'm sorry. No, I'm totally off on that one. Sorry. Let me see.
And you got 40 respondents, whatever the operative term is.
Yeah, no, that's the one moment. I'm actually referencing the. So I took you to the wrong one. That's business customers. And
okay.
It's exhibit MAC 1, page 15 of 35.
MAC 115 of 35.
290 respondents, and you have the correction likely. Correct?
If we're looking at the same page, I'm looking at unlikely. Q11.
Oh, 11. I was looking at 13. Sorry.
I'll just, so we're all looking at the exact same thing. We'll just verify. This is what you're talking about, Mr. Cervantes?
Yes.
Yeah, okay. Why would you be?
Yeah.
No. Oh, 15 or 11 of 35. 11.
Am I in the wrong number again?
No, you're in the
Yes.
right. No, I think you're in the right number. This is the one that I'm looking at too. So these are customers that are unlikely to pay for free via the automated phone system. So these customers are basically telling us that via the IVR, for them it's inconvenient, but via on question, 1 second.
How many respond? Well, I can find it.
Mr.
Is that-
Hearings, excuse me, I am very sorry. I need to leave. I want to just know who is going to be up tomorrow. I apologize, but I need to leave.
Well, it looks like who's up first tomorrow
So
while we're finding the information.
my understanding is we plan to go back to the order.
Mackenzie,
McKenzie, Ms. Garnell, Mr. Felsenthal, Mr. Morris. And then I am not sure who we would pull in from the
that's what we'll be working on for who's on deck on the shuffled lineup card. I'm just trying to move us along. We have a long hearing. So Ms. Nazi, you're excused. Have a good evening. Thank you.
Thank
See
you.
in the
Is
morning.
it possible for PNM to let us know if they can tonight who will be up tomorrow other than Ms. Grinell? And the people that she just, Mr. Felsenthal and whoever else she just named?
It's McKinsey, Grinnell, Felsenthal, Morris for sure. No doubt. Then I think one of the Heffington, Pino, or Sanchez will be on deck, or two.
Great.
Yeah.
Okay, that takes care of an issue that I was going to ask about at the end. So we've at least expedited that. Have a good evening, Mr. Mazza.
Thank you for your indulgence. I'm sorry.
No worries.
Um,
Okay, let's go.
Yeah, Mr. Ryan, I actually, in looking at the responses, I don't think any of these get to the question you were asking. I'm sorry. I had an opportunity to review all of them.
Thank you. That's fine.
Hearing examiners, can I ask a question along the same lines?
Of course.
I guess I'm wondering a few things. Is one of them is if you would have the capability of producing data as to which customers are paying in which way based on their usage. You know, like if you're looking at like block 1, how many, block 2, how many, block those that get to block 3, how many are paying based on, and then so that's one question, and maybe something, if yes, then maybe something that could be included, you know, in the bench request that was directed earlier by the hearing examiner.
Commissioner Aguilar, I would have to look into that a little more to see if that's possible, but we'll definitely do our best.
Okay, and the other questions I have are sort of along the lines of whether you considered any other a different approach, such as making the credit card fees or making it free pay for a certain usage and then not after a certain usage. Did you consider other proposals like that is the question, or is this the only one you considered?
No, we didn't look at that combination of that you just described. It was mostly looking at best practices and what other utilities have implemented in other jurisdictions, and also again responding to what customers requested, right? And really trying to keep it simple for them, because ultimately what they're looking for is you know, to basically pay without incurring that fee. So that was really the focus on you know, this plan.
Okay. I do see on page 14 of your testimony that you mentioned that 31 investor-owned utilities have a fee-free credit and debit card program. I guess my question is, in which states? Because, you know, it's been established that, you know, somewhere in this proceeding that, you know, New Mexico is not a rich state. You know, depending on how we consider the federal poverty level, there was an estimate about like 40% being under that level. And so, you know, in considering the 31 investor-owned electric companies that offer this, I guess I would question what states are they in? Do you have any information about that?
Yeah, that is a very good question, Commissioner Aguilar. I do, and that is actually in my exhibit MAC4, and that's titled Enhancing Customer Payment Approaches by Edison Electric Institute. So Edison Electric conducted a study.
And that's your direct testimony.
That's my direct testimony, yes. On this specific topic. So they conducted a study on this topic, and part of that study included the list of utilities that are offering a similar program to what we're proposing. And it's on page 9 of that study or that report. And you can see there are a list of all the utilities that have implemented a fee-free credit card program, and the state is listed next to the utility name.
Okay, thank you for that information.
Yes.
Great. Okay. I think I'm getting the feeling that we should, Mr. Cervantes, would you be able to start tomorrow morning at 9 again? I'm kind of feeling like we should break. I'm sorry to break you in the middle of your examination, but I feel like it's been an awfully long day. And I appreciate you being here, but I do have one question.
Sure.
As we depart to consider overnight. Do you think there's been, or do you know whether there's been any difference in customer behavior in terms of the way they pay between when the hearing examiner issued the corrected RD on August 15, 2016? She would have been looking at the evidence of a snapshot of, say, 2014 to 2016 in terms of customer behavior and making her recommendation. Has it changed since then?
There has been quite a bit of change in behavior, and a lot of that was driven by the pandemic. And the reason I say that is because customers really started, adopting digital options as a result, and credit and debit card fees fall in that category. And so customers are now expecting more options that are easier to use, free of charge from, the companies that they do business with. And so, to answer your question, there has been quite a shift in behavior. And you can see that again, even in the graph that I showed with PNM, there's been a pretty significant improvement uptake in the number of electronic payments that customers make pre-pandemic.
So in I'm sorry.
Yeah.
Go ahead. No, so in bid request 5, could you give us that back in time snapshot from 2015 that would have been relevant to the period in the 2015 rate case, and show what the behavior was like then compared to now? Since the same issue has arisen, we need to know the difference, and because that may be salient. Is that possible?
Yes, I believe so. We can pull that information. Yes.
And don't forget though, also the granular level of detail that Commissioner Aguilera pointed out with regard to the different blocks, at least for residential customers, right? If you have that data, at least for current behavior, customer behavior would be great. Thank you, sir. All right, with that.
Mr. Welliger is trying to interject.
Yeah, no, of course, I'm not. Go ahead, Mr. Welliger.
I just thought, and I would, if I could do just a limited amount of redirect to the commissioner's questions, and I will promise I won't do any redirect tomorrow on any issues covered now, because I think I could just inform some of the answers to those questions. So
sure.
I'll limit my redirect tomorrow to the questions that come up tomorrow, if I can do
Thank you.
a bit now.
No, that's good. That's
Okay.
good. Go ahead.
Okay. So, Mr. Cervantes, you were asked some questions by the Commissioner Aguilera about whether you considered making credit card payment fees, applicable by usage level. And do you recall that question?
I do.
Did you limit the fee-free payment to certain customer classes? And is your proposal limited to certain customer classes?
It is. It's limited to 1A, 1B, 2A, 2B, so residential and small business technically customers.
So at least it's to usage level. You didn't make a distinction with it of usage levels in those customer classes, but PNM is not proposing that any other customer classes besides residential and small power would get a fee-free payment. Is that right?
That's correct.
Okay. All right. Now the next question I have is, you did provide some data on the low-income customers, correct me if I'm wrong, Mr. Cervantes, who make online payments. Is that right?
I did. Yeah, specifically customers that pay using a credit card, and that is in my direct testimony. Yes.
Can you find that reference by chance?
I can. It's on page One moment. One moment. Yeah, it's page 17.
Mhm.
And it's it states, has the company considered how eliminating the service fees associated with credit, debit cards, and ACH payments as a guest?
I'm sorry, associated with,
Credit/debit cards and ACH payments as a guest will impact low-income customers?
Okay, what's the percentage of low-income customers who pay via credit card? Do you have that?
Yeah, so from the 13-month period that we looked at of June 1, 2021 to June 30, 2022, there were approximately 45% of customers who made a payment using a credit card or debit card were considered low income.
And do you know, oh, I'm sorry, were you done? I did interrupt you.
Yeah, no, I'm done.
I don't know if you know, but do you know whether Dr. Pitts has broken down where low-income customers fall in their block usage in her testimony? Do you know that? You might not.
Yeah, I'm
Okay.
not too sure. Yes.
Would it hurt to distill it as part of this analysis though, Mr. Williger?
Yeah, I didn't want to testify, but in case we can't run based on our billing system, what Commissioner Aguilera asked for, particularly by blocks, I think we could maybe do that 45% plus Dr. Pitts's analysis to sort of try to come up with a percentage on a percentage, if that makes sense.
Okay, but
Yeah.
let's not let go of the blocks issue though.
If we can do it, yeah.
Well, we want to see, who's in, what block 3 is doing, folks in block 3, for instance, right? Okay, for the redirect.
That's all. Thank you.
Okay. So we have the lineup for tomorrow, starting with Mr. Cervantes, and then after that, McKinsey, Grano, Felsenthal, and Morris, and perhaps people on deck filling in so we can have a full Friday to keep the train moving.
Yeah.
Is there
and
anything else?
just for clarification, our on deck would be Pino and Sanchez, Angela Pino and Leonard Sanchez, not Mr. Heffington. And
No. Okay.
I can send that note to Miss Nanasi just so she's.
That'd be nice. Thank you. You don't have to do that, but that's professional courtesy. That's appreciated.
Yeah.
Is there anything else before we recess for the evening? Sorry, Mr. Borman.
This is why I raised the issue 45 minutes ago or so.
Don't complain. Come on, we got further along here. You pick it up later, okay?
I got a wife who's unhappy right now.
I'm sorry.
I'll give her your regards.
Yeah, no, just go ahead and blame it on me. I can take it. Trust me. Okay. So with that, we're in recess until tomorrow morning at 9 a.m. Have a good evening.